Good morning. This is the Colorado Oil and Gas Conservation Commission. It is February 22nd around 9 a.m. We are agendized for a hearing today. We will start by recognizing our existence with the roll call.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez,
Here.
Commissioner Hackett, Commissioner McGowan,
Here.
Commissioner Misner,
Here.
Commissioner Nanjapa,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great. Good morning, folks. Good to see everybody. I know we've all had a long weekend getting prepared for the next day or two's deliberations. We do have an agenda before us. The first matter of business is a consent agenda. We have a PDC spacing, excuse me, a Verdad pooling, a Pierre McGee spacing, and a Nickel Road exception location consent agenda request. Do any commissioners have any questions with regard to consent agenda? Commissioner McGowan.
I apologize, Mr. Chair. I thought this was on our agenda for Wednesday as if it were a regular commission hearing. And I did look at these and I need to apologize. I was looking at the exception location and I have to admit, I'm not sure I quite understand what that is. It's not necessarily that I'm opposed, but I haven't had time to ask staff about it.
And actually, Commissioner McGowan, I and Hearings Manager Larson are wrong. That is set for Wednesday, not this morning. I misread the agenda and I think Ms. Larson missed it too. So you get a whole nother day to look at the exception location, and then we will take up that consent agenda tomorrow morning. This is what happens when we go out of order and have meetings on Tuesdays. So with that, we will not take up consent agenda this morning. We will do it tomorrow. We will all have an ability to look at that this evening after we're done with deliberations. We now will take up the primary order of business, which is docket number 2106-00097, the financial assurance rulemaking. To remind everybody where we are with regard to this, we have been undertaking the financial assurance rulemaking for approximately a year. We have had a number of different iterations of rules and iterations of stakeholder input into the work that we are doing. Today is the calendared first day for deliberations amongst commissioners. We received the final party presentation sort of closing statements last week. We have spent the weekend reviewing our notes and going over the various written submittals, and today we will engage to sort of bear down and get through a list of issues. I did spend a little bit of time with Director Murphy trying to come up with a proposed order of play or script so that we could figure out the best method of getting through the various issues that are before us with regard to the financial assurance rulemaking. I'd like to sort of introduce that with the assistance of Director Murphy. Commissioners, today is our day, and so we will work together to work through these issues. After Director Murphy and I sort of introduce what we think might be a appropriate way to sort of move through this, I definitely want to open it up for your input, because we all 5 need to work together with Director Murphy as being a intangible 6th with us as we sort of work through the issues. I would note that I think we all can agree that the financial assurance rulemaking rules, the regulations, the most recent red lines that we looked at, they are very much integrated and interrelated. So if you tug on one thing over here, it has impacts over here. And we need to work through the issues, and then I think we need to step back and take kind of a holistic look at the place that we may have landed in terms of the financial assurance rulemaking. In my mind, that plays out that we work through issues sequentially today. If we're able to get through all issues, then the step back might be this evening and in the morning, and then sort of come back and sort of look and see where we are. I also would suggest that from my perspective, depending upon how robust we are with regard to suggestions and revisions, if we get to a point today or tomorrow where we have given direction to staff to sort of finalize sort of approaches with language, that we could do that and then give staff the remainder of the week. This is playing off of some of the ideas that I suggested last week of diving in, giving staff that final direction, giving them time to make some final edits, also work on the SBP, the statement of basis and purpose, and then come back the early part of next week. The downside to that is the effective date moves from April 15th to April 30th. I weigh that as being kind of it's okay, because we've been working on this well, and it's important to get to an appropriate spot. So those are my sort of initial introductions into the worthy work that we have before us. With that, I would love to call upon Director Murphy to perhaps share a screen and populate out an order of play that the commissioners can take into account and sort of see where we are. Director Murphy.
Thank you, Chair. So what I have before you is just the topics that, as I listened to stakeholder commentary and your questions on Thursday and Friday, broad topics. Nested within each are subpoints for discussion that I hope that you will raise and help kind of turn it into the discussion document that we've used through mission change. To me, I think one of the most important places to start today is the definition of inactive and low producing, because those two decisions cascade through the financial assurance plan options. They interrelate with the definition of single well financial assurance and the discussion around transfer of wells. I think once those four topics really hang together closely, and by tackling the definition of inactive and low producing first, it'll help set the stage to make decisions in the subsequent three categories. After that, I think it turns a little bit more into kind of single topic items. I don't think this is an exhaustive list either, but it's where I started based on my notes from Thursday and Friday and your questions. Again, this is the first four, I think, need to be decided fairly close in time together. And again, starting with inactive and low producing. Outside of that, I'm pretty agnostic about how we take up decision making, and would look forward to your comments about, number one, broad topics that I've missed, and number two, really what are the issues within each of these topics that warrant discussion based on your work over the last year, and especially since the revised draft came out and we've received thoughtful and voluminous commentary from our parties.
Thank you, Director Murphy. From my list, I think under the other topics, if we could also just sort of make sure that we ring the bell on the consideration of federal wells and the concept of amnesty, or whatever we want to call it. I think that you've got surface owner protection. And then there is a minor topic around insurance, I think. And then I'm now looking to other commissioners in terms of order of play, sequential approach, other topics, etc. Commissioner Gonzalez.
Yeah, I'll just kind of go through my list, Chair, and add a couple topics there. One is volume measurement equivalencies. And kind of as they apply throughout the rules, maybe they're best dealt with on a rule by rule basis, but I think there's some uniform application I think we could talk through. Let's see. I think we need to add to the list and maybe this is part of the out of service and plugin list requirements, but the AVO versus AIM thorough discussion we've had throughout this process. And I think those are my big ones to add to the list.
Thank you, Commissioner Gonzalez. And there are, lots of other subtopics that are, lie within some of the things like the, the options piece is, that's a fairly large topic. But we are all aware of the various subsets that are within that. Other commissioners that would like to alter the list, add the list, provide input. Commissioner McGowan.
Sorry, I'm looking at the list to make sure it's not on there and I'm missing it. Never mind. I see it. We're good. I'm going to have little things, I think, sprinkled in and about, and a couple of things in the definitions series that I think we might be able to clarify in the statement of basis and purpose.
Chair, if I may, it's fine to capture those at this point in time. Like I can break this into multiple slides to make sure we don't lose track of ideas also. It's up to you all.
I have a list of those little things, and if we miss them as we go through, Director Murphy, I'll circle back around and see if folks are open to some of my ideas.
Commissioner Messner.
Thank you, Mr. Chair. I mean, for me, this captures kind of the big picture stuff. I mean, I agree with Commissioner McGowan. There's specificity with all of these and things that will get rolled into all of these. And I don't know if it really makes sense to continue to break this down any further, but just gives us a starting place for discussion. And then these other pieces, because everything is interconnected, they're just going to start to be a part of the discussion as we work through this. So I'm good with it as we have it, as far as like the big topics, right?
Okay, good. Director Murphy, if this becomes our list, I'm now sort of asking process wise, and let's say we tackle inactive low producing to start. Are you thinking that you might create like a new slide for each of the topics and then capture the discussion or the landing spot for that? And I'm totally putting you on the spot because we didn't talk about this.
Right, but I think you're recalling how we've done it for the last, 4 months of 2020. So yes, that was my intent. I think after confirming from Commissioner Najapa and the commissioners that this is a list, me taking 2 minutes to put together individual slides on these topics will be less awkward than everybody watching me do it in real time.
Okay, Commissioner Najapa, did you have anything to add?
No, I think this does capture all the big items. The only little thing, which I'm sure will come up anyways, is thinking about single location financial assurance or sort of the offsite facilities issues.
Okay. All right, then I'm going to call an audible. Let's take 5 minutes and give you sufficient time to generate out the PowerPoint. That also gives me at least time to make another cup of coffee and be ready for our deliberations. Let's come back at 9:22. All right, Director Murphy, thank you so much for the great work that you're doing here. So I think we have determined that we will start with working through the definition of inactive low producing, as it does, these definitions do have repercussions throughout the rules. Commissioner Gonzalez noted that we should also be thinking through on the volume measurement equivalencies, and that's on the slide as well. With that, got my slide deck open so that I can see everybody. Does anybody want to lead off? Commissioner Messner.
Thank you, Mr. Chair. And again, understanding that these things all tie together holistically as we look at, how financial assurances are going to be addressed throughout the rules. And listening to testimony and contemplating over the weekend, I still am of the opinion that the 2 BOE and 10 MCFE is the appropriate definition for low producing wells, and reverting the inactive well definition back to previous draft with a 0 production threshold. And that my statement on that does tie into how things are treated in the different options and transfers. And so I'll just make that known that, that opinion will change should we make significant modifications to some of the drafts around options and so on and so forth. So, but as currently contemplated and as I'm looking at things, I'm okay with that those 2 definitions.
Commissioner Najapa.
Thank you, Mr. Chair. I feel the same after kind of reviewing everything. And, I had talked about a threshold for inactive, but given what I think is also being contemplated for, broader areas of the rules, I'm also comfortable with these definitions as Commissioner Messner just articulated.
Commissioner Gonzalez.
Thank you, Chair. And I tend to agree with most of that. I think the inactive wells should be defined as inactive. One piece I want to mention is there was a suggestion that maybe there be some production thresholds in order to prevent wells that are effectively inactive from being miscategorized, misclassified. And I wanted to explicitly say that I don't think that's necessary given the broad discretion by the director to be able to bring any one of those wells that he or she in this case feels should be inactive up to us for hearing for that determination. So that's an important aspect of it. I do think that inactive wells should be 0. As we've discussed, low producing wells, we've had a lot of consistency and a lot of consensus on the definitions being surrounded for low producing wells being tied to 2 barrels and 10 MCF in that regard. And of course, with the equivalencies there. And I thought that that's been appropriate, for the entire time as we've worked through these discussions. I think the part that really gives me a little bit of hesitation at this point is the excess bonding under the proposed tier structure being applied to low producing wells at this threshold, and really just the amount of growth that bucket's going to pull in. Now, I'm not saying that's the wrong thing to do or the right thing to do, but it's a consideration that I'm thinking about as we work through the options and work through the tiers in that regard. But just for define it as we have it now, I'm comfortable with moving forward with the definition of 2 barrels and 10 MCF.
And Commissioner Gonzalez, can I ask you about that? The director discretion, and this may be for Director Murphy or it's for all of us, but we had a lot of discussion that there would be this ability of the director to sort of capture gamesmanship if we have inactive as 0 production. Is that what you were getting at, Commissioner Gonzalez?
Yes, Chair. I'm trying to move away from the word gamesmanship because I think it implies malintent. But for miscategorization, right? If there's an inactive well that's effectively inactive, should be treated as such. The director should have the option to bring that up, bring it up to us for hearing for that designation. If an operator has a well that's been deemed as inactive and they think that it shouldn't be inactive for specific circumstances, I think that we built that into the rules in the last proposed draft, that they have the option to protest or to petition a hearing based on that for a change in that designation. So I think it works both ways, and I think it will account for the possibility that wells that are effectively inactive aren't classified as not such. That makes sense?
Yep. Commissioner McGowan?
Thank you, Mr. Chair. And I agree with everything that's been said. I just want to clarify something that Commissioner Gonzalez said. I think you said 2 barrels and 10 MCFE. So I assume we're all agreeing that we want to move to energy equivalency. I just want to clarify that. That's what we're saying. Instead of BBLE and MCF for the definition of low producing.
Commissioner Gonzalez, can I just call you out on that one?
Yeah, no, that's that. Thank you, Chair, and thank you for the question, Commissioner McGowan. Yes, that's my intention. I tried to kind of throw that in at the end of my statement to capture that. I say barrels and MCF just kind of colloquially, but I understand that we are in a rulemaking where the words matter and we're trying to be deliberate with our language. I will correct myself in that regard. I do mean BOE and MCFE, and really, I think that should be applied across the rules, not just in the inactive and low producing well definitions. And I kind of went through and identified all those and verified that I do believe that that's the appropriate application. I think the only place where we would not use a BOE or an MCFE and would use a barrel or an MCF is in talking about the GOR ratio for capturing kind of that equivalency in the byproduct, not the primary product of the well. Does that answer your question, Commissioner McGowan?
Yes, thank you for clarifying that. And so another question, when we're talking about the director having all of this discretion, are we thinking we're going to reflect that more clearly in the rules, or are you thinking that might be in the statement basis and purpose? I know folks have been worried about, a well that gets turned on once a year or twice a year, et cetera. And I know that we've talked about it, but I just want to understand how we're going to be clear about it and our intent with words on paper.
And Director Murphy, feel free to weigh in on any of these topics at any point in time.
Thanks, Chair. I've tried to capture where I think it fits, which was in the statement of basis and purpose, because I think that in this concept, and I've tried to flag where we may need to come back and talk about other things, but I know that if we go back to the discussion on the 31st and the 1st, there was a strong direction from the commission to make sure the statement of basis and purpose talks about addressing this intermittent operations or intermittent production piece. And so to me, connecting that conversation to this morning's conversation in the statement of basis and purpose made the most sense to me. It's hard to, I don't think we have really clear criteria to say a particular well should or shouldn't be designated inactive within the director's discretion. And if we had that, we'd probably have a clearer definition of inactive itself. And so that's why I had suggested in my typing on the screen to include it in the statement of basis and purpose. The one other clarification that I wanted to make is I added, if you'll recall staff's presentation on the 14th, I noted that staff neglected to include shut-in language in the definition of inactive. And so I wanted to confirm that you all are comfortable with actually making sure that comes into this draft. It's language that has been included for a long time in our definition of inactive, and it's been in every version of staff's draft. We accidentally deleted it when we were making edits. But I did go ahead and call that out in the second bullet point saying including shut-in language.
Commissioner Messner.
Thank you, Mr. Chair. And two other points, and I think you have it captured there, Director Murphy, but if we're going to do the 2 BOE and the 10 MCFE as the low producing definition, I think that the GOR also has to be reflected in that definition as well, so that it's clear. And I think a previous draft perhaps had that, but to me, that's important. And I think to Commissioner McGowan's point, I mean, I have been concerned about the mischaracterization of inactive wells, which is why I had been floating ideas of a production value for inactives. With consideration of low producing wells in the option structure and understanding that should this commission decide to utilize low producing wells as a requirement in the option structure for single well financial assurance for tiers 1 or options 1 and 2, I think that one of the criteria for an inactive well is that it has to have single well financial assurance if it's going to stay inactive. And so that potential requirement for single well financial assurance for low producing wells in the option structure gives me comfort that at least that piece of the criteria of inactive wells has the potential to be captured, in addition to the director having the ability to call that out as well. So.
Commissioner Gonzalez.
Thanks, Chair. Yeah, I want to respond to Director Murphy's, I guess, some of her questions or comments. But specifically, when we think about, and this may have been Commissioner McGowan too, I can't recall, but in the broadness of the director designation and kind of what that entails, and if it should be in the SPP or in rule language, I think that the 434C, 2, B, and C are drafted appropriately. So I thought that captures pretty broadly what the director can do in that regard, and then capturing our intent and the specific circumstances that we are trying to avoid in the SPP is also appropriate in that regard. There was something else that I had that I can't recall, so I'm going to hold off on that right now.
Okay. And I agree with my fellow commissioners in terms of where we're at on these two definitions, knowing that it's going to ultimately, we need to look at everything holistically. But I think we're all sort of throwing that flag down. Okay. Anything further on this slide in terms of initial deliberations? Okay, Director Murphy, do we want to proceed?
Indeed. Sorry, I have one question for Commissioner Gonzalez. I assume that the collective intent to use BOE and MCFE in both of these definitions and staff's proposed language about calculating from the primary product, the GOR, to understand which applies and then how to account for the equivalencies. That language is all okay as it relates to these two definitions.
Yeah, I believe so, that the GOR definition is, and I think the language is fine. I think there was some question as to the location of where that language should go, that GOR language. And so I'll leave that up to AG Stafford to think about that, as well as you, Director Murphy. But yeah, I think that the GOR language, that sentence, I think it works the way it's drafted.
Okay. With that, I think my questions are answered, and I would take us next to financial assurance plan options. And to me, there's a couple of different iterations of this question. I think starting first with, I would suggest we start first with the actual criteria for the different options and then the amounts of bonding associated with those. And then if we want to talk about what financial assurance plans, specifically the information requirements or a review process, kind of bucket it in that way. Obviously, the question about the equivalencies carries through options 1 through 4. And so I don't know if it makes sense to talk about 1, 2, 3, and 4 individually, and then make decisions about equivalencies or the reverse, and then have hold a conversation for option 5 and option 6, which are to me, so much different from the first four that probably warrant individual discussions.
Commissioner Gonzalez.
I'd like to make a suggestion here that maybe we talk about the distributions of the various products, whether primary products, whether it's a gas well or an oil well, and the appropriate bucketing within that distribution structure before we go into the options, because that kind of frames really the thematic approach to how we're capturing which operators, which portfolios will be in which options.
Do you just want to roll with that, Commissioner Gonzalez?
Happy to. Happy to. Commissioner McGowan's got a question, so I'll let her jump in before I start talking.
Commissioner McGowan.
Thank you. Thank you, Commissioner. Thank you, Mr. Chair, and thank you, Commissioner Gonzalez. I'm wondering, I'm wondering what your thoughts are. So for me, the discussion about production levels for each of these options might be tied to whether or not the commission is going to consider the percentage of an active in excess, or whether that will turn into low producing. I guess my point being that if I think one of the stakeholders suggested that percentage, instead of it being in excess of inactive, could instead be low producing. And I think if it becomes low producing, and depending on and the definition of low producing, that might influence my thoughts about whether or not the production levels in the tiers are appropriately set, because we'll be folding in a lot of low producing wells that will lead to, I think, additional single well financial assurance and or putting them on the plugging list.
Commissioner Gonzalez.
Yeah, I think that's an appropriate consideration. I think I can kind of explain my rationale on the equivalencies first, and we can kind of talk through that, because I do think that there's going to be just kind of a pulling of levers as we adjust to get to that right spot. But just generally, from like a thematic perspective, when I think about these volume equivalencies, is that, and I appreciated what Mr. Sir brought up in his presentation. It gave me a lot to think about over the weekend. But the way I think about it is that I don't think about those two distributions and all four of those buckets to be tied to each other. I think about them independently. There's an independent oil producer distribution, there's an independent gas producing distribution. And then we use the numbers on each of those independent distributions in the same buckets, right? And so I don't think that it's necessarily a good idea to look at it at a straight ratio, or to think of our GOR ratio of 5.8 to 1 as an appropriate way to bucket those. Mainly because if you look at that, you're accounting for the potential that an oil well, which is a very different production profile, maybe not the right word because the profiles are very similar, but very different production amounts coming out of those than a gas well. For instance, if you applied a 6-to-1 ratio on a 1,000 barrel oil well in the DJ, right, which is not unheard of, it's a high producer, right? And you say, well, then that's going to be the equivalent of a 6,000 MCF gas producer. Well, we don't really have 6,000 MCF gas producers, right? We have maybe 1,000 MCF gas producers. And so to think about it in terms of those equivalencies, I think is an inappropriate application of those numbers. So that's kind of my first pitch, is that that distribution is viewed independently. At looking at the way that distribution was reworked by Mr. Sura in his presentation, really it took the distribution and applied it to wells across the state. So as if the state had its own well portfolio, where would those wells fall in the distribution? Whereas the proposal from Western Slope COGA and the proposal that we've talked a lot about in our deliberations really puts that distribution across operators. And you have most of the wells in the state really consolidated with a smaller number of operators. So it's natural that if you have a distribution that's based on operators and distributing those operators across the different buckets, that if you apply that to wells, that distribution is going to necessarily be skewed towards the front end of that curve. And so it's just a different way of thinking about it. I think we have to recognize and honor that the gas production and oil production is very different, and that the equivalencies that we talk about when we use that GOR ratio is really to capture byproducts. Really, that's just an easy way of capturing that secondary product. Whether it's a gas well, you're capturing the liquids. If it's a liquid oil well, you're capturing the gas that comes up with that. And that's just a way of equalizing it. I just don't think you can equalize it across all wells as a categorical application. So that's kind of just thematically how I think about the distribution of the buckets, of the tiers, the options, and the application of MCF, E, or BOE to those buckets.
Commissioner Messner.
Thank you, Mr. Chair. Appreciate the comments, Commissioner Gonzalez. I think about it similarly. As I look at it, I think that and I think I testified to this as well, but that philosophically, I think that the way that the option system works is looking at the expected life of operations and expected life of wells, and essentially creating a retirement plan that as you get closer to the end of life of operations than the beginning of life of operations, then there needs to be additional financial assurance considered the closer it gets towards the end of life of operations. And so, and I think that there, as you look at that, I agree that you look at oil operators versus gas operators and the different metrics associated with those to determine how we're going to approach the different tiers. I think philosophically for me, operators that are in option one are operators that are both plugging in, abandoning, and retiring assets, as well as drilling new wells. And by looking at both of those metrics, they're actively drilling while they're actively retiring, and they are creating a certain production threshold. They're able to develop income from the new activities that they're engaged in, which creates funding mechanisms to help meet their retirement obligations within their portfolios. And that metric, whatever that metric we decide that metric is, that's that metric, that balance that allows them to be in option one. As they start to minimize new operations and start to rely more and more on existing operations, then necessarily operators start to move into option two. And as they start to eliminate new operations and really start to rely on existing operations, then they naturally shift towards options 3 and option 4, understanding that through all these different options, we're increasing the dollar amounts associated with financial assurance as they move down the production thresholds. And so philosophically, that's how I'm looking at it. And I think the question to me is, and I also look at it from an operator standpoint and not necessarily a per well standpoint, because we're looking at an operator's portfolio and how that interacts with their existing operations versus their new operations. And so the only question that I've got as I'm looking at stuff and is, as we look at oil, as we look at natural gas, do we have that right? Do we have that right production metric so that we are capturing the ones in option 1 that have active new operations as well as retirement of existing operations, and then as they start to not have new operations and are starting to rely on their existing operations, does that start to work into option 2, 3, and then 4? And so I'm not suggesting that the metrics that are in the current draft are necessarily wrong, but just as we're talking philosophically, that's how I'm looking at it at this point. So.
Commissioner Najapa.
Thank you, Mr. Chair, and thanks to both Commissioners Gonzalez and Messner for kind of leading off on this. I really appreciate the way that you kind of just described your philosophical approach, Commissioner Messner. I think that's, generally what I've been thinking, but definitely much better articulated in the way that you just described it. I think for me, and this kind of came up in our questions at the end of last week too, that I'm not sure that we need a bell curve distribution of wells, given these considerations and given the ways in which we're kind of trying to contemplate how we just determine financial assurance, and given the same issues that Commissioner Messner articulated of the as you proceed down the different options, there's additional requirements, as you go through those different options. And so I think that thinking about having more wells in options 1 and 2 doesn't bother me. I think that, we get, greater coverage of whether we decide on an active or low producing wells in these options 1 and 2. And then the single well financial assurance, as you go into 3 and 4. I won't jump into my comments on 5 and 6, I don't think quite yet, but I do have opinions on those. But I think, I think given all of that, I definitely appreciate, the conversations I've had with a few different stakeholders, including Mr. Sura, about changing the MCFEs in particular for these different thresholds. But I think I'm comfortable with where they are in the current proposal.
Commissioner Gonzalez?
Yeah, thank you, Chair, and thank you, Commissioners Messner and Commissioner Nanjapa. I think I want to get some of this fleshed out and really understand what you guys are thinking here, because it seems to me, the way I've thought about this, and I think the way that we've talked about this in the past is trying to find a proxy for financial health, and that we've done that through production portfolio. And so that's just kind of thematically where I thought we've gone. So I'm curious, Commissioner Messner, what do you have a proposal about what these options would look like if we're not looking at specifically production as a proxy for financial health or for risk, and we're looking more at an operator's activities or an operator's, new drill programs alongside their plugging programs? And then the thought that options 3 and 4 are really for operators who are not drilling and who are more moving towards legacy production. I think that's kind of a new idea. I don't know that I've given it any thought, so I'm curious what you're thinking there.
So I maybe you misunderstood a little bit. I mean, that's philosophically where I'm at, but the philosophical piece is still basing it on production, right? And so, like, what are the production levels necessary in order to capture those that are actively drilling and actively retiring? And so, I'm not suggesting different options or not utilizing production metrics. I think my point is philosophically is that philosophical approach should inform how we determine production levels. And so I still think production levels is the metric necessary to be able to utilize this option structure. But as I'm looking at applying it, I just want to make sure that those production levels do capture the right characteristic of operators in each of the option, and then utilize those production levels. So, to be honest with you, as I look at it, right now for option 1, we're at 90 MCF, 60 BOE. That in many ways, I think, as I look at the operators that potentially captures the vast majority of operators that are both actively drilling and actively retiring assets. I think you can also look at up to 120 MCF and 60 BOE, MCFE and 60 BOE. It shifts a few operators from option 1 into option 2. I don't think this is utilizing the production metric and utilizing my philosophy is a perfect science, right? So, I mean, I'm not saying that it's going to be exactly right. So, depending on where this commission lands, I mean, I can be comfortable with it, the production metrics as proposed. But I have looked at it utilizing slightly different production metrics, and it potentially captures philosophically a little better what I'm expressing. But it's, as you apply it to operators, it's really only shifting it a few operators in either direction. And so, I'm not hung up on making a big change on where we're at right now, because I still think that the other backstop to this that is really important is this consideration for single well financial assurance for low producing wells in the option structure as well. And that really, rounds out the security of utilizing this option structure. And so to me, that becomes more important than, making a few MCF adjustment on the production metrics to maybe better capture my philosophical approach, if that makes sense.
Thank you for the clarification there.
Commissioner Messner, do you want to speak to that last point? Do you have ideas along those lines?
Regarding the single well financial assurance for low producing wells?
Yeah, and like how to capture that?
Sure. I mean, for me, it's what Western Slope COGA proposed, and I think a few of the conservation groups supported, which was requiring single well financial assurance for low producing wells, but allowing for a 10% threshold in option 1 and a 5% threshold in option 2. And for me, in option 3 and 4, presuming allowing those single well financial assurance to be captured in the financial assurance plans associated for options 3 and 4, because they are already contemplating single well financial assurance for all of their wells, subject to commission approval of their financial assurance plan. So that's how I'm looking at it.
Commissioner McGowan, you had raised your hand and you were nodding, so I would recognize you.
Thank you, Mr. Chair. I'm aligned with Commissioner Messner on these thoughts. And it's taken me a long time to kind of figure out the philosophical difference between, I think, what the conservation community, or in particular Mr. Sura, was requesting as far as MCF and this equivalency. And when we're talking about oil and gas, they're both the same, they're both similar products, but they're not apples to apples. And so I think that I'm comfortable with where the levels are set in conjunction with this conversation about percentage of in excess low producing wells that get single well financial assurance, which I think will drive behavior, which is to either bond up or to plug and abandon low producing wells or wells that are no longer productive for folks. They're going to make a choice as to whether or not it's still worth the effort and to bond it up, in which case we've reduced risk significantly, or to P&A it, and then we've also reduced risk significantly. So I think it's a pretty good model. And to Commissioner Messner's point, if production slowly decreases over time, you shift into these other options where your bond becomes more robust and you are more fully assuring those wells.
Yeah, I appreciate that. And Commissioner Messner, I tend to agree with your thoughts along those lines. Director Murphy?
I think, okay. What I have heard from the dialogue that has taken place thus far is that option 1 and 2, we should use the definition of low producing instead of inactive. And a lot of conversation about some interest in perhaps exploring different thresholds for gas, but right now it feels like there's not an interest in shifting those. Perhaps nobody's put numbers on the table. So I assume that means a 211 draft stays intact. And I know Commissioner Nanjapa, you commented early on, but I don't think I've heard from you on some of these other pieces, and want to make sure to hear from you also. And with that, like, are we good with this? And can we move on to other topics around option 1, 2, or 3, 4, and 5, and 6?
Yeah, thank you. Thank you, Director Murphy. Yeah, no, I did say that I am comfortable with the thresholds as they have been currently proposed in the 211 draft, and that I like the proposal of, I guess I was being a little wishy-washy of saying wherever we land on inactive versus low producing, but I do think that by changing that to low producing, for me, kind of the broader premise in general with this approach to these rules is to think about the overall risk. And so we have our perhaps least riskiest operators who have higher production values, having the opportunity to have blanket bonds, but they still have to cover a large percentage of their low producing wells, which are in my view, the highest risk of their portfolio. And so I think that makes a lot of sense. And so, yeah, I think in terms of what we've discussed so far, I'm comfortable with where we're at.
Commissioner Gonzalez?
Thank you, Chair, and thanks for all the comments. When this was initially proposed, I like it. I think that the low producing wells as the threshold is protective. I think we're looking at making, paradigm shift protections through these rules. And I think that's important. I've had a number of conversations with some concern over the low producing wells that kind of, popped up in our, last Thursday kind of last minute idea that I don't think are prohibitive to my thoughts here or to kind of my support of moving with the low producing wells, but I think it's important that we acknowledge those. And really, when we think about the excess bonding that we're talking about, whether it be for low producing or inactive, when it was inactive, that was a certain quantified bucket that operators have been thinking about and kind of have been a part of the entire contemplation of this rule change up to present. And moving to low producing necessarily expands that bucket by a lot. I don't know what the numbers are, but I want to acknowledge that. So we are adding a substantial amount of additional protection by going to the low producing wells. I also want to acknowledge there's some operators out there that keep an entire portfolio of low producing wells and very little inactive wells. And by shifting to this direction, it almost eliminates their opportunity to move into an option 1 under a strict, I guess it makes it maybe more cost prohibitive to move into an option 1 structure in that regard. And I think that's a concern that has weighed on me as I've been thinking about this. But at the same time, I anticipate that we're going to be moving forward with some version of an option 5 that will allow operators with these specific unique circumstances to bring forward their concerns and perhaps seek a more amended and more precise approach to financial assurance. So I just kind of want to throw those thoughts out there. I'm comfortable moving forward with the low producing wells as a trigger for the excess bonding under options 1 and 2 as proposed. But I do want to acknowledge the concerns, and really, this is going to happen throughout a lot of these rules, is that there's going to be people who are left in the margins, and whether you're left in the margins, you're either going to get a really good benefit or a really bad detriment to you, depending on which side of that margin you fall on. And that's just part of making statewide rules, and it's going to happen on not just this rule but others. And I kind of want to acknowledge that existence and that reality as we move on. So that's kind of my piece on that, Chair. Thanks for the time.
Commissioner McGowan.
Thank you, Mr. Chair, and I appreciate those thoughts, Commissioner Gonzalez, and I've been thinking similar kinds of thoughts that I think we're going to have to allow a conversation with operators who, I mean, I think Evergreen's another good example of a unique circumstance where they have a different product and they are concerned about how they see themselves fitting into these tiers. And so I think we're going to end up having some conversations with some operators who don't see themselves fitting perfectly into these options. That being said, I also am supportive of the percentage of low producing as the bar, because I think I heard a lot of comments and testimony last week about concerns over using transfers as the pinch point for looking at single wall financial assurance. And so for me, if it's folded into these tiers and it's folded into financial assurance over here, that opens up the discussion for me about single wall financial assurance upon transfer, which I think people found problematic. Many people found problematic on both sides.
Commissioner Nanjapa.
Yeah, thank you, Mr. Chair, and thank you, Commissioners McGowan and Gonzalez about these, other considerations. I was trying not to get too far ahead of the discussion, but I still think there is a way that we can create what I keep calling an on-ramp into option one, just option one, that is apart from production thresholds, using financial health criteria, compliance, and plugging history. And I can talk a little bit more in depth if we want to go there. But I think that we probably will have few operators that will be able to use that on-ramp. And that's okay. And, I think it allows them to get in there. But I did have the same thought as Commissioner Gonzalez raised, that, some of our very healthy operators have entire portfolios that fall into the low producing threshold. And so I would propose that we create an on-ramp that allows for the same sort of idea around the blanket bonding, except that they would single well financially assure their inactive wells. So that would be just something I would throw out. I don't want to overcomplicate these rules. I think we're getting to a good place where we're getting less complicated. But I do think one on-ramp is something to consider. And so I want to throw that out for discussion. The other piece that I still feel pretty strongly about is option 5. I really don't want this to be a free-for-all. I think that all of our operators can fit into one of these tiers already. And if they have the option to ramp into option 1 to get a better deal because they can demonstrate and prove up that they have the financial wherewithal to be in that option, I think that's a fair way to go. And I think option 5 should really be that when we look at these options and what your requirements are of us, we can't meet them, and therefore we need option 5. And so I'm hesitant to use the undue hardship language, but I do think it should be due to circumstances that prevent an operator from using the options or the financial assurance plans in the ways that we are contemplating. And so option 5 should be more, for an exception or a very specific set of circumstances that would prevent them from fitting into the option that they should naturally fall into. So that's my view on that. I want to keep that very limited. I think that if it's open to everybody, then we're going to potentially get a whole bunch of different plans, and maybe not right at first, but potentially down the line, we have to think, 30, 40 years into the future. And I don't think I like having an option 5 open to just anything.
Commissioner Gonzalez.
Thanks, Chair. And thank you, Commissioner Nanjapa, for kind of bringing option 5 into this. I think it's appropriate that we talk about option 5 kind of as on the front end, because it's kind of like the backstop against all these other options that we're talking about. So I think it's wholly appropriate to kind of think about these in conjunction. With regard to option 1 and the financial health component, are you considering that as an or on-ramp? Because I know that was a little bit of discussion and I wasn't quite sure where you were landing on that. I would support an or on-ramp there, where basically you've got the production thresholds and it categorically puts you in option 1. But if you can demonstrate that production should not be a proxy for your financial health in other means, or that you would otherwise qualify as what we would call a top option operator, I would support additional language that would have that alternative approach there. Do I have that understanding correct, Commissioner Nanjapa?
Yeah, thank you, Mr. Chair, if I may. I think I have been thinking about this quite a bit. I'm a little on the fence about the or versus and the only reason, well, let me say this, that I think it would be an or because we're talking about production or, you know, the ability to qualify in if you don't have that production level. So generally speaking, yes. On the other hand, I did think some good points were raised with respect to financial capabilities in thinking about the fact that if production thresholds are a proxy for financial health, then why is there a concern about also looking at actual financials along with that? So I am curious. I think it will. I've heard in conversations with stakeholders over the weekend that it would kick out, you know, certain operators from option 1. And this is one of these points where I don't know. I'm going a little bit back and forth. I think that if it truly is a proxy for financial health, then your financials should demonstrate that also. So I'm not sure why an and is a problem. I guess I'll just say that and leave that, you know, out there for discussion. But generally speaking, I'm talking about this as an or to allow operators who do not meet the production threshold to be able to ramp in.
Thank you.
Gonzalez.
Thank you for the clarification, Commissioner Nanjapa. I think that's really helpful because I was kind of, you know, thinking about the same thing, right? You know, and I think about an on-ramp is supposed to create a little more accessibility, which is why I think the or makes sense there, whereas the and, you know, the conjunctive really, it makes it more limiting and so more exclusionary. And so that's really, you know, something that we'll have to dial in the discussion there. I support an or, as I just mentioned. With regard to option 5, I think I diverge from you a little bit there, where I don't necessarily believe that there should be a hurdle to make option 5 accessible to certain operators. But one thing I absolutely want to make clear, and I think it's important that maybe this is something that we say out loud and that maybe makes its way into the SBP. In fact, I think it should make its way into the SBP, is that I don't think option 5 should be a mechanism for an operator to just come before us to look for a better deal, right? To just say, hey, maybe under option 1, you know, I'm paying $10 million in financial assurance, but I just want to get 9. So I'm going to go through option 5 and try and make all these cases why it should be a little bit less. That's completely inappropriate in terms of the way I think the application of option 5 should be. And the way I think about it is really a demonstration of unique circumstances. And so perhaps the SBP could have, you know, an including but not limited to type list of here's things that we would consider, whether it's financial health, whether it's, you know, plugging history, compliance history, you know, whether it's an operator whose sole business model is to operate, produce, rehab, and maintain low producing wells, right? You know, these are all things that I think are important. So I really focus more on the unique circumstances as a way to tailor a financial plan for someone who does not necessarily fit fairly into one of the other options. But I'm not in favor of making a hurdle, really more of a showing at hearing that demonstrates why you should be not under options 1 through 4, as opposed to why you can't be under options 1 through 4. So that's kind of the way I look at it.
And Commissioner Gonzalez, I agree with everything you said, and I don't know where the rest of them land, but somehow or another, if you could take everything you said and stick it into the SBP, I think it would be awesome if we're in, have a majority that are sort of in agreement with that. I disagree with politely, Commissioner Messner, with the undue hardship sort of hurdle. I think it is a extraordinary or a exceptional circumstances. I think we've done, I think if anything, what we figured out is over the course of years, it's really hard to create an option mechanism that protectively establishes, good financial assurance for all the different operating models. And we've heard from, the CBM folks, or we've heard from the own resources or the evergreens that they've got good models, but they just don't collectively fit really well into one of, or more of the options. And so I appreciate your approach on that. I saw Commissioner Nanjapa. I also saw Commissioner Messner. Maybe I'll just go in that order just because I think that's who I saw first, but we'll all get a chance to talk.
Thank you, Mr. Chair. Yeah, no, I totally agree. The language I've been using and talking to stakeholders is I don't want to see option 5 as an escape hatch. I don't want to see it as you articulated, a way to get a better deal. So that's really my concern. And that's where I think it should be that the other options as we lay them out, every operator should fit into one of them. And there has to be a real exceptional circumstance, to use the verbiage that Chair Robbins just used, for why there is a proposal for something different. And in my view, it's more like circumstances where the amounts required maybe pose a problem, or the timeframes, or other types of unique circumstances. But yeah, exactly that. It should not be just a way to get out of the obligations that they would be expected to follow in the particular option that they would fit into based on their production threshold.
Commissioner Messner, and then Commissioner McGowan.
Thank you, Mr. Chair. Thank you all for your thoughts on this. And certainly with all due respect, but I'm adamantly opposed to an on-ramp for option 1. I think it flies in the face of the philosophical reason that we're developing an option structure. I don't think that, I think it's a mischaracterization to say that production is a proxy for financial health. That's not philosophically what I presented. I presented, the idea that production levels show operators that have wells that are closer to the beginning of life than to the end of life. And as philosophically, we look at this as a retirement plan over time, then we are requiring additional financial assurance as operators who no longer are producing new operations and are shifting operations towards existing operations and are getting closer and closer to the retirement age of their assets. Then we're requiring additional financial assurance. And so to me, philosophically, creating on-ramps that take wells that are closer to the retirement age of those assets than to the beginning stages of those assets, and putting them in a option 1 that really contemplates assets that are at the beginning of their stages because of those production levels, is a bolt-on that flies directly in the face of the philosophical approach of the option structure. And so I'm not in support of that. Now, having said that, I mean, this is why there is an option 5. And so that an operator can say, I don't fit. It's an exceptional circumstance. And I appreciate, I threw out the undue hardship piece at the last deliberations to create a starting point for discussions on understanding that there needs to be some discussion or for a qualifier for option 5. And so I think Mr. Matthews from COGA had some good ideas around what that qualifier could be. I'm not opposed to some of the things that are that Chairman Robbins has suggested, but I think there has to be a qualifier there. At the same time, I don't want to discourage creativity in option 5 because I think there's some options there, but I think we need to presume that operators can all fit in the option structure that we created. And rightfully fit into the options that we created, because our philosophy of the option structure that we created is that as it gets closer to the end of life, more and more financial assurance has to be secured. And so to me, that's a fair approach. And so I think that there are operators that will want to use option 5 because of some of the things that have already been mentioned. And I'm not opposed to operators utilizing that, but I think that's what option 5 is designed to capture, not creating an or a bolt-on option for operators who are naturally in option 3 or 4 to move into option 1. And so those are my thoughts on that. And I do think option 5 is an important piece. I think it can be utilized for a lot of things. I mean, we'll have a discussion about comprehensive bonds at some point here. I mean, I continue to believe that comprehensive bonds is an appropriate place to be considered in option 5. I think some of the other circumstances that are being discussed here as far as why there would want to be an on-ramp for option 1 is another reason to utilize option 5. But I agree 100% with Commissioner Gonzalez that it is not a mechanism to be utilized to get a 10% discount on their, on whatever their financial assurance requirements are.
Commissioner McGowan.
Thank you, Mr. Chair, and I'm really appreciating the conversation with everyone. Commissioner John Joppa, I'm trying to understand the on-ramp concept, and I guess trying to differentiate between on-ramp into 1 versus go the individualized route instead. And I think what I hear you saying is if you can show financial health and kind of what your situation is, you fit into tier 1, the tier 1 structure applies to you, but instead of the percentage excess of low producing, it's inactive that would apply. And then when you have to single well financially sure up is if you go above the percentage of inactive wells. Is that what you're saying? Because because potentially their whole portfolio could be low producing wells.
Correct. I mean, in thinking about this, I am thinking about some of these operators that we've heard from that are, they have a different business model, but they are, healthy operators. They are not necessarily at the end of their lives of operation. I appreciate those notions that Commissioner Messner that you raised. I think those are important in general, but I think that because we have a few operators that could demonstrate and prove up, their financial health. In particular, I didn't articulate this yet, but I think that option 1 in general should be fully a surety bond. And having a surety and being able to qualify for that, regardless of whether you're, qualified just based on production or in an on-ramp situation, gives some additional assurance that the operator is good for that amount, that full amount. But yes, the difference would be if it is an operator that would fall into, options 3 or 4, where their overall production threshold or overall production amount would be in the low producing range, that I'm throwing this out for discussion, would be that then they would be single well financially assuring all of their inactive wells, their excess inactive wells. So
okay,
that was the difference that I was proposing.
Thank you. I think I'm trying to decide if they should just go the bespoke route instead of the on-ramp, and I need to think about it for a little bit. For option 5, and again, I'm really appreciating this discussion around it. For me, some of the things to show that that we think you are capable of considering that option or route are some of the things that we've been talking about that show that an operator is in a healthy situation and in good standing. And I think we've heard some of the things that are red flags. And I think those are compliance history, being up to date on your MIT or brain head testing, up to date on your royalty payments. And then I know that I continue to push for, and I'm hoping we're going to have this conversation at some point during the deliberations this week, is that we do need to be looking at not just the surrogate of production of wells as financial health, but actual financial health of the operator. And I think that some indicators have been shared with us from stakeholders. I think a super easy one could be income to debt ratio. And if that's negative, then I think that's another red flag that we should be thinking about whether or not that person should be taking the option 5 route, or we should be concerned about what tier they're in. So I throw that out for consideration.
Thank you, Commissioner McGowan. I could weigh in a little bit here. I am in agreement with Commissioner Messner that I don't know that the additional on-ramp to 1 is necessary if we create a robust 5 with whatever parameters we think are necessary. I mean, there's nothing to stop a operator that doesn't necessarily fit into one of the categories as easily to come into 5 and offer up a 1-like approach, right? And it would be up to commission to make determination of whether that makes sense. I still think, and I could be convinced otherwise, that there are healthy operators in the state that don't necessarily fit into one of the options, and the bespoke does make sense for us to be able to sort of categorize those folks into a healthy financial assurance plan that is going to work for those more atypical operators. Commissioner Gonzalez.
Yeah, thanks, Chair. And I think I'm along the same lines as you and Commissioner Messner. While I would support an or addition there, I think that it could easily be captured under option 5, and maybe even specific language in the SBP that says that this could also be a possible demonstration for access to an option 1 blanket bonding regime or what have you. I think we have it pretty open-ended on what could come out of an option 5. So I would be comfortable with that going in there. And I think we could outline a lot of the things that were proposed as an and by Mr. Sura, and as an and or maybe an or from Commissioner Nanjapa into the SBP in terms of adding that to the list, right? I think that with option 5, it's going to take a good amount of capturing our discussion, our intent around what we would like it to be in the SBP supporting the rules, because I imagine this rule, it will be pretty open-ended when it's drafted as I think it should be. So that's kind of my 2 cents on that one. Commissioner McGowan, in terms of your suggestion about using income to debt ratio as a financial metric, I have some concerns with that. And when I think about it, businesses use debt for a lot of different reasons, and debt, it can be very different, right? And if you capture debt just in one way, you may be making a very clumsy application to financial health in that regard. So that's not one that I'm really keen to add as a potential financial metric. I think, if we think about this, as a component of an option 5 demonstration, I like going back to bond ratings. I think that those are better. I think that some demonstration of a balance sheet health, and perhaps that could be fleshed out a little bit, would be a good way of doing it. But when I think about debt and how it's used and the different types of debt, I have a hard time just categorically saying debt's bad, income's good. If you're at a negative in that ratio, it's bad categorically. I just have a hard time with that. So just wanted to throw out that piece as well.
Commissioner Messner.
Thank you, Mr. Chair. I mean, I see Commissioner Gonzalez and Commissioner McGowan's. I see both of the points here. So I have a suggestion to throw out there. So I do think, consideration of an operator's financial capability, is an important consideration in any of the tiers, or options, not tiers. And so one thought that I had, and although I think that, to Commissioner Gonzalez's point, creating that specificity within the rules of a shall and certain things that have to be required may be too specific and doesn't create the ability to really necessarily see the overall picture of an operator's financial capability to meet all of their obligations within the act. And so currently there's some language that's in option 5 that is a certification of financial capability. And it states that an operator will provide a certification of financial capability to ensure it's financially capable of meeting every obligation imposed by the act and commission rules. And the certification will be signed by an operator's corporate officer and will include its net worth demonstrated through financial statements accompanied by a modified opinion issued by an independent auditor. So that's what's currently stated in option 5. My suggestion would be to take out some of the last piece, right? And just say the first sentence, which is that they're essentially signing, an operator's corporate officer is signing a certification that states that the operator is capable of meeting all of their obligation imposed by the act. But in order to show that in their financial assurance plan as part of his financial assurance plan submittal in the statement of basis and purpose, it would incorporate some of what Commissioner McGowan is suggesting, which is these are some things that you could or should submit. And it doesn't preclude other things to be submitted. It doesn't say that all of these things have to be submitted, but this is a general idea of how you could, because statement of basis purpose is a guidance document to help operators comply with the rules. And so this is the things that you could submit in your financial assurance plan to show that you're financially capable of meeting your obligations under the act. To me, that seems logical within all of the option structures as a submittal requirement and an addition to the statement of basis and purpose, with that one piece that would stay within the rules. I'm sure I wasn't clear there.
Commissioner Gonzalez, do you want to clear?
Well, no, I don't know. I don't want to clear it up. I actually thought it was pretty clear to me, and I thought it was a pretty clever approach here. And so, you know, I like the idea of maybe a potential corporate officer certification that just kind of generally accounts and attests to an operator's financial health, and then accompany that with an including but not limited to type list in the SBP that says here are ways that you may back up that certification, right? And it leaves up to the operator and their unique circumstances to make that attestation in an appropriate way and in a way that best accounts for their financial health given their independent and unique financial situation. So I thought that was a pretty clever way of doing it. And I think that I like that idea. Now, Director Murphy, I see you type in here under the financial assurance plan options. I'm considering this under the option 5 kind of support in the SBP, as opposed to a requirement for a financial plan. I'm not quite sure how we got to that spot just yet, but I'm much more comfortable with it being in the option 5 support in terms of demonstration of financial capability, financial health, than as something that is required on an every financial assurance plan basis. I think that we're going to have an opportunity to look at these financial plans over and over again, and have that regular review that will allow us to look at changes in an operator's portfolio or what have you that would give us enough triggers to ask for more information should we need to.
Here, may I? Thanks. I may have misunderstood Commissioner Mesner, but I thought he was reading language that we have included as a requirement for option 5 and truncating it a bit to have it applicable to all other financial assurance plans. Because right now, the statement that he read is a requirement for an option 5 submittal.
Commissioner Messner?
Thank you, Mr. Chair. Yeah, so to be clear, I was taking some language out of option 5, and my suggestion is to take that language and to put it in all of the options, right? So that initial language, which would require officer's signature, ensuring that they're able to comply with all the obligations under the act. I mean, that specific language being more specific in the existing rules. Applying that to all the options as a financial plan requirement, a submittal requirement, and then in the statement of basis and purpose, creating what I had suggested and you had talked about, Commissioner Gonzalez, which is these are the things that that could be submitted in order to make that showing. So because I do think if we're going to require it for, I don't see a problem with requiring it for all the options, because we do have an obligation to ensure that all operators are able to meet their obligations under the act. And I think this is a pretty clean way of doing that.
I think I could probably get behind Commissioner Messner's idea here. I think it's a little bit of a boots and suspenders approach, and does allow for creativity. And I like the idea of the sort of broad sentence and then the backup with some of Commissioner McGowan's thoughts into the SBP. Others? Commissioner Gonzalez?
Yeah, thanks, Chair. And I guess I didn't quite understand that connection that Commissioner Mester was making. So I apologize, Director Murphy, for calling you out for typing on the wrong slide. But no, that makes sense to me. I want to think about it a little bit. I don't, at first blush, to think about it just as a certification of financial capability. That's the obligation under the rules, right? That you are financially capable. So to attest to that, I don't see a problem off the front end of it, but I'm going to give that some more thought. So I appreciate the suggestion.
Commissioner Nanjapa?
Thank you, Mr. Chair. Yeah, I'm not opposed to this being added for all of the options. I guess I'll just maintain what I said before about where I see option 5 being used. And I know we haven't done any straw polls yet, but I still think that for the very few operators that could demonstrate and prove up financial health, that an on-ramp consideration is not unreasonable, but I may be outvoted, so.
Okay, Director Murphy.
Thank you. So what I've heard is support for using some modified language from 702 D5F. And I think I have the site right. I'm sure Caitlin would have told me if I don't. As incorporating Commissioner McGowan's concept of articulating operators' financial health as part of all options. And Commissioner McGowan, I think that would be in lieu of the income to debt ratio, but if I've gotten that wrong, let me know. Otherwise, I'm going to delete it. I see you affirmatively shaking your head, so I'm going to delete this piece. Maybe not very successfully, apparently. And with that, it seems like we've closed the loop on this individual conversation within the broader topic of what information should be collected on financial assurance plans. I think that there remain a number of outstanding discussion items from the previous 2 slides. I don't know if we want to go down and make a decision about whether there isn't an alternative on-ramp to option 1, or get back into the meat of what the criteria for the different financial plan options are, and the amounts. But I would probably suggest taking us back to at least option 1.
So also sort of cognizant of time in terms of where we're at, are folks So we do need to break at 11:30 to noon for a break. Do folks want to take 5 minutes to right now, and then we can dive back in, just kind of a short break, and then we can dive back in? So why don't we do that? Let's return at 10:44. Hey, welcome back. It's 10:45. This is the Colorado Oil and Gas Commission. We will continue with deliberations. Director Murphy, thank you for resharing screen. We've kind of been sort of rambling all over the place with good thoughts and deliberations. Where do we collectively think we ought to go next? Commissioner Messner, Commissioner Gonzalez. Go ahead, Commissioner Messner.
Thank you, Mr. Chair. Are you suggesting shifting to another topic, or where should we go within this topic?
I think it's more like, where should we go within this topic? We've
Um,
been talking about the various options. We've not had any deliberation yet amongst ourselves on option 6. We do need to talk through that as well. Again, it's kind of like do you pick them off one at a time? Do you look at it holistically? It's not easy to sort of figure out the best way to have 5 or 6 folks deliberate on these topics.
Well, from this commissioner standpoint, it seems appropriate to kind of solidify as much as possible options 1 through 4, solidify generally option 5, but I think option 6, at least from this commissioner's opinion, relates to option 5. But I think there's a couple of things we want to solidify but in options 1 through 4. And I think one of those things is whether or not to have an on-ramp to option 1. And then at some point, I also would like to talk about kind of a broader concept within the options, which is kind of financial assurance plan submittal requirements. Because we haven't totally talked about that yet, and that may be separate. So anyway, those are my initial thoughts.
Commissioner Gonzalez, you had raised your hand. I don't know if that still is on point or not.
No, I think we should work our way through the options, finalize that. We'll move on to the next topic, which I think could be financial assurance plans.
All right, do we want to sort of take a straw vote on whether we want to have an option 1 on-ramp as suggested by Commissioner Najapa? Go ahead, Commissioner Gonzalez.
I'd like Commissioner Najapa perhaps to flesh out what that on-ramp looks like in her mind, so that we have a proposal to take a straw vote on.
Commissioner Najapa, you've been called out.
Yes, thank you, Mr. Chair. Yeah, so again, my thought here is that we've got some good operators that don't meet the particular production threshold that I think could prove up financial health. And my thought there, again, in general for option 1, I think, is that it should be the particular type of financial assurance that we should require, in my view, is a surety bond in total. And so therefore, anybody on-ramping would have to qualify for a surety bond in the total amount as required. And then related to that, I think if we're now including the language that Commissioner Messner just noted with respect to financial capability and a signature from the corporate officer and a few other items, I would add to that the rating for the bond that they are securing, Standard & Poor or Moody's rating, perhaps require more specifically in the on-ramp, the audited financials and then in general, commission compliance. And I'm in particular thinking about whether they're up to date on MITs and Bradenhead testing, royalty payments, and no major commission violations in the past 3 years. And then the last piece that I've thought there is plugging versus either drilling or acquisition, knowing that in some cases, we've got operators that are not drilling and maybe just acquiring, or perhaps neither. But as long as they're also plugging, we can have a summary of their plugging history over the past at least year. So those were my thoughts on what would have to be proved up to get into option one. So yeah, I guess I will leave it at that as in terms of the consideration for, and then with the other caveat that I noted, that if the operator that is trying to prove up their ability to on-ramp into option one, if their overall production threshold, the production average is in the low producing threshold, so what is it, 2 BOE or 10 MCFE, that they would single well financially assure all of their inactive wells.
Commissioner Messner.
Thank you, Mr. Chair. I think again, and I'm just gonna state counterpoints to this so that I have that on the record. I mean, in talking about I've already talked about the overall philosophy and how I believe like this doesn't fit into the general philosophy. But as we get into the specifics of this, we've got a situation where, option one necessarily has a backstop of the requirement for single well financial assurance for all low producing wells. That is another layer of protection around financial assurance. With this proposal, you're taking an operator, and I'm not arguing whether or not an operator has financial capability or is a successful operator, but whose portfolio, because they are in option 3 or 4, has a significant number of low producing wells. You're allowing them to come into option 1, which is also a director recommendation in option 1. So you're asking the director to make a discretionary decision, because it's an option 1, on whether or not this plan is appropriate. You're giving them a reduction in the necessary backstop of requiring single well financial assurance for low producing wells in option 1. And so, and I also picture, I assume that most operators out there think that they're good operators and have good financial situations. And so you're opening the door for every operator who's in any tier in any tier 3 or 4 to come in and petition to be option 1. So I see too many problems with the application of it. I think that utilizing in these particular situations that you may be thinking of, option 5 is a good utilization of option 5, allows for commission review and allows for the considerations that you're proposing as an on-ramp. And I think it's just cleaner and in line with the overall philosophical approach of the option structure.
Commissioner Messner, I tend to agree. I would like to give Commissioner Najaba an opportunity to sort of explain the benefits you see with this approach that would not otherwise be obtainable through utilization of option 5.
Thank you, Mr. Chair. I think in general, it's just that my philosophy on option 5 differs, I think, than maybe where the rest of you are going with it. I see it as a much more limited, scenario of using that option for very special and unique circumstances. Whereas this, in my view, when we're talking about some of these operators that do have business models that are based on lower producing wells, that are otherwise financially healthy, compliant with the commission. And just on that note, for Director Murphy, my comment, there was no major violations in the past 3 years. But also that they are, so by requiring all of those operators to have single well financial assurance, I understand the premise that Commissioner Messner has brought forward, that we're talking more about wells that are potentially at the end of their lives. But in talking with some of these stakeholders, my understanding is that we have a few unique situations with certain operators that it isn't necessarily the end of the life of some of their wells or their overall portfolio, and therefore being required to have single well financial assurance for some of these particular operators feels a little punitive. And so by having an on-ramp option, it gives them an opportunity to demonstrate and prove up and show their sort of good behavior, for lack of a better way of talking about it, and their ability to have a more favorable financial assurance plan. So that's just my kind of general thoughts on it. I do think that the general concepts that we've talked about with option 5 make sense in particular circumstances, but I think in this circumstance, when we're talking about these types of operators that have, that can meet all these criteria, why not allow them to just ramp into option 1 rather than say, we'd like to propose an option 1 like plan? I guess that's just my view on it. But
Okay, thank you. Others with comments on this topic? Commissioner Gonzalez?
Thanks, Chair, and I appreciate the discussion here. I've been kind of agnostic as to whether or not this falls as an on-ramp for option 1, or whether it should be best under option 5. And when I thought about it just in terms of looking at bond rating or one specific financial metric to look at, that's enough of a bright line for me that I think it would be easily to administer and to capture financial health and move as an on-ramp into option 1. But when we start getting into these, multiple trigger points on what would be allowed to access this alternative criteria, it starts to sound a lot like an option 5 is the better place for it to be in my mind. Specifically when we start saying, okay, it's going to be option 1, but then you're excluded from the low producing threshold, and instead for you, it's an inactive threshold. I think that's a challenge for me to reconcile. I think the security type limitation for the alternative criteria may or may not be a pinch point. I can envision there might be operators who have cash on hand and are willing to set it aside and through a letter of credit or some other financial instrument that takes the money out of their hand and puts it, essentially with the commission as a beneficiary. When we think about summary of annual plugging history, to me, that's not bright line enough. That adds some subjectivity to it. And then the last one, that it goes to a commission decision as opposed to being through the director, which is, again, another part of an option 1 way of dealing or administering this option. All these things compounded start pushing me toward the camp of this should be an option 5 consideration. And I think that there are specific operators that are being contemplated for this potential on-ramp. And I think that those operators would, in my mind, from what I know thus far, be pretty good candidates for an option 5 approach. So that's where I'm leaning there is towards moving, just given all this list, moving it over to the option 5 per Commissioner Messer's recommendation.
Commissioner McGowan?
Thank you, Mr. Chair. And I think I agree with the points being made by Commissioners Messner and Gonzalez in that I think this is hard because we do know that there are these operators that don't necessarily belong in option 3 or 4, but I think that, if the bespoke option, the individualized plan survives and kind of put some guardrails around it, I think that maybe that's a cleaner way to deal with those folks who have those unique circumstances.
Commissioner Nanjapa?
thanks, Mr. Chair, and thanks all for the discussion. I appreciate, I don't have any hard feelings if my ideas are not accepted. But I will say that the reason that I, brought some of these ideas and in particular the criteria for it is I do feel that there are very few operators that would qualify, and that it should be a high bar if you're gonna, if we're gonna allow this as an on-ramp. But if it sounds like everybody is viewing the option 5 a little differently than me, and that's fine. But I just wanted to note that that's where I was with this on, for the record.
No, I appreciate that, Commissioner Najapa, and I think your thoughts, if they have not generated a majority view, might help us in terms of framing option 5 when we get to that point. So let's move then with the concept that we're not doing the on-ramp, with all due respect, and then we can look to, some of the other pieces to options 1 through 4, 5, and 6. One point that I would raise, and this gets back to Commissioner Messner's idea of a, weaving in some form of corporate officer signing off on financial assurances, and I'm not sure exactly what the language was there, Commissioner Messner, but I did have some discussions with some of our stakeholders, and that may be a difficult undertaking depending upon public versus private capacity. And I know that there are certain SEC filings that in particular public companies have to do that are kind of a corporate certification to the SEC and the investors as to financial health, et cetera. And I just wanted, I don't know if, and I'm talking a little bit out of school because this is not my area of expertise, but I wondered if we could have some discussion around that as an alternative to signature from corporate officer. If there are, it's kind of like that, if there are already something that's been done in the public world in particular, if we can just look to that as an example of financial worth. Commissioner Messner?
Thank you, Mr. Chair. I appreciate those thoughts, and I'm a little surprised because this was, I pulled that language from the existing draft and heard no testimony on it in the last review or the last week. And so I'm not sure why all of a sudden it's a problem now, but I think that the intent there, and I think we can play with the language, and I'm actually comfortable sharing intent at this point and allowing some language to be crafted to react to. But the intent there is that there is an operational sign off on an acknowledgement, right? That there is a responsibility to meet all the obligations of the act. And then in the SBP, creating some guidance on ways that you could meet that obligation, right? Or meet that requirement. And so that's my intent. I'm open to different ideas, but understand that I pulled that operator's signature or the officer's signature thing from the existing draft in option 5.
Okay. With that, and I've not really been paying attention to your scrollings over here, Director Murphy. Apologies, I'm trying to keep track of hands being raised, et cetera. Where should we move?
My suggestion, Chair, sorry, I went to the wrong slide, is that we try to elucidate from each other whether there are additional discussions to be had around option 1 or option 2, financial assurance amounts or thresholds or criteria, and then do the same for 3 and 4, knowing that we've got kind of this backlist on slide 6 of kind of some categorical questions about what information are we gathering in financial assurance plans themselves.
Commissioner Nanjapa?
Thank you, Mr. Chair. If we're going to discuss amounts, I had a proposal that differs from the 211 draft in terms of how the amounts are calculated for the blanket bonds for options 1 and 2. And this came up in part from comments that Commissioner Gonzalez had raised with respect to, perhaps some sort of flat percentage, and thinking about the operator that has 48 wells versus 53 wells, and how those kind of fall out, or those in those different numeric counts, that separate the amounts per well that are paid. And so if we're ready to go into that discussion, I put together a little chart I could share just with what I'm proposing. So I guess we're ready to do that. Let me share my screen here. Okay, so this is what I'm proposing, is that for option 1, it would be a 5% calculation per well across the board based on 100,000 per well. And the reason I went with 100,000 is that, knowing that in some cases it's going to be an overestimate, in some cases it's going to be an underestimate. But for the purposes of blanket bonding, it just, creates a nice round number. And so this is the current means, that current column is based on the 211 draft. So if an operator under option 1 had 49 wells, they'd be paying 588,000. If they have 53 wells, they would be paying 636,000. If it was a flat, so 5% of 100,000 is 5,000. So if you want to look at the formulas up here, these are all basically taking the number of wells times 5,000, and you'll see that it's the same, when you're at that 150 to 1,500 range, because that's the same amount that is in the current draft. But as you get up in numbers of wells, we're having those operators pay a little bit more. And I think that's appropriate, because I think that we should have a little bit more sort of equitability across numbers of wells. And I don't think it's an unreasonable amount. I ran this conceptually by a few stakeholders over the weekend, and they were favorable, including on the industry side. And then option 2 would be a 10% flat amount. So again, the operators with the smaller number of wells get a little bit of a break. You get to sort of a break-even point when you get up to the 1,500 wells in this case. But again, we're getting, the numbers are not all that far off if you look at them, kind of from this perspective, especially in the upper 3 tiers. But when we're talking about less than 150 wells, then those operators are getting a slight break. And it is just a cleaner calculation. So that we don't have to think about, is it this many wells? Oh, this is 1,500, or this is 3,000, or whatever. So that's just my proposal for you all to consider. And I can send this, for consideration in the record. But it was just something I like, again, how a lot of our other ideas are getting to something a lot more simplified. And that's where I was my mind was in proposing this.
Sorry, I was looking at the notes. I think I saw McGowan and then Commissioner Gonzalez.
Thank you, Mr. Chair, and thank you, Commissioner Nanjapa, for sharing this. I want to make sure I'm understanding the proposal, the supposal proposal. So is it 5% of whatever single well financial assurance will be set at? And in this case, you assumed it was $100,000?
No, so what I'm proposing is for the blanket bond amount. So the blanket bond still only applies to up to 10% of the low producing wells in option 1, and up to 5% of the low producing wells in option 2. So those numbers stay the same. I know it's a little confusing because I'm sort of flipping the percents on the blanket bond amounts. So I don't mean to confuse there, but the single well financial assurance calculations for the low producing wells would be a separate calculation. This is just for the blanket bond that applies for up to 10% of the low producing wells in option 1 and 5% of the low producing wells in option 2. Does that make
So,
sense?
sorry, so I'm trying to figure out, so I think what you're saying is you are assuming in these scenarios a per well. I guess I'm not, I think, yeah, I need you to walk me through this again and what you're taking 5% of. What is the 5% and 10% of?
5% of the total number of wells and 10% of the total number of wells. And that is the, for what is calculated for the blanket bond. So in the current option 1, sorry, I'm going to scroll to the language there. It's when you're in, for example, in option 1, we're talking about 702D. Sorry, 702D2 Part B, where this is talking about, so the total well count excluding the out of service wells. And in the current proposal, it is, in option 2, it's 18,000 per well. In option 1, it's 12,000 per well for that 0 to 50 category.
Yep.
And then in for 50 to 150, it's 10,000 in option 1. In option 2, it goes up to 15,000. And then so those amounts, if you look at those, the AA, BB, CC, in those different sections. So what I'm saying is, rather than having these different amounts per well, I'm proposing that we look at 5% of 100,000 per well for the wells that are going to be included in the blanket bond. And so that comes to 5,000 per well for option 1, all across the board, no matter how many wells you have. And option 2, it would come to 10,000 per well, all across the board. And so when you look at these numbers, you can see that when you're less than 150 wells, and I just kind of threw out these different random, numbers that fit within those numeric categories, that you're going to have less, as you get kind of lower number of wells, less, a smaller amount required for the blanket bond. But as you get into a greater number of wells, it's a larger amount for the blanket bond, which I think makes sense, because I think that the greater number of wells you have, the more financial assurance that the operator should carry to kind of, I don't know. I guess I don't think it made sense entirely to me that we go so far down, to like 1,500 per well when you're talking about a smaller number of wells. I'm sorry, a larger number of wells, like over 4,000, for example. So I'm just proposing a cleaner calculation that in option 1, it would be 5,000 per well across the board, no matter what number of wells you have, and 10,000 per well for option 2, no matter how many wells you have. Does that make sense?
Yeah, yes, makes a lot more sense now that you walked through it. Thank you. And sorry, do you prefer this just because it's cleaner, or sorry, it's cleaner, but you also philosophically, this means operators with more wells are taking on more financial assurance?
Right. It would be a larger amount in the blanket bond, which I think philosophically makes sense.
Okay, thank you.
Sure. Thank you, Commissioner Nanjapa. I always appreciate creative ideas and simplicity. So I really like really like the thought here that went into this, and it was along the same lines that I was thinking during our kind of pre-deliberation session a couple weeks ago. One of the things I was thinking about as I was going through this is the greater amounts or the greater deltas affecting the operators with more wells. And the way I've always thought about the blanket bonds as it currently exists, as it's been proposed in our draft rules, is that the more wells you have, the more likelihood that your producing wells will cover your plugging obligations, which is why I think the numbers go down as you have more wells in your portfolio. When you have fewer wells in your portfolio, you have to have higher coverages because there's an assumption or there's some thought that perhaps at some point, if some of those wells go down, you may not have enough production to cover the plugging costs just within your portfolio. So that's kind of one initial reaction I have to these numbers, in particular to the over 1,500 benchmark, or over 1,000 benchmark. Looks like that's where kind of the information melds, or the models meld there. So that's a concern I would have. I don't know if this is the place to introduce this, but looking at these numbers got me thinking about an idea that I had tossed in my notes and had chatted with a couple folks about over the weekend. But it's the idea of maybe a cap on blanket bond amounts and or on excess low producing or inactive amounts. And what I was thinking there is that, if you have an operator who has a big well portfolio, right? I'm less concerned about that operator so long as their production falls into the option 1 or option 2 categories. I'm less concerned about them orphaning those wells. That being said, the protections in place as this goes as proposed, you're looking at $21 million, which is almost double what would it be under the current model. And under the current model, I was even thinking about a cap. So numbers I was thinking about there were $15 million cap on the blanket bond totals and a $30 million cap on the excess low producing well totals. And the reason that the second one's bigger than the first is because my understanding that even in the current regime, that the excess inactive bonding as it is currently is the vast majority of an operator's financial assurance. So that's kind of another wrinkle I'm not trying to introduce into this already new wrinkle, but I thought it'd be appropriate for me to kind of throw out this time as a placeholder for other discussion. I appreciate the simplicity. I think that after the discussion we had in the pre-deliberations, I kind of went back to saying we've worked under this bucketing regime for the blanket bonds in the past. It seems to work. There's comfort on its application. There's a known applicability to it. So I want to give this some more thought. I'm not ready to make an opinion on it right now, but those are just some of my initial reactions to it. And again, I appreciate the clever work as always. So thank you for the proposal.
Commissioner Messner.
Thank you, Mr. Chair. I would agree with Commissioner Gonzalez. I appreciate the creativity. I think that there's lots of different ways to get at numbers and to approach, how to determine the financial assurance amounts and blanket bonding. Over the last few months, I've utilized trying to apply percentages. I've tried to utilize concepts similar to what North Dakota proposed, which was 100,000 for every 6 wells. And there's lots of different ways to do it. I think a couple of things about this particular proposal, and one is just a timing issue. I'm a little uncomfortable at this late in the game proposing this big of a shift in how we're considering some of this stuff, particularly because we've already had party presentations on a number of different drafts. And to me, if we're going to introduce something like this, it would necessarily require another round of party presentations, because I think it's a significant shift. And so I'm a little concerned about the timing of it. I also think as at least anecdotally, my understanding of some of the situations that have resulted in wells on our orphan well list. It's not the biggest operators that most often have wells that ultimately find their way to our orphan well list, but oftentimes it happens to be some that have less wells. And so I guess I'm not totally sure what the rationale would be to ramp up the amount of financial assurance for those who have more wells and ramp down the amount of financial assurance by more than double the financial assurance requirements for those with less wells. I'm just not sure what that nexus would be that would rationalize that. I also think it's important to acknowledge that, I mean, I'm not sure on your proposal here, but if you're basing it just on $100,000, that's one thing. If you're also allowing for demonstrated cost, then the numbers that we're seeing right here can also be significantly lower than what we're seeing right here, which also makes me uncomfortable in some instances as well. And so, I mean, again, I always appreciate creativity, and I think that, I certainly think that there's ways to work with this and rethink it. I'm just not sure at this point it's the right time to bring it up.
Commissioner Nanjapa.
Thank you. Just to respond on that, and I appreciate all the conversation so far. This is, obviously specifically for options 1 and option 2. So we're already talking about operators who are above the 60 BOE or 90 MCFE in option 1. So even if they have fewer wells, I'm not sure I totally followed what you were saying about like fewer wells being more risky, because we're also talking about really high production levels. And then, in option 2, what is it? 15 to 60 BOE and 22 to 90 MCFE. And so I think, we're still also talking about, pretty high levels of production, but they are a little more risky. So that's why it's a greater amount, which is the same as our current draft shows. I did run this by several stakeholders and did not get major concerns raised. But I appreciate what you were saying about folks not having the ability to directly comment on this. And I would be open to us inviting, a few folks to comment on this if there's enough support amongst you to think through it. But really all I was trying to get at here was simplification of the calculation and, certainty, I guess, both for us and the operators in terms of what is going to be expected of them, regardless of how many wells they may acquire or, get rid of or plug or, those kinds of things. So that does kind of help create certainty in both cases. So this is apart, though, as I said before, from the single well financial assurance calculation for the low producing wells. So this is just the blanket bond calculation. I'm not sure exactly. I don't remember if we had a specific explanation on how those particular numbers, 18, 12, 15, or whatever they were that were determined for the different numerical separations. So I'm not sure. I don't know. And Director Murphy, if there was a method to that madness, that would be great to understand a little bit better. But I think, the idea here is just to simplify and to be able to have an easier calculation for the blanket bonding. I'm not opposed to a discussion on caps as well. I'm not sure with respect to the amounts that Commissioner Gonzalez just threw out, but I wasn't sure if we were getting into that conversation, because I think that is another conversation that we need to have around all of this. But anyway, I just wanted to respond on those particular points that, we're already talking about the highest producers in these two options. So fewer number of wells, but really high production, and separate coverage of the low producing wells made me feel like going to these numbers is not introducing additional risk.
Commissioner McGowan?
Thank you, Mr. Chair. Commissioner Messner, could you explain to me your concern about demonstrated cost with this proposal again? I'm not quite sure I caught your meaning, because demonstrated cost is demonstrated cost regardless of whether we're picking this model or a different model, correct?
Yeah, I mean, I agree. Demonstrated cost, I think demonstrated cost needs to be an important consideration. I think my point is that we're picking numbers here for comparison in here. And so we're assuming 100,000. We haven't made a determination of what single well financial assurance actually is. And so there's just an assumption in here that 100,000 is going to be our dollar per well, is going to be our dollar amount associated with single well financial assurance. In addition,
Just for the blanket bond, sorry to interrupt, just for the blanket bond, not for the single well financial assurance calculation. Otherwise.
Right, that's how I'm understanding it. The $100,000 is just the amount you're taking 5% of to figure out your per well in the blanket bond, but then the in excess low producing, right?
I understand, but I mean, the 100,000, I mean, it would be easier just to say 5,000 and 10,000 than percentages of 100,000, because if that's the case, then that's the
Commissioner
case.
Najapa is shaking her head, but I'm inclined to agree with you. I don't know. We're just saying it's 5,000 per well and 10,000 per well.
Sure, I was just letting you know how I calculated it, but I agree with you. Like it doesn't really matter that it's based on 100,000. That was just the way I came up with that number. But it is really just 5,000 per well and 10,000 per well. So if we want to just kind of forget about that part, because it is a separate calculation for the low producing wells, single well financial assurance for the low producing wells, I think, you know, I don't want to confuse that. So I want to make sure that, I mean, if we want to just think about it, I can just take out these percentages and just talk about it as 5,000 and 10,000. That's really what I'm trying to say here.
Okay, well then that changes, because I was assuming that you were saying single well financial assurance was 100,000 per well, and then you were basing your calculations off of that, which is what initially was proposed, I think, from Commissioner Gonzalez, was to look at single well financial assurance, do a percentage off of that, as far as perhaps looking at what could be included in blanket bonding. So this is really a different approach, which is it's 5,000 and 10,000. So that initial piece that I had talked about, as far as demonstrated cost effectiveness, I guess doesn't affect it. I think it just flipped. Essentially, I mean, I'm looking at it, all it does is flips what the current draft indicates on its head, and charges more for the bigger operators and less for the smaller operators.
Commissioner McGowan?
Thank you, Mr. Chair. So I'm not necessarily opposed to discussing this idea, and I think it's another way of looking at it. I am with Commissioner Messner. I feel like we just got beaten over the head when we added voluntary relinquishment and timing and allowing people to comment. So if we decide we want to put this option on the table, I think we really need to offer folks a chance to give us feedback on it. And I appreciate that you've talked with some folks, but that's different than folks having time to kind of chew on it and digest it and give us feedback. So I am not necessarily opposed to this idea. And I think philosophically, there are some things here that make sense. And Commissioner Gonzalez, I feel like, so to Commissioner Njapa's point, these are on average high producing wells. I think operators with many, many wells might get into option 1 or option 2 by putting a lot of their wells on the out of service list so that their average increases. I think they have a lot of low producing wells, and I think that those are the higher risk wells when we're talking about when we need to think about bonding up. If you have fewer wells, your average across the wells is probably higher, I think. So the only concern for me here is that it needs to be vetted with the folks and give them a chance to talk about it. And so I don't know what the appetite is for the commissioners to do that.
All right, well, maybe I can weigh in a little bit. First, I appreciate the creativity, Commissioner Najapa. I tend to agree with Commissioner Messner, though, that we're pretty late in the game at this point, and we've spent a lot of time with a lot of vetting of the structures that we already had. I, for one, am not interested in reopening up for additional vetting on ideas. I would like to, and I think the state deserves getting this wrapped up so that we can move forward. And I, looking at how this plays out, I'm pretty comfortable with the current structure which has the lower numbers with a little bit bigger bonds as opposed to the higher numbers with a little bit bigger bonds. So I appreciate the creativity, but I would likely, if we did a straw poll, just suggest that we stick with what we've had. I have several dogs that just showed up, so I'm going to mute, but if someone wants to speak, just raise your hand and go for it. Commissioner Messner.
Thank you, Mr. Chair. I'm going to fall in the same line as that, and I appreciate the creativity. And I'm not sure this is any more protective philosophically, looking at it holistically than what's being presented that would warrant the additional time necessary to fully vet this particular option. And so so I'm pretty comfortable with where we're at right now as far as the option 1 and 2.
Commissioner McGowan.
I think we'll be on the end of this straw vote, but I am open to letting folks review it and give us feedback.
Commissioner Gonzalez.
Thanks, Chair. Where I sit now, I'm with you and Commissioner Messner. I really appreciate the creativity and the ideas, and I had a bunch of ideas this weekend too, and I was thinking, oh man, is this just too much too much of a change to bring up? Some of those things that I've held back on for the sole purpose of we're trying to get to resolution, and I think that the outline that we currently have works. May this work better? Possibly, but is the incremental benefit out of it, or the incremental protections going to be great enough to kind of warrant more delay and more feedback on it? I'm inclined to say probably not, and so that's just my 2 cents on it. I think I'm in line with Commissioner Messner and Chair Robbins in that regard. Excuse me. Again, I don't want to stifle any creativity. All the ideas that come up are helpful. They help us get into this dialogue. So please keep them coming. And I'm just not aligned on this one. Thank you.
Okay, if folks are comfortable, I think it's sort of straw poll 3-2. So I think we have a sort of landing spot. Again, all the admiration in the world for the great thinking from Commissioner Najapa. It is past 11:30, and at least 2 of us had an 11:30 hard stop. If we could, I'd like to take a break and call it an early lunch break. And I would suggest maybe return at 12:15. That's a little more than 40 minutes or thereabouts, and then we will continue forward. And I want to thank the commissioners for the great work this morning. We've tackled quite a bit of very important topics. See you at 12:15. Okay, welcome back. This is the Colorado Oil and Gas Conservation Commission. It's 12:15, and we are back live. Thank you for the break. I have to admit I was preoccupied and not able to eat lunch over the lunch break, so I still have a little lunch to go, and I may turn my video on and off so you do not have to see me chewing. So with that, Director Murphy, I don't know if you have thoughts about direction. We've had a lot of good explorations around the options, in particular, 1 and 2. I think there's probably still some discussions around 3 and 4. We've had some discussion about 5, and we've had no discussion about 6, which is the sort of comprehensive bond. Maybe we could go there as a starting point. do you have thoughts, Director Murphy, on next steps? Okay. Commissioner Gonzalez, are you raising your hand?
Yeah, I was about to, Chair. I wanted to bring up the idea specific to options 1 and 2 of a cap for those amounts. And the numbers that I've thought about and that I'm going to propose are, if the idea is palatable to and acceptable to the rest of the commission, and it's this commission's pleasure, consideration of caps on the blanket bonding amounts, just so that there's some certainty on the level of exposure that is that is out there, and really, to make sure that it's in line with the appropriate level of financial assurance in general on an operator basis. So the numbers I was thinking about were for option 1, 15 million for the blanket and 30 million for the excess low producing wells. Another reason why I think this may be important is with the low producing 30 million for the excess low producing wells, is that with the low producing wells being the trigger here, we're talking about a bigger bucket. We haven't quite run the numbers on what that inclusion looks like. And so I think that a backstop through the idea of a cap could be a beneficial way to go. For option 2, the numbers I'm thinking about are 25 million for the blanket bond, and then the same amount for the excess low producing wells, 30 million. So I'm not quite sure if anyone's thought about this or has any comments or concerns about it, but I'd like to open up discussion.
Commissioner Messner?
Thank you, Mr. Chair. I mean, essentially, I think what you're suggesting with these caps is you're looking at both low producing well cap and a blanket bonding cap is a comprehensive bond. And so, I appreciate the statement that you made that you're looking for a certainty for a level of exposure. I think operators in this system have the ability to create certainty in their level of exposure by utilizing the out of service well list, by determining how many wells they want to have that are low producing, and balancing their portfolio necessarily within the structures in order to create their level of certainty as far as exposure goes. Again, I think that there's ways to utilize option 5 to create some administrative simplicity as far as what their approach could be. And I'm not necessarily going to say absolutely no right now. I want to have further discussions about option 5, about option 6, about how some of these things tie together. I've heard a counter proposal to the one that you're floating out there around, essentially creating another tier, which would be a tier that would utilize the production thresholds associated with option 1, but rather than a straight cap on low producing wells, it would create an additional allowance for low producing wells, up to 20% of overall wells being allowed to be low producing. And so understanding that there's and use that potentially in place of a comprehensive bond. And so, again, I think that these creative solutions like that can be utilized within option 5, option 5. Yeah. But I don't know right now that a one size fits all cap, because I think as we're talking about, it's the same concern I have with a comprehensive bond, which is we're allowing consolidation of operators under a parent company. It's unsure how many overall wells we're talking about. If we're allowing this, potentially allowing this consolidation, we're essentially setting a cap. And so instead of a $30 million cap, we're setting a $45 million cap and or a $55 million cap, depending on whether you're in option 1 or option 2. And is that, I mean, that has the potential to be a significant reduction in overall financial assurance requirements for the biggest operators, but those operators that are like just meeting that, they're still having to just meet the financial assurance requirements. And so I see equity issues there, and I see disincentives for utilizing the out of service well list. And so these are the kind of this is a little bit of the heartburn I have with it. Although again, I'm happy to have dialogue around it and continue to think through it.
Commissioner Gonzalez.
Yeah, I just want to respond to one point and acknowledge something that I hadn't considered that I think is an important consideration and will influence how I think about this going forward, is how it may be affected through consolidation. I think that's a really important aspect as we consider it. I'm just thinking about ways that we could create, a backstop of what, kind of overall for an option one operator or an operator with high production, what an overall kind of adequate amount of financial assurance would be. The reason I chose my numbers is because they are kind of rounded up by multiples of millions from numbers that I've heard some of the biggest operators falling into. So it's my understanding and anticipation that under the proposals that, as I understand them to be for the two options, and understanding what I have heard from certain stakeholders in terms of whether or not they fall into those two options, what their amounts would be, is that these would exceed that. And so this is kind of more of a future backstop, the way I'm thinking about it, more so than a status quo backstop. Now, the numbers that we receive, I haven't vetted them or, looked through and double checked everything against COGCC, but I'm kind of taking them at face value there. And yeah, it's just an idea to socialize. I think it could be considered in conjunction with our discussion for option 5 or potential option 6. But I'd like to keep a pin in it until we do make a determination on it. And this is a new idea. I don't know that I heard anyone ask for a cap in our deliberations. But I heard a lot of concerns about some of the numbers that our financial assurance plans could drive operators to from that total financial assurance exposure. And so I just wanted to throw that out there as an idea. I'm not married to it, but I don't think it's a bad one. It is new, and I welcome other thoughts on that.
Thank you, Commissioner Gonzalez, and thank you, Commissioner Messner, for the two sets of thoughts. I agree, it's all kind of intertwined. And so maybe if we can hold it there for a bit, Commissioner Gonzalez, and then further the discussion around sort of the comprehensive bonds, the option 6, and then come back and sort of see where we're at. That might be an appropriate place to go forward. This is also hard because everything's so intertwined and interrelated in trying to create the appropriate protocol. But with that, I will muse a bit about option 6 and the comprehensive bond. I'm generally speaking, I'm in favor of it. I think that it is an appropriate option to have for our operators. I'm comfortable with the $30 million number. I'm comfortable with the protections that exist for that. I'm comfortable that the operators that would take advantage of that are the operators that are doing most of the additional development within the state, and they're the operators that provide the least risk. I'm comfortable with the administrative approach that exists for that. So in general, I would sort of start that discussion with one commissioner's ideas that it is an appropriate and appropriate piece to the puzzle that we're building with our other options. Commissioner McGowan.
Thank you, Mr. Chair. So I am not opposed to the comprehensive bond, and I think that it creates an avenue for folks who have a lot of inventory that toggles between different things and they're buying and selling wells, et cetera, that it can be potentially an elegant solution. I personally think the $30 million is too low with the number of wells that we're talking about with these operators. I guess I'm thinking more along the lines of a $40 million amount for the comprehensive bond. And then I I think I was talking last week about my concerns that if you have a comprehensive bond and all of these if and what then kind of rules do not apply, that there's a potential that wells could be sitting in an inactive status or a low producing status, and they don't get pushed into the out of service because you're never held to, if a well's in a certain status for a certain amount of time, you have to make a decision. I also think that there has to be some parity with what we're doing with options 1 and options 2. And so I was thinking that along the lines of a 25% cap on their in excess of low producing, and then anything above that, in addition to the $40 million comprehensive bond, would have to have single well financial assurance. Even with that proposal, I think that an operator with more than 3,000 wells is probably getting a good deal with this proposal.
Commissioner Najapa.
Thank you, Mr. Chair, and thanks to all for the discussion. I think I'm a little more in line with what Commissioner McGowan just mentioned, a greater amount and some sort of inclusion of single well financial assurance on the low producing wells. I also am not entirely comfortable with the way that option 6 is written in terms of the out of service wells. There's sort of the asset retirement planning section that discusses, the plans for the retirement of their operations, but there's not like a specific designation of out of service wells required as we have in other options. And this is kind of a separate thing, but I think rather than just an inactive well list, and this is, for me, it would apply to all of the different options. And I'm sorry, I didn't think to bring this forward when we were talking about some of the other options, but I think it should be more of a plan that really specifies how long the well is intended to be out, to be inactive, and when it will be returned to service. So that we can, upon annual review, kind of follow back up on what's happening with those inactive wells and whether or not they're being continued. So that said, I think with option 6, I would like to see a greater amount. I heard from certain stakeholders over the weekend, some of those who proposed this idea that they were comfortable with 40 million. And I like the suggestion from Commissioner McGowan of capping that up to 25% of their, sorry, and I wanted to get clarification from Commissioner McGowan if you were talking about inactive versus low producing, but then single well financial assurance on the remainder on those. So
I was thinking low producing so that it's on parity with options 1 and 2.
Okay, yeah, and that's kind of where I was landing as well with this comprehensive bond idea. That said, I also think this could potentially be folded into option 1 as a cap on option 1. I'm kind of ambivalent. I'm kind of agnostic, I guess, on whether it should be a separate option as a comprehensive bond or whether it should fall into option 1 as a cap overall. The reason I like it within option 1 as a cap overall is that then all the option 1 requirements, as I was just kind of mentioning, like the inactive wells, the out of service and plugging list, et cetera, would be required, and the low producing wells. So very not definitive, but I'm more along the lines with Commissioner McGowan on this one.
Commissioner Gonzalez.
Thank you, Chair. So I like the idea of a $40 million comprehensive bond and some sort of trigger to incentivize or to disincentivize, just say, an operator from keeping an unlimited portfolio of inactive wells. I have a little bit of trouble when I think about the low producing wells as the threshold here, because production on wells could fluctuate, right? And the idea of a comp bond is kind of a longer time frame between reviews. It's more of a relief of administrative burden. And so I think that the ties to low producing wells take some of the efficacy out of the comp bond in general, because you're constantly evaluating, okay, where do my wells fall in and out of? Are they low producing? Are they not? Is it low producing for half the year? Is it low producing this year? Every year you're doing that evaluation again to determine whether or not your comp bond should stay, or if it doesn't stay, then alternatively, whether or not you need to submit as an amended financial assurance plan to put you in some other option. So I really think that the intent of the comp bond kind of gets lost when we tie it to low producing wells. And that gives me trouble just in general, because I do think that there should be some consistency with the way we apply these rules when we think about them. And so, when my first thought was, well, we want low producing well in the blanket bonds, maybe low producing well here. But as I think about the administration of that quantity of low producing wells, I have a little more of a hard time with that. So I would support 40 million, 25% inactive as the trigger. I'd make it available to an otherwise blanket bonding, meaning option 1 or option 2 operator. But just on kind of the proposal as it stands, I think that's my position on it.
Commissioner Gonzalez, can I ask a question?
Of course.
Did you say 25% on inactive? And is your rationale there is you know kind of what the inactives are as compared to the low producers that come and go?
Yeah, exactly. The low, because production levels change, right? Your well's either inactive or it's not. Your well may be low producing, 1 year and not low producing the next year and low producing the following year. And just, there's just a little more fluctuation with it. So that's why I like the inactive. Now I want to address something that Commissioner Nanjapa had proposed in regards to wanting to know more or reporting on the inactive well status. And I'm not quite sure how that would differ from the reporting required under Rule 434B, which also requires an annual review of progress on inactive wells. So I'm not quite sure if that addresses that concern and it's already in the rules and kind of a clear consolidated place, or if we would need additional requirements that mirror that under this rule. So that's kind of more of a follow-up question.
Okay. Thank you, commissioners, for that. Commissioner Messner?
Thank you, Mr. Chair. Appreciate the thoughts from the different commissioners. So I've been kicking this one around for a couple of days now, and more than a couple of days for the comprehensive bond, but this idea that I think Commissioner McGowan has suggested. So I think a couple of things, and this goes a little bit to what Commissioner Gonzalez is indicating, but what I continue to hear from operators is the reason that there needs to be a comprehensive bond is for administrative ease. But the more proposals that come forward, what seems to be the reason for comprehensive bonds is for a discount or a cap on the amount of exposure that they have or liability that they have. And so to me, those are two very different things. And so I've suggested multiple times that option 5 is a realistic utilization for developing comprehensive bonds on an operator by operator specific situation in order to create the right number based on the number of low producing wells, based on where they're at in their production levels and where they're at in their blanket bonding, that could be applied to develop a specific number for a comprehensive bond that they could be in place for 5 years as anticipated in the existing draft, which would create the administrative ease without the significant potential discount associated with the current utilization of the comprehensive bond. And so now if we're talking about certain operators getting the benefit of being a big operator and capping their overall level of exposure, then I'm going to be more in line with where Commissioner McGowan is at, and I would hold pretty strong. I mean, I would suggest 20% threshold because that's double what option 1 is versus a 25% threshold. I would mirror the language in option 1 and 2, which is low producing wells and not just inactive wells, as the criteria in there for their overall wells. But I would agree with the $40 million cap on bonding. So it's 40 million cap on bonding plus 20% exemption for low producing wells. Anything over and above that would would require single well financial assurance. That still incentivizes the utilization of the out of service well list, which is I think an incredibly important part of the discussion here. A flat comprehensive bond does not, I mean, it disincentivizes the utilization of the out of service well list. But if the reason truly is to limit the amount of liability associated with the big operators, then Commissioner McGowan's suggestion with some modifications would be where I'm going. If it truly is what I'm hearing from operators, the administrative ease, then I think individual tailored comprehensive bond amounts based on where they land in the option structure should be done through an option 5 bespoke approach that locks in place that number and administrative ease for 5 years. I hope I was clear there.
Commissioner McGowan.
Thank you, Mr. Chair, and I'm super appreciative of these thoughts and people's points. I guess the way for me to solve the toggling of wells in and out of low producing is to pick a point in time each year that the operator says, here's my well portfolio, here's how many are low producing, and you just pick a point in time and they have to update it each year at that point in time. And so you still have that streamlined simplification, low burden on administration. For me, the trade-off of the assurance that you will have a cap on your bond, along with some sort of cap on low producing wells, to Commissioner Mesner's point, is looking at the portfolios of these larger operators who I think are going to take advantage of this. They will have to put a significant number of wells onto the out of service list, which is a commitment to get them plugged and abandoned, which is what I think we're trying to achieve instead of them sitting in this inactive status or continual low producing. And there will be a commitment to get those P&A'd. And for me, I think that's a good policy for us to support and have some sort of teeth around it.
Commissioner Nanjapa.
Thank you, Mr. Chair. And yeah, just thanks to all for the discussion. I think there's some really good points that have been raised. I also, I think I appreciate the suggestion from Commissioner McGowan of, picking a point in time for the low producing wells. What I guess I don't understand, and maybe this is a question for Commissioner Gonzalez, is wouldn't that be the case for any of the other scenarios as well with low producing wells? And why is that not a concern? And I guess the other question, and I appreciate that your comment regarding 434, and I was just looking back over that again, and I maybe this is more of a question for Director Murphy, is it wasn't entirely clear to me how those two provisions, the comprehensive bond as currently written in the 211 draft, tied to both the out of service list and the inactive well list. And I was, it seemed as though there was less of a requirement with that. But maybe I misunderstood. And if that's not the case and all the 434 provisions apply, then that's good. But I share the concerns and the comments from Commissioner McGowan and Commissioner Messner that, that's a super important part of all of this. And I think we need to make sure that those are part of the equation, that they have to be designating wells as out of service or, inactive, and that we have a way to sort of track and ensure that those things are moving forward in the way that they have committed.
Commissioner Gonzalez.
Thank you, Chair, and thanks, Commissioner McGowan and Commissioner Nanjapa for the comments there. Exactly what you described with the annual review was exactly what I was anticipating as part of the problem. And the reason is, and this is how I envision it, how I envision the problem playing out if it does, manifest itself, is you have year one, you've got an operator with 5,000 wells and 1,000 of them are low producing, right? And so they go to the surety and they go to market and they get a comprehensive bond of $40 million, X amount. There's a lot of effort that goes into that, okay? Well, then a year later, they've got 1,005 low producing wells. So then in year two, they're saying, okay, well, I can't take my comprehensive bond anymore. So now they've got to go to the surety, release that comprehensive bond and have a different bond issued in a different amount that tracks to one of the options. If that goes back and forth on an annual basis or has the possibility to, I think it defeats the whole purpose of what a comprehensive bond is intended to be done, at least by the proponents of it. So that's kind of one point that I think is a challenge. Now, if we extrapolate it out to a point in time where your low producing wells are going to be static for 5 years, perhaps that's more palatable. I don't know. I haven't given that enough thought, but that's, potentially a possibility to add the certainty and the administrative relief that's being sought by writing a very big check that is backed by a surety's financial review. So that's kind of my comment on the annual review piece and why that still, in my mind, perpetuates or at least would be part of the problem should the problem manifest itself. And I want to be quite clear that we don't know if it will or won't, right? We're kind of speculating here, so I want to qualify that. With regard to, how is that different from the other options that have annual reviews? I think the whole point of option 6 is basically to not have those annual reviews and not have that same level of frequency with regard to financial plan applications, with regard to calculating the portfolio and understanding each of the portfolio components that would put you in a different option. Option 6 is just designed to be hey, this is going to be bigger than anything we're going to be doing anyways. Let's just write a check. Let's have it backed and reviewed and outsourced the financial review to the surety, and that's it. So I think when we start tagging on some of these other requirements, in my mind, it defeats the purpose of having an option 6. And I'd be curious if it would ever be used in the way that is currently being contemplated with kind of all these additional triggers to meet it. Because my understanding, it's not the amount that folks are trying to seek as a discount or as a lower amount than they would otherwise qualify for under a different option. My understanding, and I'll take this at the value of the way it's been presented, is that some operators have the money to put up a large bond, a larger bond than they think that they would otherwise need to put up under a different option, and that the value in that delta is achieved because they don't have to have all these reporting requirements on an annual basis. So that's kind of my 2 cents on why I think that inactive would be a better trigger, but also why I think we're challenging ourselves with adding more and more stage gates, more and more, I guess, qualifications to the access of an option 6.
Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Commissioner Gonzalez. So sorry, I'm gonna have to. I have a couple of questions, and then I'm trying to run through the rules here to remind myself what the current draft requires. So my first question would be, if the cap is 25% or whatever percent on inactive, I imagine that number changes also for an operator on some sort of regular basis, depending on what their P&A looks like, or if they've transferred wells or sold them, that's going to toggle and change also. So now I'm starting to think about the review of financial plans and what we're requiring. And I do remember us having the discussion about option 6 having a longer time frame between the, I guess, renewals. I still think it needs to be reviewed in some fashion, but not maybe change unless something significant has happened. And so is there a way to address your concern by extending the annual review of an option 6 financial plan unless something significant triggers a change? And I don't know what that looks like. And now I'm just making things maybe a little more difficult. But if we don't currently, and I can't find it right now. So, but what is the review requirement for an option 6 in the draft right now?
Director Murphy.
The review right now is it's a 5-year, it's a commission level approval, number 1, which I think might differ from what the chair laid out earlier, which is why there's a question on there for you in brackets. Staff's
And it's a 5-year.
Right. And then the commission reviews it every 5 years, unless the order would unless you would otherwise order it. And again, that's that commission level review. These plans are not exempted from staff's annual evaluation under 707 to make sure the surety is in place, to make sure you're still meeting the criteria, right? Like if you went private during the year, I think staff would flag that as a concern.
Or if you haven't plugged any of your wells on your out of service list, or you haven't shown progress or whatever, those things would get flagged, I think. So the 5-year review for me takes care of changes in inactive and low producing, if that remains the way that it is. And I'm sorry that I couldn't remember that and find it. I have read the rules multiple times.
Can I ask a couple questions, Chair? So there are a couple of places on the slide where you see brackets. I've heard people talk about the idea of caps and thresholds somewhat interchangeably, and to me, they're very different concepts. To me, a cap on the number of inactives or the number of low producing means if you exceed it, you no longer qualify to be option 6. If there's a threshold, it means if you exceed it, you're bonding up to single well financial assurance if you go above it. Those are very different, and I want to make sure there's clarity about what the options are. As has been noted, option 1 and option 2 both have threshold requirements for now low producing wells at 5 and 10% in opposite order. And so to me, there's a really different policy decision that will need to be made based on the words that I've heard used today. I'm not entirely sure what the reference to out of service wells is, which is why it's kind of a hanging sentence or hanging reference to out of service wells there. I've already flagged the question about commissioner director review. And then as I read the rules, there also is the same kind of robust requirements for reporting out the different statuses of the wells as part of your asset retirement plan, identifying specifically what your inactive well, when it'll be returned to production, and why it shut in the last sentence of the inactive well, the asset retirement language. And so I just want to make sure we're kind of all together. And if anybody wants me to pull up the language about what financial assurance plan requirements are for option 6, I'm more than happy to do so. I actually have it up. Sorry, lots of questions, but.
Okay, I've seen everybody's hand except for Commissioner McGowan, so I really don't know where to go. Oh, nope, now I've got hers too. Let's go with Commissioner Najapa.
Thank you, Mr. Chair. I guess I would like to just get some clarity and apologies. I know I asked like 8 questions at once sitting the last time I had the floor, but what I was trying to find out is, so Commissioner Gonzalez raised the point about 434B, I think, or at least the requirements there in terms of what gets reported for inactive and out of service wells. It was not clear to me how that ties to option 6 in terms of the plan that an operator that selects that option would make. And so I wanted to better understand, or just make sure that I was clear on it. It does talk about the asset retirement planning, but it is, if I remember correctly, there's a couple of different pieces that differ from some of our other option requirements. So that's one thing I just wanted to maybe just get some clarity from you.
What was that for me?
Gonzalez?
Yeah, so a couple things. So I was referring to 434C. I think that's the appropriate subpart to be looking at here. And really, that requires the initial, when you have an inactive well, you got to fill out the Form B, Form 5B, as I understand it, or this is the process as I understand it from reading the rules. So you fill out that Form B, Form 5B, and basically on that 5B, it's why the well is inactive. And then basically the financial assurance plan. I'm trying to find the right spots here, but it's my understanding that 5B, and maybe I'm wrong here. I need to take a look at this to understand what the frequency with updating that is. So I'm going to hold my response on that, Commissioner Nanjapa, until I get a chance to reread through that. I was kind of thinking out loud there about the requirements under 434B, but it's 434C that I think I'm really thinking about. So now it's right in front of me. I guess, Director, is there is there anywhere else in the rules that I'm missing or that I may be thinking about where reporting on inactive wells has a frequency that they have to be updated, or the operators have to update that before us? And what is that?
Thank you for the question, Commissioner. I'm going to roll up a little bit to the 434 B language for temporary abandonment, which we've talked about a lot. And with temporary abandonment, we have a notice when a well is temporarily abandoned, and through a Form 4, and then if the well remains temporarily abandoned for 6 months, we receive another Form 4 explaining what is going on. So the first Form 4 requirement is for 434B1. In 434B3B explains why there's a request for an extension of time, the reason for the request, and the plans for future operations. So that's specific to the temporarily abandoned wells. At a year from being temporarily abandoned, the 434C kicks in, right? And that is where we do have the 5B that you referenced that doesn't have a lot of information requirements. And I think Commissioner Najapa, you were really intent on making sure we capture the information about an operator's exposure, for lack of a better word, on inactives, and where staff built that requirement in is into the information gathered as part of the financial assurance plan. And so that's why I'm gonna go back down to it so I don't misquote rule language, because my brain's fuzzy too. So if we get into 702, sorry, there's 702, A, B, C. The plan options are in B, and then in D are what the financial assurance plans are. And my recollection is that all of the options require production data to be reported so that staff can verify the production thresholds, a list of well statuses and designations, right? And so that's where we're going to capture how many wells are inactive or are low producing or are on the out of service list. Well plugging data, that's a little bit simpler. And then the inactive well list is a more robust list of the actual individual wells by API number, the reason for low or no production, and the planned date for return of production. And so that's built out as a separate subpart specifically. And I think that's carries forward through the different, that was option 1. Here's the same regulatory language in option 2. Option 3, again, 1 through 5, I think option 4, option 5, and then scrolling up to option 6, again, we have that kind of comprehensive information coming in annually, like with the financial assurance plan about these different pieces. And that seemed to be the best place to gather that information when staff was putting together the revisions based on your feedback from the 31st and the 1st, to be able to look at it. It is a snapshot in time, no matter what type of well status or designation we're talking about. It's always a snapshot, but at least giving a single point in time to compare year over year, to understand trends, to understand where things are going. What is not as robustly captured in this option 6, it's been a topic of conversation today, is the out of service progress and list, but I think that has its own independent reporting requirements that are being managed separately, but they do fit together in a way that's important. And now I've talked for a really long time again.
I think, Chair.
Go ahead.
Yeah, Director, I think that's a good summary, and I really appreciate that. I was confused, and I think I put the inactive well reporting requirements, and I mixed those up with the out of service and plugging list, which has those requirements once they're taking advantage of that, out of service relief. So that's my confusion. That's my confusion, Commissioner Najapa. So I apologize for that as well. But I'm glad we talked through and got to the right spot there. Yeah, I don't disagree with those. Requirements don't exist otherwise unless it is part of an option 1 through 4 reporting requirements, or it is part of the out of service list. So so I think that squares up at least what our thought processes were, where I was relying on different information. I'm not quite sure if that answers your question, and I don't really recall what your question was, so I'll give you an opportunity to repeat that and help me get back on track here.
Commissioner Najapa.
Thank you, Mr. Chair. Thank you, Commissioner Gonzalez. No, I think that was all helpful for me as well, because I thought those were sort of different and they are related. And I guess that brings me back to another. So I think Commissioner Gonzalez, you've answered the questions in terms of what you were looking at and what you were thinking. And now with Director Murphy's input, that has cleared a lot of stuff up for me. What I still have a question on is, and this kind of pertains to all of the other options, but was there a reason that we didn't say specifically, like Form 5B and or 6, whatever it is, 6A? I'm sorry, I'm getting them all confused. For the forms that are required for the inactive wells and the out of service wells, versus what as I interpret here, this is just a simple list or a chart of like, the API number, the status, the reason or whatever, which is different from the forms and the details that are required there. And I guess the other question is what you showed in 434 is like the progression from temporarily abandoned into inactive. But in this case, when we're asking for their inactive well list, are we assuming that they've already submitted their forms on the inactives? So I'll start there.
Yes, so there are a couple of different processes we're trying to manage with the different rule provisions. And in the 434 space, in my mind, it's really about making sure the well is correctly represented in our system, right? And correctly designated. And that's an individual well by well component. Here, when we're talking about the plan itself, and there's a comprehensive list of all of the operators' wells, it lets us look more globally instead of pulling individual well by well data to ascertain why is something shut in, when is it planned to be returned to production. It's a nightmare for me to think about pulling 2,000 of those to be able to look at during a financial assurance review. It's easy if you have 10 wells, right? So that to me is we're trying to achieve really different functions. With 434, again, it's about making sure that the well status is correctly represented in our system for the public, for our inspectors, and for the well file itself. Whereas this plan is to look more globally across the operator's assets and plans, and are they achieving what they've said? And if not, why not? And can we have that conversation at a more macro level? So that's why we've broken them apart in this way. I think there's any number of ways to accomplish these goals. And my idea is, yes, that a well would either have been designated before as inactive or very closely to submitting the financial assurance plan to be on the submitted as part of an inactive well list in the financial assurance plan.
Follow up, Commissioner Nanjapa.
Thank you, Mr. Chair. Yeah, thank you so much, Director Murphy. That is helpful. And that makes a lot of sense, from the perspective that you were just describing. I guess, yeah, so if and I'm sorry if I'm not sure I'm still totally clear. I guess we were saying that this is option 6 is a 5-year review, but would there still be an annual look at some of this? And I'm sorry, could you clarify again what gets looked at on an annual basis?
Yes, and I'm gonna close your eyes, everybody. I'm gonna scroll down to 707 so you don't get car sick while I'm moving through it. Okay, so when we move to 707, this is really the comprehensive rule around how staff and the commissioner are reviewing any financial assurance plan. The director's annual review for the 5 subparts identified applies to every single financial assurance plan option. There is not an exception for option 6. And I think that is appropriate because this is the kind of gut check of, does somebody still qualify, right? Like, are you still meeting your production threshold if you're talking 1 through 4? Are you still a publicly traded company right now if you're talking option 6, for example? And is your surety still in place? That's occurring no matter what. There is also the opportunity for director to take a discretionary review, right? Like if I saw that somebody had announced they were going private, even if it didn't fall within my annual review plan, I would probably take that up, right? Turning now to 707B, we have the commission's thresholds for review. So under B1, if an operator's commission approved financial insurance plan requires regularly scheduled commission review, the operator will file for it and obtain that. And so if we connect that then back to option 6, where we have a 5-year review cadence, presumably option 6 plans would be reviewed by the commission under that 6-year cadence. That said, under 707B2, the commission also has the authority to pull up and look at a financial assurance plan option, whether it's 1 through 6, at any point in time. So I hope that helps us. And I'm sorry, I know the rules are all scattered about. Like, I really wanted to find a giant spider web so that we could follow the different trails between the different pieces. But I didn't have enough graphic arts skills to do that.
No, thank you so much. That is super helpful. Thank you, Director Murphy. Okay, so I think that helps a lot with some of the sort of questions and concerns I had. I guess the last piece that's still not entirely clear to me, coming back to you, Commissioner Gonzalez, is the idea that if we were to include some sort of consideration of single well financial assurance for low producing wells in option 6, that these can change year to year, but why is that not a concern for you with the other options?
And thanks for that. So the reason it wasn't a concern for me with the other options is because of the amounts that you're talking about, and really the ability to kind of be in a very similar threshold or a very similar bonding regime, if you will. Option 1 and 2 is just difference in amounts, right? But really it's the same application of information. If you go from option 2 to option 3, really you're bonding up from what was a blanket bond amount to an equivalent amount of single well financial assurance. I think when you talk about the comp bond, we're talking about the idea, at least, is that the comp bond would be at a certain level that's higher, and you essentially have to quantify whatever the delta is in a downward direction. And I just think that kind of eliminates the purpose of an option 6. If you're looking on that, if you have to go through all that information anyways, right? And you're looking at that every year, then why wouldn't you just turn in all that information and go with option 1 and pay a lower amount if that's what it comes down to, right? And that's what we're hearing. It would likely be a lower amount. The comp bond would likely be a higher amount. So really, just going back to the whole intent of why we're even talking about this is we had, a group of stakeholders who were interested in the comp bond for the purpose of administrative ease. And the more burdens we put on this, the point of it goes away in my mind. So that's one reason. I know that's really not articulated as well as I would like it to be, but again, with these comp bonds, you're kind of, the idea is, at least how it's been presented, is you're kind of ignoring all the requirements of all the other ones. You're just saying, tell us what your production threshold is, and then pay us a big amount, and we'll see you again in 5 years. So that's one thing. In regards to the inactive versus low producing, this was an earlier question I didn't get a chance to answer, but I had it in my notes, is an operator is going to have a lot more control over whether or not a well is going to be inactive, or they're going to place it in inactive status, or they're going to cease production or shut it in or temporarily abandon it, versus whether or not that well over the course of a year is going to produce 2.5 BOE or 1.9 BOE. Right, there's a lot less control on that production when you're in that, kind of targeting that trigger threshold. So again, these are all little things that are kind of adding up that to me kind of demonstrate the reasoning and the desire for an option 6 comp bond. And so I'm just trying to provide that explanation, right? If this idea is getting traction, and if we're considering this, I think that I have some opinions which I've shared on the right way to do it. So that's kind of, I guess, in sum, that's a lot of little pieces that have added up to my philosophy that it should be a pretty straightforward approach to comp bonds.
Thank you, Commissioner Gonzalez. I would weigh in that I tend to agree with your line of thinking. And I also get back to sort of looking at the holistic approach of what we're doing with regard to financial assurances, and the subset of operators that, if we were to have a comprehensive bond, is small. It is not that subset that is, in my opinion, risky. And it's that subset that has been historically volitionally plugging and abandoning wells at a pretty good clip. And that's before you have any of the incentives that are set forth in the new plans. I also agree with Commissioner Gonzalez on the pivot to inactive wells for the reasons that you mentioned, Commissioner Gonzalez. That's a known controllable thing. I think that if anything, inactive wells are going to be going down because they're going to be plugged and abandoned on a year-by-year basis. But I also think that the operators who qualify for a comp bond likely will not try to redo it during that third and fourth and fifth year, because it's probably not worth the value that is generated from that. So those are my continued thoughts on the idea. Commissioner Messner had raised his hand.
Thank you, Mr. Chair. So I'm gonna like ask a couple of questions to both Chairman Robbins and Commissioner Gonzalez, because I'm trying to understand. I mean, I feel like there's problems here. I also think there's potential solutions, because I acknowledge I'm not opposed to comprehensive bonds. I acknowledge the administrative simplicity that can be created by a comprehensive bond. I think that as proposed in the current draft, it absolutely takes away the incentives for utilizing the out of service well list. And so I believe that strongly, because you're essentially saying that you're going to exempt the operator from having to do even single well financial assurance for inactives, which means that their comprehensive bond covers all of their single well financial assurance for inactives, for low producing, for transfers, for bonding. And so where is that incentive to utilize the out of service well list? And so I do struggle with that a little bit. I think there's a solution here. I think there's a possible resolution to this, but I think that's my problem with the flat one size fits all, particularly at the level that we're talking about here. Because even for a small to moderate size, mid-size operator that's in option 2, their single well financial assurance, even with utilizing the allowed exemption of 5% of their overall wells, is going to be pushing that $30 million with their single well financial assurance alone. So why are we asking that operator to get close to $30 million for their bonding amounts? And we're giving this discount to the bigger operators who have way more inactive wells, let alone low producing wells, than this middle size operator that's in option 2. And so I have some equity issues with that. So having said that, though, understanding that we're trying to come up with a way to create some administrative simplicity, I guess, what's the issue with asking the operator to come in front of the commission for a commission review for a comprehensive bond, submit their financial assurance plan that indicates this is how many low producing wells I have, this is how many inactive wells I have, this is what I plan on putting on the out of service list, this is what my blanket bonding amount would be, this is my overall number of wells, this is what I'm having allowed exemption for option 1, and say my bonding amount would be $33 million. If I was in option 1 and I applied all these things, I would like to have a $35 million comprehensive bond, and I would like to not have to address this for 5 years. That right sizes it to that particular operator. Another operator, depending on how they utilize the out of service wells. I mean, because again, now you're incentivizing the utilization of the out of service well list. And so this other operator over here says, I'm not going to put very many wells on the out of service list. And so their option 1 single well financial assurance amount is going to be quite a bit higher. They still would like the simplicity of the administrative simplicity of the comprehensive bond. They go through the option 5 route. It's determined that their overall liability is $73 million. They ask for a $75 million comprehensive bond. because they want the flexibility of not having everything on their out of service list, and they just want to bond up on that one amount, right? And so I think it accomplishes what I think you guys are saying is the most important thing. It locks it in for 5 years, utilizing a snapshot in time for their low producing wells and their inactive wells that carries over for 5 years. And I guess I'm confused as to how that doesn't solve the problem. So, I mean, it's a question.
Commissioner Gonzalez.
No, I think that's a super fair question. I think a lot of great points were made there, Commissioner Messner. When I think about that, because without saying it, what you're describing is, why does an operator just come and ask for a fixed amount through an option 5 and ask for a longer time frame to hold on to that plan? Well, what's to prevent every operator from coming in and saying, I'd really like an option 5 comp bond. I'd like it to be $10 million. I'd like it to be $15 million. I'd like it to be $2 million. Whatever it is, they're just rounding up and trying to get a longer runway to hold on to their financial assurance amounts. So again, I'm not advocating for us to go one way or another here, because I'm really kind of high centered on which way this falls. But that is one of the concerns I have, is that if we offer that comp bond as part of an option 5 and don't set a fixed amount as part of what that looks like, every operator, if I'm an operator, I'm going to say, hey, look, I ran these numbers. I'm going to give you an extra $2 million of financial assurance. We'll round up to the next multiple of 5 or whatever. But you're not going to hear from me for 5 years. I don't want to talk to you about my out of service. I don't want to talk to you about my inactives, whatever. Right. And then we'll see you in 5 years. Here's my money. I don't know that that's quite what I was thinking about in terms of how I would like comp bonds to shake out. I think that that's possibly a little too, too loose in terms of its application. And so that's why I thought, and again, I've been lukewarm on comp bonds this whole time. And the only thing that really kind of pushed me towards more favorability this time is a higher number, right? Coming to 40 million. I think that what makes the comp bond attractive to me is that it is a big number, and it's not just a custom number that operators are going to be pitching to us as a nice round number to stay off my back for a few more years. So that's really how I would distinguish thinking about option 6 and option 5, at least the way I'm thinking about it.
Follow up, Commissioner Messner.
No, I think that's a good point. I think that, I think that we certainly don't want every single operator to utilize it as a way to lock in their blanket bonding amount for 5 years. So I think it's a legitimate point. I think it can be resolved with has to be at least 30 million, or has to be at least 40 million or something like that in order to quantify that, right? But still has to go through an option 5 approach, and it's not just necessarily a fixed number. I'm still really uncomfortable with the fixed number not taking into consideration low producing wells like option 1 and like option 2 too. So like I said, if we want to look at it, I'm okay with the 40 million as a cap on the blanket bond, and then give them a 20% allowance for their overall wells to be low producing. And I think that still accomplishes limiting their liability, because between that 20% allowance for low producing wells and the utilization of the out of service list, which again, it encourages them to do that, it accomplishes again what we're trying to accomplish with the comprehensive bond. So I still think that a hybrid, a version of what Commissioner McGowan is suggesting is a realistic piece forward, because I do think that I do think that we're asking every operator in 1 and 2 to reconsider their blanket bond, or reconsider their bonding amount every year. So if they're getting a surety bond in 1 or 2, then they're having to make an adjustment on that every year based on their low producing wells. And so, they just are, even if it's at $5 million, they're still having to make an adjustment on it. And so that, that piece is inherent in those. And then if we're doing this other piece with the 40 million, maybe a compromise there is to allow them to have it fixed for 3 years. And that creates some administrative simplicity. So it's a snapshot in time for 3 years. But I'm uncomfortable giving an unlimited exemption to having to account for the number of low producing wells if we're requiring it in the other options.
Commissioner McGowan.
Thank you, Mr. Chair. And I agree with Commissioner Mesner. There has to be some kind of parity with what we're requiring option 1 and 2 operators to do. And I think if what's on the table here is too administratively burdensome, or the trade-off isn't enough so that they're going to go towards option 1 or 2, then the requirements for single well financial assurance are even more stringent for low producing wells. They're going to have to bond up, or they're going to have to put a significantly higher number of wells into the out of service list, which is also kind of what we're trying to encourage folks to do. So I guess I'm kind of struggling a little bit with the, if we're okay with a snapshot in time and the plan is good for an extended amount, I think that is a benefit for the operator that takes advantage of a comprehensive bond. These very large companies, when I'm kind of looking at their numbers, and I know they change over time, their low producing percentages are like half of their portfolio. It's significant.
Commissioner Najapa.
Thank you, Mr. Chair. Yeah, I also agree with Commissioner Messner on the points that have been raised, and I think it's important that we have some ability to address the low producing wells, and I go back and forth on the amount. I could see where maybe we could say, okay, 30 million, but then you also do have to do this low, deal with the low producing wells up to the excess amount beyond whether it's 20 or 25%. And then, that might end up equating to an overall surety bond of 40 million or something perhaps. But I do also think I'm somewhat uncomfortable with the 5-year time frame. I know that we have all these other provisions where we can pull it up at any time, but it seems like 3 years seems a little bit better, and kind of going along with what Commissioner McGowan said with sort of a snapshot in time. I'd be okay with that, but also for the reasons that Commissioner Gonzalez articulated. I mean, this is exactly the kind of thing why I wanted to have like really strong sideboards on option 5, because I think one solution, as Commissioner Messner suggested, was maybe a minimum if you want to request some sort of comprehensive bond. But I think that's the part that I am concerned about in general about option 5, that I think if we don't have some strong sideboards, there's going to be a whole bunch of alternative options that get put forward. So anyway.
Okay, so to summarize, I think we've got like 14 different versions of an Uber bond on the table. And I'm not sure that we have consensus around any at this point, with Commissioner Messner in sort of the approach of using option 5. And Commissioner McGowan, to summarize, you were at 40 million and 25% low producing, is that right? And then I started out at 30 million with no percentage. Commissioner Gonzalez was at 40 million and a percentage on inactives, is that right?
Correct.
And what was the percentage?
I'd be comfortable with 25%.
And then Commissioner Nanjapa artfully is balancing some of this, not with an actual proposal, but with a supposal. Suppose it's 30 million, it's a 3-year review, not a 5-year, and low producing at 25%, which could then sort of probably equate to 40 million. Did I get that right, Commissioner Nanjapa?
Yes, that's right.
other options out there for consideration, Director Murphy?
Thanks, Chair. I'm still unclear about the percentages and whether they're a cap or a threshold. And I know nobody else is as keyed into this as I am, but to me, those are really different concepts.
Commissioner Gonzalez?
Yeah, I'll do cap on my end. No more than 25% inactive to qualify for the comp bond. Or
Commissioner Messner?
So everything that I've ever said is going to be a threshold. So I've got no cap, right? And so whether that's in the option programs or whether that's in the in this particular proposal that I think Commissioner McGowan is suggesting, that would be a threshold, right? So it would be taking the same definition that's in option 1 and 2 and just changing it from 10 and 5% to 20% as a threshold in option 6, should this be considered. And so while I was at option 5, I actually agree with both Commissioner Nanjapa and Commissioner Gonzalez that that may have some, that, that may have some problems as far as my proposal there, because I don't want to open the floodgates on that one. And so I appreciate that. This is why we're talking through it. That's why deliberating is good. I didn't pick that up in the arguments that I was having with myself. And so, I'll support Commissioner McGowan in her proposal with the 40 million, the 25% threshold. I love 20% over 25% because it's logical for me to go from 10% in option 1 to 20% in this particular option, because we doubled it from option 2 to option 1. And then, so anyway, that just makes more sense to me, but I'm not going to fight over the 5% piece there. But I think what Commissioner McGowan is suggesting makes a lot of sense. It captures everything. It encourages the utilization of the out of service list, and creates some administrative simplicity that I think is desired by operators for this particular option. I'll suggest incorporating Commissioner Nanjapa's 3-year timeframe with it.
Commissioner Nanjapa?
I'll provide a little bit more certainty in my response, in that I like where this is going with the current suggestions, and I'm comfortable with this. I just wanted to quickly make sure that I was understanding that Commissioner Gonzalez, when you're saying a cap, you're saying that, I think Director Murphy is just articulating this now. So if you have more than 25 inactives, 25% of your total well count as inactives, you can't qualify for the comprehensive bond. Is that correct? Yeah, no, I want to think about that a little bit more. I almost think that is, well, okay. No, I will just stay where I am at this moment, and I think that 40 million, which will be inclusive of up to 25% of the low producing wells, and anything above that is single well financial assurance. And 3 years.
Commissioner Messner?
And I'm just remembering that, I mean, I had initially mentioned, and I think Commissioner McGowan mentioned this, but maybe I was wrong, that the qualifier for this is still a production threshold, which you have to at least be 60 BOE to qualify for the comprehensive bond. I think you said that, Commissioner McGowan, but I'm just confirming because I didn't see it in the notes. So
Yeah, I mean, I'm trying to figure out how some of the things we're asking of the option 1 operator, which is our highest tier and the one that we think is the most secure, some of those things that I think have to also apply to taking advantage of the comprehensive bond. So I think the 60 BOE has to be something that applies as well, or I don't know if some folks are going to be MCFE.
90.
90.
Commissioner Messner, can I have a follow-up question with you? So production threshold is something new, I think, and we've not been talking about that. And at least I don't think we have. And if we have, I apologize. But if they can otherwise qualify, what is the rationale from your perspective on production threshold?
It's a good question. I mean, I guess I was thinking of it because what we're saying, at least what I initially understood the argument around the comprehensive bond is that you've got these high producing operators that want the ability to have administrative simplicity. And so to me, a high producing operator has to at least be an option one operator. And so that's where the production threshold came into it. Now, understanding that if an operator is able to access a $40 million blanket bond, flat blanket bond, plus any additional excess surety, any excess single well financial assurance for low producing wells above 20% overall wells, I mean, arguably that would already put you in the high producing operator realm because those are pretty big numbers. And so, I don't know.
I guess I'm just trying
Yeah.
to think, we're trying to create a tool that has been requested that does not create additional risk, that is creating additional net positive. And I'm not sure if the production threshold is, I don't know whether it's doable overall, given that some of the larger operators have a lot of low producing wells. Do you have an answer?
Yeah, I mean, I would argue that's why it's important to access the out of service well list, right? So, I mean, once you take the out of service well list, whatever you've got on your out of service well list, and your 20% exemption that you've got for low producing wells as far as your overall wells, and then you apply it to this particular situation, that increases your production levels quite a bit. But again, having said that, I mean, if you're able to secure a $40 million bond and you're able to meet all the obligations of the other thing, maybe that's not important. So
I guess that, yeah, I guess that's kind of where I was coming down. Commissioner Nanjapa?
Thank you, Mr. Chair. Just a question. I know that the way it's written in the current draft also includes that it would be available to publicly traded companies. Are we all, I think there was some back and forth, when we talked about this before. I wasn't sure if everybody was still in agreement on that. I know we heard some stakeholders suggest that it shouldn't be limited to publicly traded companies.
Commissioner Messner?
I mean, I appreciate the arguments around publicly traded companies, but I don't know as it has to be limited to publicly traded companies. For me, as long as we keep it within that 3-year time frame.
Commissioner McGowan?
Yeah, I don't think I'm not necessarily wedded to it has to be a publicly traded company either. I think though, Commissioner Nanjapa's point was there's a lot of information available when a company is publicly traded, which allows us to kind of consider the comprehensive bond and the administrative reduction, whatever I'm looking for the words there. That being said, I don't want to preclude a privately owned operator that might be able to fit into this paradigm. So is there a surrogate? Sorry, and I know we're making things more complicated. But is there something that they could show to show us that they have the capability to fit into an option 6? And I'm really not trying to make things more complicated, but I do think shutting the door on a private company that might be able to fit into this option seems inequitable.
And I tend to agree. I mean, I had tossed out at some point earlier today, there is some filing requirements with the SEC that the publicly could turn to and show us. I think there's likely some form of audited financial statements for a private company that could, we could even have them have an independent review of it. If they're trying to get an Uber bond, they would, I think that's costly, but it would probably be worth their effort. And so that would cover both public and private. So I don't, as one commissioner, need there to be just a public option. And I could get behind all of this. I do not think we need a production threshold. I think if they can get the 40 million surety, then, they're there. And I don't know about the unintended consequences of this last add-on, bolt-on, as Ms. Gutierrez would say. Director Murphy?
Thanks, Chair. I think that there are some important components around transparency that come with being publicly traded. And as Commissioner McGowan restated Commissioner Nanjapa's initial reasoning for it, that's important to me when I think about the expertise of staff and the expertise of this commission when it comes to reviewing financials and reserve reports and all of these like magical terms that mean a lot in the banking industry that mean diddly squat to me. I think that we need to be thoughtful about that. And the other question that has come up to me through this discussion, and as I've heard multiple commissioners now say, if you can get a $40 million surety, that should be a good estimate or proxy that somebody else is also looking at your financial health. And that's true, but only if you limit option 6 to only being able to obtain sureties as drafted. Your direction from the 31st and the 1st was that any combination of financial assurance mechanisms could be built together to achieve the actual financial assurance amount. And so that I just want to flag that what I've heard you say isn't totally consistent with what I think the rules as drafted allow. And here I am adding more problems maybe, but I do want to think I want you to think about if you eliminate publicly traded, what is the stand-in for it? And is it something that requires expertise that either the commission doesn't have, or is that outside expertise that the operator would bring in to support their application as a third party? I think audited financials, which we put in option 5, staff's okay reviewing, or we wouldn't have included it. But there are other mechanisms out there.
And I think I could get comfortable behind your surety only approach. I don't think we'd really sort of thought about that as you've mentioned that I'd like to hear from Commissioner Gonzalez.
I've got a question kind of along those same lines with regards to public versus private and this idea that public companies have, these publicly available financial information. How is that financial information going to be applied to an option 6 determination? If someone meets all these other criteria, they're option 1 or 2, they are 25% low producing and they're paying above that. They have a $40 million financial instrument, whether that's letter of credit that is set aside, whether that's a cash bond with the commission as a beneficiary, or whether that's a surety bond. I fail to understand where in this review we're going to say, okay, I see you meet all this criteria, but subjectively, we don't like what your 10K says or other financial information for a company. I just don't, I'm failing to see that intersection.
Director Murphy?
Thank you, Chair. Commissioner Gonzalez, to me, it was not so much that do we like what's in your 10K, but it's the requirement that you have to file a 10K. That you as a company are accountable to external stakeholders in addition to us to be managing your company in a more transparent way. That's how I understood the advantages of it. And so it's a yes or no analysis, not a is your 10K sufficient or any other particular filing.
So I guess, one of the things I'm contemplating here is that if we think about a private company, and I've been thinking about this in a myriad of different ways and how private companies operate, but let's think about, a family run private company, right? And let's say that they have a ton of money, right? And they say, I've got $40 million. I'm going to go ahead and put that in a bank account that is specifically directed to support my financial assurance. The commission is a beneficiary. I thought the whole purpose of the comp bond was basically saying, if you can come up with this amount of money, that this amount of money is a adequate financial assurance for an operator in this state. And I guess that's why I'm struggling with any kind of limitations on the financial instrument used or on whether it's a private or public company. Like I understand that public companies have more transparent financial records. And that they have to file those publicly. I don't know that for me, that's influential in terms of why we would limit it to only them, because I'm still not making that connection to how that's actually applicable to the adequacy of the financial assurance that we're contemplating at a fixed amount under a comp bond. So my view is that, if we think this amount is adequate, the production threshold to me, I don't see necessary, and I don't see necessary to limiting the financial instrument or the public versus private categorization of operator.
Commissioner Messner.
Thank you, Mr. Chair. I think Commissioner Gonzalez brings up some good points. I want to make sure that everyone understands that, at least from my perspective, we're not talking about just $40 million. It's $40 million plus whatever the single well financial assurance would be in excess of 20% of overall wells. So it could be, depending on an operator's portfolio, $60 million, $42 million. I mean, it just depends on the situation. A surety bond to me only means that that operator has enough collateral to get the surety bond. So, I still kind of like the idea of them being a higher producing operator. I don't know as I'll die on my sword on this one, but to me, that's a good check and balance. If we're going to allow both private and publicly traded companies to be able to utilize it, it's not an unreasonable threshold because it's the same threshold for option one. But I think it's fair that there's a number of different, that operators should be able to have different mechanisms that they want to utilize if they want to do the comp bond option for simplicity. I still like the idea of the production threshold. Yeah, I'll leave it at that for right now.
Commissioner Najapa.
Thank you, Mr. Chair. This one, it's a little bit, it's messier than I was thinking it would be, but I think I could be comfortable with not limiting it to publicly traded if it was surety or cash or a combination thereof. I guess I don't know enough about letters of credit other than, when I've received similar things from my bank in terms of how much certainty it gives us, I guess. The thing I like about sureties from what we heard and what I read is that, while yes, it's kind of related to the collateral that's put up, it at least lets us know that the operator is good for that amount of money, and they are also reviewing it on a pretty frequent basis, at least annually, it sounded like. So I guess my general inclination would be to limit it to surety, but I think that I would be okay with surety or cash. But I'm open to hearing other arguments on other instruments.
Commissioner McGowan.
Thank you, Mr. Chair. So the surety, I think, is the most secure for the commission because the bond is in the commission's name. And so regardless of what happens, right, that's the commission knows that amount minimum comes to us. And if the 25% threshold is what is included in here, there's also then single well financial assurance for a percentage of low producing wells within this portfolio. And so I think that's financially, that seems pretty secure. And so going back to privately versus publicly, it seems to me, based on what we've heard from folks and what we've heard from the surety folks, that if you are able to get a surety bond at $40 million, there's some sort of efficacy or scrub that's been done, even if you're not a publicly traded company. So anyway, I guess I'm going back to, if a company can put up a surety bond for the 40 million plus their percentage of inactive, do we think that that's secure enough to open the door to a privately held company if they can do the same thing?
Did you mean inactive?
I meant low producing, sorry.
You're welcome.
And then I just want to throw out, I guess, I'm trying to decide what the heartburn is over requiring a production level, because if this was an operator that had all low producing wells, they've been option 3 and 4, and we would be requiring full single well financial assurance for all those wells. So at minimum, wouldn't we want a comprehensive bond producer to be producing at an option 2 or an option 1 or an option 2 level? And optimally, wouldn't we want it to be an option 1 level producer, which we're saying is the lowest risk? And this is where we're trading off, a comprehensive bond, less administrative work on their part, arguably potentially less oversight if there's only a 3 to 5 year renewal. And so I'm trying to figure out why we have heartburn over some sort of minimal production amount within this option here. And maybe it's not 60, maybe it's you have to be at least at the option 2 level, or option 1 or 2. But I'm trying to figure out why we have heartburn over that, because otherwise they would be an option 3 or 4, and we would be requiring single well financial assurance.
Well, Commissioner McGowan, I don't have certainty that the production threshold would qualify or not qualify the folks that might otherwise want to use this option, and it might fluctuate. And so from my perspective, if they can get the 40 million surety, that sort of is saying that they're good. And I don't know that there's a need for additional qualifying mechanisms. That's my simple sort of thought on it. Commissioner Messner?
I mean, maybe I suggest a path forward here, at least something to react to or to vote on. I mean, I think Commissioner McGowan has laid out a pretty logical proposal. I mean, everyone may not agree with it. I'm not suggesting that, but I mean, I'll try to flesh it out, Commissioner McGowan, and you tell me if I got it right. But even though I continue to say 20%, you continue to say 25%. So I'll capitulate, and it's 25%. So 40 million cap on the blanket bonding, 25% allowed threshold for low producing wells that would be included into that blanket bond. Otherwise, they would have single well financial assurance in addition to the 40 million. Are you okay with multiple?
Are you going to split a baby, Messner?
Well, I'm trying to decide if you're okay with multiple ways of approaching it, or whether you want surety bond only. I can't remember what you thought there.
I guess my thought, I'm trying to figure out, and I don't know if I'm going to fall my sword over it. I just feel like there should be a way for a privately owned company to take advantage of this if they meet the kind of same thresholds as a publicly traded company. But I also get what Commissioner Nanjapa and Director Murphy are saying, which is when you're publicly traded, there's kind of a different lens that has been applied to your company from a different perspective. So I'm just trying to put in a plug for the privately owned company that might be able to or want to enter option 6. But because finances are not my forte and I'm out of my sandbox, I don't know what that would look like to make everyone comfortable that a privately owned company might be able to use option 6. 5, 6.
Okay, so public or private, any surety mechanism, 3-year threshold, and commission review right? So not director review, not administrative review, but commission review. And then I guess the last question, and I'm a little unsure on this one, is a production threshold or not. I've heard both 60 BOE, 90 MCFE as the qualifier, or the operator either has to be tier 1 or tier 2. So I don't know what your thoughts on that, or Commissioner McGowan.
My original thoughts were, if you're using the comprehensive bond, that you might otherwise be a tier 1, but you don't want to go through all the work of figuring out the tier 1, and if your wells change and the annual review and et cetera. I mean, if these operators start plugging themselves into option 1 and option 2, what is their bond amount? So we haven't gotten to the Commissioner Gonzalez's thought of, should we cap options 1 and 2? At some point, everyone's going to start putting themselves into these various scenarios, and where do I fit, and what's my total amount, and is it easier for me to just do this or to do this? Like, what's the trade-off, the amount of work versus the amount of assurance that I'm going to have to put forward? And I guess my thought was, if you are producing less than a tier 1 operator or tier 2, do we want a comprehensive bond applied?
Okay, so understanding that,
It seems to me there should be some sort of production that you're producing at that's not at the same level that we're asking other operators to fully single financially assure all their wells over time. That does not seem fair to me.
So would it seem fair, as Commissioner Messner was supposing, as opposed to production threshold, just say you otherwise qualify, or you can't get this unless you're tier 1 or tier 2? Would that solve the riddle for us? Commissioner Nanjapa?
I just wanted to, our option 2 thresholds go from 15 BOE to 60, or 22 MCFE to 90. So I think if we're going to use a production threshold, it's got to be the option 1.
Mr. Chair, I would agree with that. The more I think about this, I think it's got to be an option 1 operator that's looking for administrative simplicity in this. And because that tier 2 is so variable, and to be honest, capping tier 2 at 40 million, there's operators that could potentially be in tier 2. And let's go back to the philosophy of the different options and why we have that. As you're going into option 2, you're not drilling as many new wells, and you're starting to utilize existing wells. And so your blanket bonding amount could be pushing up towards that $30-40 million alone, because the blanket bonding amounts are higher in tier 2, not even taking into consideration your single well financial assurance for low producing wells. And so I think this mechanism is really designed for that high producing operator that is looking for administrative simplicity.
Director Murphy, you've unmuted.
Thanks, Chair. I don't understand, Commissioner Messner, when you said any surety, what you meant. Did you mean only surety or cash or any mechanism? And I'm going to plug again from my perspective that if we're opening this public and private, it should be at least a surety and possibly a surety in cash.
I was saying to allow the different financial assurance mechanisms that are available to the other options that would be available to this option. I appreciate what you're saying, Director. I can be talked into cash or surety. I think letters of credit are pretty solid as well, but I don't know. I'll let others argue on that one, but when I said it, I meant all the other financial assurance mechanisms available to the other options.
I think so. I want to follow up with 2 pieces. One is that there's been some discussion about whether reviewing and approving. Actually, I assume, based on the inclusion of 3-year review by commission means that approval of the initial financial assurance plan under option 6 would also be a commission level decision. And so that buttons up some of my other concerns or questions about how it would work.
Commissioner Najapa?
I think I like where all of this is so far, and the only point that I feel fairly strongly about is that the mechanism should be surety or cash. Or combination.
And the only struggle that I have continues to be with the high production threshold. And I would throw out maybe we don't have to do tier 2 and go all the way down to 15. Maybe it's like a high tier 2 operator, like 40 as a compromise. I just get worried that what we've created is something that doesn't end up being an option. Commissioner Najapa, then Commissioner Gonzalez.
Thank you, Mr. Chair. I think I'm pretty, I think it makes most sense to me that it's an option 1 operator that's looking for some additional simplicity. Operators that want to qualify into this would be able to put more wells on the out of service list, or plug more wells and potentially could qualify into it, sometime down the line. But yeah, I don't feel that we need to make some additional concessions to accommodate more operators. I think you're in or you're out.
And I'm not actually trying to make concessions to accommodate more operators. I'm trying to accommodate the operators that have told me they wanted to use this and how they may not meet that production threshold. So I'm just being hyper honest with you. Commissioner Gonzalez, you had raised your hand.
No, nothing to add, Chair. I was going to make a comment on the option 2 threshold, but I had an error in my reading, so nothing there. I'm not quite sure where I'm landing on this. I mean, to me, I think that this seems like we're going through a lot of brain damage for 2, maybe 3 operators using this rule in a way that seems very far from what was originally contemplated. That being said, I'm comfortable with it as being proposed with this, fleshed out regime here. If they think the threshold, or Chair, if you think the threshold is somewhere around 40 that needs to be there for this rule to be effective, then perhaps that's the way to go. I have a hard time with again, we've talked about using low producing wells to stay consistent with our blanket bonding. If we go outside of tiers, we're now no longer consistent with clear, bright lines with options 1 and 2. So I'm just struggling with that. I think as it's proposed, I could be on board with options 1 and 2. I could be on board with a high option 2 producer. So I think that I'm just kind of falling in line with the way this is fleshing out, because I think it's very far removed from, I guess, the way I had contemplated this rule working.
Commissioner Najapa.
Thank you, Mr. Chair. I have a proposal. What if we went with publicly traded or 60 BOE, 90 MCFE?
Commissioner Messmer.
I think that works for what you're looking for, Commissioner or Chairman Robbins. I mean, for the sake of compromise, I'm also okay going down to a high tier 2 operator just to move forward here on this. But I actually like Commissioner Najapa's suggestion. I think that accomplishes what you want, Chairman Robbins.
I agree. And I thank Commissioner Najapa for yet again being the most creative of the commissioners today. Commissioner McGowan.
I apologize. I'm not sure I understand what Commissioner Najapa has put forward, how this would work. Sorry. Could you explain?
I was just saying that it would be any publicly traded company or a private company with at least 60 BOE and 90 MCFE production threshold. And so that gives us a little bit of insight into their financials if they're a publicly traded company. And if they're not, then they're at least at the option 1 level and they have to be able to qualify for the 40 million amount plus the single well financial assurance amounts.
Commissioner McGowan, did you have follow-up with that additional explanation? If not, Commissioner Messner's ready to go.
So I guess I'm still, and maybe this doesn't actually exist, so I need to stop worrying about it, but I don't want someone who's publicly traded to have a comprehensive bond and get these kind of advantages that aren't provided to an option 3 or 4 operator. And so I kind of am interested in Commissioner Robinson's proposal of the 40 BOE across the board for all of them who take advantage of the comprehensive. And it's okay, like we vote. So if I'm in the minority, I get it.
Commissioner Messner.
Thank you, Mr. Chair. I appreciate that, Commissioner McGowan. I mean, I could get on board with that. I'm going to split the baby one more time, though. And I mean, what about 40 for public and 60 for private?
Commissioner Gonzalez is enjoying this.
The simplicity that was this approach is moving away, but I appreciate the commissioners bouncing around on this and coming up with ideas. I'm comfortable with that final baby split, Commissioner Messner. I'm also comfortable with 40 BOE or with Commissioner Nanjapa's proposal of publicly or 60 and 90. Commissioner Gonzalez, do you want to pick one?
No, I don't. I'm comfortable with all the options that have been proposed. If we want to be more inclusive, obviously the lower production threshold is there. If we want to be more exclusive to public and have that 40 BOE as the baseline, I think that's a fair amount. I think it's a fair amount to have a higher level for private companies, given the concern with financial risk and unknowns there that we've chatted about. So I'll let someone else put it for a vote, and I'll vote my voice.
Chair, can I ask a question?
Yes, please.
We put BOE on the table. I roughly did math, and 40 BOEs slightly bigger than half between 60 and 15 BOE, but we didn't include a similar gas threshold or MCFE threshold. My rough math, I think I suggested 60. But I would just note that if we're going to continue with the theme of making sure that we treat gas operators through an independent analysis of production, we also need an MCFE threshold for 2 of them.
Do you have a sense of what a comparable MCFE threshold would be, Director Murphy?
I should do my math again, but I thought 60 kind of got close. But let me try to do that again.
Commissioner Messner?
Maybe I make the suggestion to go with the 60 for private, which is 90 MCF in option one, and then a 40, and then I'll do the math again as well, but it's approximately 1.5 MCF to 1 BOE in that, if you do the 60 to the 90. But at least maybe that's a way to get forward or have something to vote on right now. I think anyone here can reserve the right to change their mind or make a modification tomorrow as we can continue through this.
And Chair, I think my math is pretty close. I just took 2/3. 40 is 2/3 of 60. 60 is 2/3 of 90. For anybody who's curious how I got there.
Having to do math on the fly. Commissioner McGowan?
I appreciate everyone's work on this, and I'm okay with this moving forward.
Which is this? Sorry.
I was gonna say, which this is
What
this?
Commissioner Mesner put down, what Commissioner Mesner suggested, sorry.
Which was what?
Commissioner
Because I was
Messner.
doing math. I'm sorry.
Commissioner Messner, which of these options were you supposing?
You want me to say all of it? Or just?
No, just the under the options there, the 1, 2, or 3rd bullet.
You split the babies again.
So just 60 BOE, 90 MCF for private, and 40 BOE and 60 MCFE for
Public.
public. Yeah.
Okay.
Yeah.
All right. And then otherwise, it's the points that are on this slide. Director Murphy.
The financial assurance mechanism is my last piece. I still have brackets on that. So I think if we stick with Commissioner Mesner's approach, it's any financial assurance mechanism.
I can be argued out of that out of that place, but that was my supposal there. You guys, if you want to do sureties and cash, which I think is really what's going to be utilized here, I mean, I'm fine with that.
Since the commission is going to be reviewing this, I would be comfortable with anything, and then it's up to us and our discretion as to whether we think that's appropriate or not. That's my thought. Commissioner Najapa?
Just a question out of curiosity. Do we know if there are publicly traded companies that are below the 40 BOE threshold, 60 MCFE?
I
We
would
do.
anticipate there are.
Okay. All right.
And then one final little caveat, Director Murphy, I think when you were talking about the 700 rules, we're looking at this every 3 years, but you're still looking at it in some fashion every year, right?
Yes.
Okay. 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 Non-binding straw poll. Is everyone comfortable with this by showing of thumbs? Okay, we've been going at it for an hour and 40 minutes. Why don't we take 10 minutes and come back at 2:15? Commissioners are all here. Commissioner Messner is here, but without video, which is perfectly fine. Director Murphy, where are we?
So great news. We're through with option 6. I
Well,
don't
we're
know
not
that
binding through.
Right, we're not- well,
tentatively through.
we've made great strides in getting very close to a decision perhaps on option 6. Is that okay?
That's okay.
Okay. I think we've been through options 1 and 2 for the most part, except we still need to talk about whether there's a cap on option 1 and 2. Any feedback or discussion on options 3 and 4, and then again, perhaps close to a decision on 5, I think are remaining in this bucket 2 of 12 discussion items today. So on the slide that's on the screen, we've talked about in the last bullet point, option 1/option 2, we've talked about a couple of different concepts and have not moved forward with those. There's still a question on the table about whether to talk about a cap on financial assurance amounts for option 1 and option 2 operators. I think that's been put on the table, and then we moved into option 6.
So do we want to go back to the cap on 1 and 2 concept and try to see if we've got 3 votes there going one way or another?
Yes.
Commissioner Messner?
Thanks. I can kick this one off. I mean, I think because we've developed an option 6 and it's a pretty good option for operators. I'm not comfortable with the cap, particularly on single well financial assurance for low producing wells. Argumentatively, I mean, I could probably stomach a cap. I think which was suggested by Western Slope COGA of 30 million for the blanket bonding for tier 1. Now I can't remember. Shoot, I'll have to go back and look at it. I can't remember if it was tier 1 and tier 2 or just tier 1 and there was a different amount for tier 2, but I'm not sure there's really a need there, to be honest with you, for a cap. I don't know if any operator actually hits that with the existing numbers within tier 1 or 2, perhaps tier 2. I don't know. But I think there's a pretty good option now in option 6.
Others wanting to weigh in?
Chair?
Commissioner Gonzalez?
Yep. So this was, this is my idea and just kind of something to throw out as a way to create a backstop, similarly to what we did with option 6. I don't necessarily view them as substitutes for each other. I see option 1 as more of kind of a backdoor avenue to accomplish the same kind of, I guess, high-end backstop protection on this number getting too high for both options 1 and 2. Now, I feel better about option 6, including some of option 2 with kind of the way we drew that threshold. But the idea here is that, you're going to have operators who can't come up with $40 million, period, but maybe in a position where their blanket bonds, reach a level for where it may be appropriate to have a cap. So really just the general idea of a cap is really what I'm throwing out, and I wanted to support it with numbers. If there's not support for a cap, then we don't need to talk about numbers. If there is support for a cap, then we can talk about numbers. But I think I've laid out, really why, generally I think it's a good idea to have a backstop so that if there are instances where the financial assurance grows to amounts that are beyond what we're contemplating or that are beyond sustainable for operators in this state, I think it's appropriate to consider having a backstop at this point. So that's pretty much my pitch on it. Again, it's not something I'm married to, and I'm just looking to socialize that, here with my fellow commissioners and just see if there's any interest in this route. And if there is, then we can talk about numbers.
Commissioner McGowan?
Thank you, Mr. Chair. And I think for a lot of this hearing, I've been thinking about reasonable and necessary language in our act, and kind of we're wanting to reduce risk. We want to make sure that operators are appropriately resourced to plan for the retirement of their little well employees. And I think that I would be open to the idea of a cap, because I think some of these numbers can get ridiculously large. I also recognize that the structure is set up so that you can lower the amount that you need to bond to if you start plugging and addressing your lowest producing wells. And so I don't want to set a cap so that that incentive it isn't there for the operator. And so I think I'm open to the conversation. I kind of also want to discuss, is there going to be some sort of a consideration when there's a cap, or is it just an automatic cap? And what the reasonable amount would be. So I get what you're saying, and I've been thinking about it, but I don't know how you come up with a magical number and how you decide.
Commissioner Nanjapa?
Thank you, Mr. Chair. Yeah, I've been thinking about this concept a lot as well. I'm open to a cap on the blanket of 30 million, and part of my reasoning for that is the numbers, that have been thrown out previously with respect to the comprehensive bond, with the reasoning of California and Alaska. But I've also heard discussion about a cap on the low producing wells for the single well financial assurance. And I can't quite figure out, or I can't get my brain around what scenario there would be that we would need a really large cap on that. I could see a scenario, even with the numbers that I was proposing with my chart earlier, that you could get above 30 million with your blanket, and so then capping it at 30 gives a little bit of a break if it's otherwise going to be 35, 37, whatever. But yeah, I think the part about the low producing wells, I'm not so sure about. I'm feeling less good about that, I guess.
Thank you, Commissioner Nanjapa. I tend to agree with you on that latter point. And I think I tend to land on the idea that at this point, I don't know that we need cap on blanket bond either. I'm appreciative of the work that we just did. And I think that instead of doing that now, let's play out our rulemaking for a period of time, see how things are working or not working. And, we can revisit. This does not have to be static. And we are inventing a new paradigm for the state of Colorado and probably for the nation in terms of one way of one state is doing it. So I think that's where I am. I could probably be persuaded otherwise, but that's my marker. Commissioner Messner?
I think that was well said, Chairman Robbins. I'm going to be on the camp of what you just said.
Commissioner Nanjapa?
Yeah, I appreciate that that notion, and I support that as well.
Commissioner Gonzalez?
Thank you, Chair. Yeah, no, I appreciate that feedback. Again, it's something that I'm just trying to wrestle with. We're dealing with a lot of unknowns here. That's why I was proposed. I can give you some info on kind of my numbers. That 15 million I came up with, thinking at a tier 1 operator at $1,500 a well, 5,000 wells for their blanket, 7.5 million. 15's double that. Just kind of contemplates, exponential growth, on that cap. So I was looking for something that was really exceptionally high, the way I was envisioning it, just to provide a backstop, because we don't know where this is going to go in the future, and it's a concern of mine. The reason why the excess low producing wells is included in there is because I think that's where the majority more open-ended aspect of financial assurance could start to really snowball into large numbers. But again, this is, if there's not support for it, I I've made my proposal, and like all of us working through our creative ideas and trying to offer up optionality. That's what I'm trying to do here. So I'm fine if I'm outvoted on it. It is just my idea.
Commissioner McGowan?
Thank you, Mr. Chair. And I think I am trying to figure out the discussion we just had about the comprehensive bond and this cap that they have on their blanket, and then, the in excess and a tier 1 operator being in that highest level, but not having a cap. And I don't know, I just don't know how to fix it quite, but I'm intrigued by Commissioner Nanjapa's suggestion of a cap for the blanket, but the in excess, we want to make sure those start getting single well financially assured, because those are the riskiest, for example. Oh, I had another thought and now it's gone. Sorry, the thought is gone.
That's okay. I think you angled in on the good thought from Commissioner Nanjapa. Commissioner Messner?
Commissioner McGowan, I mean, I appreciate that. I mean, I think that's what we just did. I think that's what option 6 is a cap. It's a $40 million cap on blanket bonds, and then an additional benefit on low producing well allowance at 25%. And so, and not only is it available to tier 1 operators, but some percentage of tier 2 operators. And so to me, those are the operators that we're going to utilize, that may potentially in the future bump up against a cap. And so we created a cap. It was 40 million.
So sorry.
Go ahead, Commissioner McGowan. Why don't you follow up, and then we'll hear from Commissioner Gonzalez.
So Commissioner Messner, would you envision a scenario where an operator who's thinking, this amount of blanket bonding is becoming unreasonable or unnecessary, being able to go through the bespoke option to explain, and we haven't gotten there yet, so I don't know what that's going to look like, but is there going to be an opportunity to have a conversation then if you're thinking, if you can show the commission, and I don't know what that would look like, but that you should be capped, or Commissioner Gonzalez has something to say too.
Well, I don't know. Is that a question to me or?
I had thoughts along the same line as Commissioner McGowan as I was kind of working through this as kind of a backup option, is if we want to add to our list of things in option 5 for unique circumstances and enumerate ability to pay as one of them, then perhaps that serves as essentially a bespoke cap for an operator otherwise falling into a different option, right? We've had that consideration for enforcement matters. Perhaps that's an appropriate, specifically enumerated item to be included in our list for considerations under an option 5 that could perhaps bridge the gap off of picking a number and really leveraging it towards an operator's unique circumstances in that regard.
Commissioner Messner or Commissioner McGowan?
Well, I mean, I got a couple things on this. I mean, one, I think I still agree with Chairman Robbins. I mean, we may be trying to create a cap for a situation that is not happening right now, right? And so, I mean, at any time we can petition for a rulemaking, we can modify these based on what we're seeing a few years down the road. Like you said, Commissioner Gonzalez, as you apply tier 1 blanket bonding amounts right now, it would be hard pressed for an operator to even hit $15 million. Which to me means that we probably have the numbers in those blanket bonding metrics about right. Even in tier 2, it would be relatively hard pressed to get into the $30 million range. So we may be trying to come up with a solution for a problem that doesn't exist right now. And to me, the incentive, the mechanism to to create a cap for single well financial assurance for low producing wells is one that we've already created as well. That's the out of service list. I mean, that is under the control of the operator. They have the ability to utilize that in order to minimize their overall liability associated with low producing wells. There's timelines associated with that. I think there's generous timelines for significant numbers of wells on that out of service list. It's an annual process where they can add wells to that out of service list to maintain their liability in there. So yeah, I just don't know. I still think at this point, we probably don't need to do anything on this topic.
Thanks, Chair. Yeah, I just want to respond to a couple things because I agree that we can probably put this to bed pretty soon. But, you know, I do want to acknowledge that a lot of the rules we're drafting are based on scenarios that have not yet happened and that we are contemplating based on potential risk. And what I'm offering is potential risk going the other way, that is risk against an operator's really financial wherewithal if they're over bonded. So that's one point. The other point is that when I think about the out of service list and it being a backstop or a way to mitigate the amount that one would be paying for low producing wells, I think that argument holds true when they were inactive wells. I think for low producing wells, that argument doesn't hold as true because an operator is not going to put an economic low producing well on an out of service list when that's their entire portfolio, as some operators have, or if it's a good part of their portfolio, as occurs with many operators in this state. It's just those 2 points I wanted to clarify. But, you know, that's kind of where we're at in this discussion and happy to put it to bed. I do think that an ability to pay line item would be something I would suggest for SBP language for option 5.
Commissioner Najaffa?
Thank you, Mr. Chair. I generally agree, you know, with where we're going and to, you know, not include the caps at this point. But to Commissioner Gonzalez's point, I think ability to pay is a reasonable option, though I don't know that we should cap, but rather extend a time frame for providing that amount. You know, so in other words, if they can't pay, if they're in option 1 or option 2 where it needs to be, you know, pretty much upfront, you know, maybe they get a little bit of an extension or they have to put a certain amount down or something like that. But I think I guess I don't support a cap due to ability to pay. That's my opinion.
Commissioner Messner?
And thank you, Mr. Chair. I just a point, and I'm not trying to be argumentative, Commissioner Gonzalez, but I mean, I think you've said it a couple of times that if an operator has a portfolio of all low producing wells or a significant number of low producing wells, well, those are actually contemplated in option 3 and 4, right? And so those are addressed with single well financial assurance over the anticipated life of the well. I mean, there's a presumed 20-year and 10-year, but anticipated life of the well. And so I think those are captured realistically along the timeline for those operators that, and I think in a very creative way, thanks to some of the stakeholders that made a lot of good suggestions on those. And so I guess I'm not totally understanding that argument.
Commissioner Gonzalez?
Yeah, I'll just respond to Commissioner Messner because it sounded like there may have been a question mark at the end of his statement. But no, that wasn't an argument I was making, that we're trying to take operators who are otherwise single well financially assured and then try and protect them through an option 1 or option 2. I understand that distinction there. No, really, I'll just kind of reiterate, you know, what I'm getting at is that I think there should be a backstop. I appreciate Commissioner Nanjapa's clarification or potential limitation of the language, that, you know, perhaps it should be a time frame for payment versus a cap. And I'm not suggesting that we put any kind of clear or specific number in our SPP language, but I do think it should be up to us commissioners at the time it comes before us to decide whether or not we should cap, not a cap as a noun, but cap as a verb, cap that amount when it comes before us, or whether we should offer more time to ramp up to that amount. If it's under a bespoke plan that comes before us, that's at our prerogative to make those determinations based on the information before us. And I'd like to keep it as an open-ended option, just to acknowledge that it's part of our deliberations and a contemplated possibility that I'd like to account for.
And Commissioner Gonzalez, I appreciate that approach. And so let me just make sure I understand what you're saying is that operator X goes into tier 1 or tier 2, runs the math, and it becomes uneconomic or it becomes inability to pay. They then pivot to option 5 and come to us for a bespoke approach, at which time the SBP would have had language in there that allows discretion to commission to adjust what would otherwise have been an undoable tier 1 or tier 2 into a doable tier 5 that we, using our discretion, thinks makes sense for the state of Colorado and that particular operator. Did I capture that?
Bingo. Yes, it captures it. And the only thing, the only clarification I was trying to make is that we've thought about, we've discussed specific instances where an option 5 may be triggered as things that we'd like to include in a non-exhaustive list in SPP to guide operators as to whether or not they may be in an appropriate position to seek an option 5. And I was just trying to clarify and specify that particular possibility. So yes, and.
Yes, and. Okay. Commissioner Messner?
Thank you, Mr. Chair. I think that's reasonable, Commissioner Gonzalez. I will point out that that's a undue hardship, right? Financial hardship. And so that's
But it's not prohibitive. It is a consideration.
anyway, I think that's reasonable. Yeah.
I think we have to give Messner that. That was just a softball waiting to be hit out of the park. All right,
Sure.
so it appears, Director Murphy, that we do not have a majority support for caps in tier 1 and tier 2, but we do have support for the Gonzalez approach, which is to SBP up this discussion that we just had so that operators are aware of the pivot that they may want to make, and future commissions are aware of the discussion that took place around using bespoke in times when tiers otherwise are creating hardship.
That, Chair, is kind of the question that I had. It seemed like we transitioned away from the actual rule language in 1 and 2 and into the SBP language of option 5, which leads me to ask the question, are we done with 1 and 2? Are there any comments left to discuss for option 1 and 2? And can we move into the 3, 4, and 5 space and try to close this out?
I'm good. I'm seeing nods of heads in an affirmative fashion. So I believe we can move to 3, 4, and 5.
Great. As far as I can tell, we haven't had the opportunity for commissioners to offer up topics for discussions for 3 and 4. We do have one question on the table on option 5, which is, what is the standard to qualify? Perhaps it's undue hardship, perhaps it's something else. And so I think it's up to you all if you want to talk through 3 and 4, or if you want to just jump on that question for option 5. And I don't know if there are other issues to work through in option 5. We do have a lot of SPP related dialogue for option 5.
Well, before we jump to 5, do we have issues around 3 and 4 from commissioners? Commissioner McGowan.
Thank you, Mr. Chair. And I have 2 thoughts for both of these options. One is I'm contemplating or wanting to put on the table, as operators in option 3 and 4 work their way towards full single well financial assurance, As they're halfway through, then they pay 50% less into the orphaned well fund as their annual part of their annual registration fee. And when they get to 100%, I know that they asked to pay zero, and I originally have to say I was supportive of that, but I've been worried about kind of long term how the orphan well fund will sustain itself, and so I'm thinking still having to pay into the fund, but at some very low amount, like 20% of what the annual registration fee is or something, or it could be convinced zero if other folks don't think there's a risk to do that. The other piece that I just want to make sure we take care of was brought up by Mr. Freeman, and just making sure that there isn't this kind of double counting. If you plug something off the out of service list versus in your normal list, you get to discount it the following year, and just making sure we have language around that acknowledges that's not the intent of the commission. But I do still want someone who's plugging to be able to deduct that from what they have to invest next year into their sinking or trust fund. Does that make sense?
Director Murphy is trying to capture those thoughts. As she's doing that, do any other commissioners desire to weigh in on these issues? Commissioner Messner?
Thank you, Mr. Chair. I agree with Commissioner McGowan on the second piece. I think that's an important one that I've been contemplating, and I've contemplated a few different things, but I think that general intent is where I land on how options 3 and 4 interact with the out of service list. I don't know how many option 3 and 4 operators will utilize the out of service list as it as really the overall scheme is a plug and play scheme, which really takes the place of the out of service list. And so, I mean, I think that the operators that understand how that works and how to utilize that to the maximum ability, I don't know if they'll see a particular advantage to the out of service list. So, I think that we need to ensure that there's maybe we need to ensure, but certainly my intent is, because there's a potential problem here that I still think that Commissioner McGowan's language addresses, but certainly don't want to see any operator in 3 or 4 put all of their wells on the out of service list so that they don't have to pay anything for 4 years. Although understanding that they still have to plug those within 4 years. And so, I mean, I think that this language covers all of that. As far as the first one goes, I think that depends a little bit on how we choose to address the well registration fee and what we're levying that on. If we're going to do a reduction like API suggested for operators in tier 3 and 4, different than operators in tier 1, 2, or 5, that by itself may address that first piece, right? But if we're going to do a total vertical depth or some other flat fee metric, then I think that what Commissioner suggested in the first piece makes some sense as well. I think I made sense to myself there, at least. I hope I made sense to everyone else.
Commissioner Gonzalez and then Commissioner Najapa.
Yeah, made perfect sense to me, and I'm going to echo that. I'll just rephrase it in my own words to make sure that I got it right. I also agree with the second bullet point for Commissioner McGowan. I think it's appropriate for this discussion here. I would suggest that we take that first bullet point and we just move it over to the well registration fee slide, and we can talk about it there, because I will have some questions in terms of how we're funding otherwise that well registration fee, and whether or not this language or this suggestion is even applicable after we get through that discussion. So that's kind of my suggestion there.
Commissioner McGowan, are you comfortable with that? Commissioner Najapa, you had raised your hand earlier.
Yes, thank you, Mr. Chair. I'm on board with kind of everything that's being discussed here, and including kind of pinning the first bullet for the annual registration fee discussion. Yeah, so I'm good with what we have here. I had a couple other things to add, so if that's okay to continue.
Please do.
So I've been thinking about this a little bit as well. We did have a suggestion about changing the timeline for option 3 to 10 years to fund single well financial assurance from 20 years. And I think that makes sense given that option 3 has a pretty, sorry, I guess it's, no, okay. I think that makes sense given that the option 3 we're talking about a slightly higher, or quite a bit higher production thresholds for that particular option. And in my view, I know we had a shorter time frame for option 4, but in my view, if we're to a certain extent, we're talking about the oldest wells, the lowest producing wells, perhaps more end of life wells in option 4. While on the one hand, I understand trying to get that paid up quick, I'm a little more of the mind that we give a little more time in that case, because whatever we get, first of all, the operators can be using in the plug and pay concept and can keep drawing money out. But also whatever we get, if we have a situation where an operator walks away, we've got a good amount, or we're going to have money in hand, which is better than some of the situations we've had in the past. But given that there are lower producing operators, I thought it might be more equitable to give a little bit longer of a time runway. I was originally contemplating 20 years, so switching the two, 10 years for option 3, 20 years for option 4, but I'm thinking more like 10 and 15 for these two options. And so I just want to put that on the table to see what other folks thought.
Commissioner Messner.
Thank you, Mr. Chair. So I think it's important to understand as written that option 3 and 4 has thresholds that are timelines that are presumed, right? So it's presumed 5% a year for option 3, 10% a year for option 4. It's 5% a year for option 3 because those have more production, right? So they have a longer anticipated life associated with those wells. 10% because there's significantly lower production threshold on those and have a shorter anticipated life. But also important that these are commission review and they're just presumed. And so if there's a situation where it comes in front of the commission and we determine that even in an option 3 operator, we need a shorter timeline based on that operator's portfolio and financial situation and the other submittal requirements that are required as part of a financial assurance plan review by the commission, this commission has the ability to adjust that appropriately based on an operator's portfolio, financial capabilities, and anticipated life of those wells. And so I think that's already built in there. I don't think we need to create these like hard down payment concepts or hard timelines associated with these, but we're creating, this is the presumption, but we're going to look at this package as a commission review, and we're going to look at it on an operator portfolio by operator portfolio basis. So, I mean, I'm not going to be really supportive of putting anything more in there than what's already there, because I think it gives us the ability to already do that.
Commissioner Gonzalez.
Thanks, Chair. I agree with Commissioner Messner on that one. I think it was contemplated, longer for option 3, shorter for option 4, just given the same reason that Commissioner Messner stated, based on this presumption that that those operators have a longer life due to higher levels of production across their portfolio versus for an option 3 versus an option 4. I'm comfortable with the language as drafted. So that's kind of where I sit on that.
Me too. Others? Okay, do we want to just leave 3 and 4 then where we've got them at this time? Commissioner Gonzalez?
Yes, and the suggested language, perhaps in the SBP that Commissioner McGowan had proposed. I don't know if it's rule language or SBP language. I think it could have the same effect both places. And I think that's here, the bullet point number 2.
The out of service. Okay, I think we let you get caught back up, Director Murphy. Nicely done. All right, do we want to pivot to option 5 at this point? So on option 5, we've already had some discussion from Commissioner Gonzalez about putting in the SBP language around if your hearing is otherwise creating hardships, then we would look to bespoke. I think the other main criteria was Commissioner Messner's original understanding and thought of undue hardship. And then what else?
Chair, if I can.
Yes, please, Director.
I think that there were a number of pieces that Commissioner Najapa built out that are in the 3rd bullet point. That are things that are important things that an operator should consider coming forward with if they're pursuing option 5 is how I would state it. I know that when Commissioner Najapa was running through those items, I got the 2 BOE threshold, but I missed the MCFE threshold. And I didn't know if he meant to mirror the definition of low producing, but that's why there's a bracket in that 1st bullet point under relevant information. As we go ahead.
No, go ahead.
And then as we've talked through it, the real question that I think that staff needs direction on changing or not is undue hardship the threshold for requesting an option 6 plan, or is it no threshold, or is it something else? And I've got 4 different options already on the table, so that's going to be wonderful to think through.
Commissioner Messner.
While I mean, I think I already said this, but while I had initially proposed the undue hardship, it was really to create a starting place and a discussion around, is there a qualifier that's necessary for option 5? I mean, I think based on deliberations today, it seems that like there should be a qualifier. I don't think undue hardship is it necessarily. I think in here we've got due to circumstances that prevent an operator from using other financial assurance plan options. That itself may cover financial hardship, which is what Commissioner Gonzalez had indicated. I think exceptional or unique circumstances is one I mean, that makes some sense to me as well. I don't think no threshold makes any sense. And I already talked about the undue hardship. I think the other piece for me in there is that it should be presumed that that an operator is in whatever financial assurance requirement that they would be in within the option 1 through 4 structure as a starting place in the discussions as well, so that they are, and that may be more of a submittal, right, than it is a qualifier, but that's an attempt to try to get at this piece that's in bullet 2 under the SPP, is that the option 5 is not a mechanism to simply get a better deal. So I'm comfortable with small bullet 1 and 2, which is due to circumstances that present an operator from using other financial assurance plan options or exceptional or unique circumstances, or both of those things, as at least a starting place in this discussion.
Commissioner Najapa?
Thank you, Mr. Chair. And yeah, I agree with that. And I think you could just kind of roll the first and second small bullet together into one sentence, that it's due to unique or exceptional circumstances, or however you want to put it, for that prevent an operator from using another financial assurance plan option. For the second large bullet, I was just trying to think of, I think the second bit after the semicolon there, demonstration of unique circumstances, including things like financial health, et cetera. That's what we were talking about as we were talking about the potential on-ramp, into option 1. I suppose those could be like evidence in support of whatever new scenario that the operator is proposing. So it's not so much that in every option 5 situation, they have to demonstrate things like financial health, plugging activity, compliance, et cetera. Does that make sense? So in that second bullet, I'm talking more about sorry, I'm talking about the SBP bullet. Okay, I just wanted to make sure we were caught up. So that second part after the semicolon in the SBP bullet, I don't think you have to come to the commission for an option 5 and have to show financial health, plugging activity, compliance, et cetera. What I'm thinking that those are more like pieces of evidence that might support a particular different plan that they might want to propose. Like they could say, we would like to do, this different option and this different time frame because we have these other pieces, but I don't know if I'm making sense. I don't think it should be those things listed there should not be a requirement for option 5. I'm not sure if I'm communicating here.
Well, I think by the edits to create this as a non-exclusive list of things that you can bring.
Okay, yes, I think, okay, I see. I was not following where the edits were happening and what I was saying. Okay, I think that makes sense. The other thing, the minimum daily well production thing, that was again more about if you were qualifying into option 1 and you were a lower producing operator, that we would single well financial assure. Inactive wells, I don't think that really is something that we even put in here at all. That was the on-ramp idea. And let me just see what else here. And the surety only was also the on-ramp idea into option 1. So I think you can eliminate that one.
Oops.
Yeah, I think with what's listed there for now under the third bullet for would be, again, considering that first bullet of exceptional or unique circumstances, and maybe why a longer time frame or a slightly different approach was required, but not necessarily trying to seek a better deal. And that the justification could be, here's our financial picture. Maybe it's not necessarily a financial health situation, but rather a inability to pay, as Commissioner Gonzalez, offered previously, but a just an overall sort of financial picture of why they might need more time or some different considerations or things like that. And I'm trying to think, I thought there was something else that we wanted to look at. I can't remember what that is, but I could see the kind of general, unique circumstances of having the difficulty or the inability to pay or something like that, but they are compliant, they're up to date with their MITs, they're blah, blah, blah. And this is why, this different plan should be considered, something along those lines, if that makes sense.
Commissioner Najapa, in response to the thoughts that you had under the first criteria, and I think you had supposed we put exceptional or unique circumstances in the same bullet as due to circumstances that prevent. I respectfully tend to like those two being separate.
Due to unique or exception.
And being an or.
Okay.
Because I think there's a difference there. I think.
Okay.
I mean, it can be in the same bullet as long as there's an or, because, you may not fit for whatever reasons or circumstances, but there also may be exceptional or unique circumstances that the operator thinks it could come to us and bespoke up a better plan, better than one of the tiers that would have been met. And I would delete that you just highlighted, Director Murphy. That's just one commissioner. Commissioner Gonzalez.
Thanks, Chair. Yeah, just a couple small things in here to kind of clean up the language a little bit. Circumstances that prevent an operator from using financial assurance. I'm not quite sure that prevents the right word we want to use there. I don't have a suggestion, but I would leave it up to the wordsmiths to maybe come up with something a little bit better. Just if I'm reading that, I'm going to be thinking, does this really prevent you? Or is it just not the best way, right? And so that's something that I think could use some wordsmithing. And then the second to last sub bullet of no major violations in the past 3 years. I think that's an appropriate consideration as we had thought about in the on-ramp perspective. I think that we do need to be looking at compliance history from an enforcement perspective, but I would have trouble putting a time frame on that, and I would have trouble saying major violations given, are we talking about the rule is major? Are we talking about the impact classification is major? And all that, kind of debate and nuance that we worked through in some of our enforcement hearings in the past. So I want to honor the importance of looking at those violations. I would change up that language and not limit it or not have it be so precise as to no major violations within the past 3 years.
Commissioner Messner.
Thank you, Mr. Chair. I wonder if I could suggest just a structural idea as far as the last bullet, big bullet here is, I think there's certain submittal requirements for financial assurance plans that should be universal amongst all the options. And I think it would be good to flesh those out. I think there's some already in the draft. I think some stakeholders have suggested some additional ones. And those would carry through all of the options. Perhaps in option 5, there's a couple of additional ones that maybe we want to include, but it may be helpful for that, at least that last bullet, to flesh out what's the universal submittal requirements for all the different options. And then if there has to be something unique to option 5, then hash those out. Does that make any sense?
Let's let Director Murphy take us to that.
So what I have on screen is the information required for option 5 plans. Option A, or like, sorry. A includes 5 subparts that are consistent across all plans: production data, well status and designation, well plugging data, inactive well list, asset retirement planning. Option B is fairly consistent, but it's a calculation of what the operator, in this instance, to me, it'll be what the operator is proposing is appropriate for financial assurance as part of their option 5 plan. C is the type of financial assurance, and the difference in the current draft rules from option 5 to a number of the other plans is D, which is the certification of financial capability, which we talked about a little bit earlier on. And if I can recall and recap that conversation, the idea would be to build in some of this idea around an operator certifying or attesting that it can meet the obligation imposed by the Act and the Commission rules, including that as part of the information required for all of the plans. But what would remain unique to option 5 is the mandatory requirement to have the certification signed by an operator's corporate officer, including its net worth as dominated through financial statements, accompanied by an unmodified opinion issued by an independent auditor. So that is that last sentence, even with today's direction, would remain a unique information requirement for option 5. Whether that's enough or not is up to you all, but wanted to walk you through where we are as of the February 11th draft.
What are folks' thoughts? Commissioner Messner?
I'm just running through a couple of notes here because I have notes on this and I'm just trying to get to it because it's my fault. We jumped over to this and I wasn't quite ready for it, but I just need a couple of seconds here. Yeah, I don't have in my notes anything additional for an option 5 plan. And I think that those that what's currently in the draft is appropriate. I think one question is whether that submittal should include number of low producing wells and some explanation of wells that are on the out of service well list.
Does anybody have heartburn with that?
Can I, Chair?
Go ahead, Director.
Forgive me for jumping back and forth between screens. So for all plans, including option 5, well status and designation data is coming in. So the number of wells that are designated out of service will come in with this plan as with all others. And then there is well plugging data. And Separately, on an operator 6B, we will be tracking what's going on with an out of service plan. And that's not the most articulate I've been all day, but the 6B is designed to get an annual update from the operator around progress on plugging and some of the interim steps related to getting to plugging out of service wells. And
So
I think
are you saying though, those are already, the two things I said are already captured so that they would be either available for the director or for this commission to review as we're reviewing a financial assurance plan?
yes.
Okay.
And if we look in 8.5A little v, a demonstration of how the operator is planning for the retirement of its facilities, including out of service, inactive and low producing wells.
Okay, I'm comfortable with that.
Okay. Chair, I've made some changes to the first bullet point under option 5. I think that there are a majority of commissioners who are interested in making sure there is a threshold for who can, under what circumstances an operator can pursue option 5. I think I heard a majority of operators interested, or majority of commissioners interested in the conglomeration of the first two into due to circumstances that prevent an operator from using other financial assurance plan options or exceptional or unique circumstances. I might be overstepping my bounds here, but that's what I've heard at this point, and I guess I'm motivated to keep us moving.
I think that's fair. Everybody comfortable? All right, you got thumbs up.
Fantastic. So I think we've buttoned up 3 and 4, 5, 6. We've started talking about what information is coming in on financial assurance plans. I think that there's a question on the table about the financial health. I think what I've talked through is, again, using a modified version of what's coming in for option 5 plans and applying it across all of the other plans. And I think that there's generalized support for that. We've talked a fair amount today about the inactive well list and asset retirement planning information that's coming in across all plan options. And so I don't know if we've closed the loop on these or if we need to discuss them further, and if there are other issues commissioners want to talk about as it relates to the information for financial assurance plans. And this is largely in 702D.
Chairman Robbins.
Go ahead. I'm sorry, I was looking at my notes.
Oh, that's okay. Director Murphy, now this is the submittals and I appreciate that. Do you want to talk about director or commission review later or as part of this?
Bring it on.
Okay. So first, my first question is so I think we've determined that options 1 and 2 would be administrative review initially and move forward. Option 3, 4, 5, 6 would be commission review initially. It's not clear to me whether it's commission review moving forward from there or not. And whether if it is commission review moving forward, if that's an annual review, a biannual review, something different. So that's a question initially.
Yes, so Commissioner, I think you've correctly stated that the director has the authority to review and approve or deny, which would then come to you, option 1 and 2 plans, and monitor compliance with them and changes to them going forward, so long as the operator meets the criteria for option 1 and 2. For options 3 and 4, it's a commission level review and approval. There's not a specific, well, actually for 3, 4, and 5, it's a commission review and decision on the initial plan submitted. And then that would stay in place and unless and until either the commission pulled it up for review, the operator no longer qualified for it, or the operator submitted a revised plan. Unless the commission also specifically ordered, we want to review this every 2 years or every 6 years. There's not the same review mechanism. Option 6 is going to be based on today's decision, commission review and decision on the initial plan, and then a by rule 3-year review, which the commission could also change to be shorter or longer, depending on the circumstances. Does that answer all of the questions, or just the ones I wanted to answer?
No, I think that answers all the questions. And so I think, I just want to make sure from an administrative point of view that an annual review is feasible, I guess. Understanding that that's where it is right now, but I think 400 and some plans annually. So I just want to make understand that that's a feasible ask.
That's a good question. We're looking at it on the staff side in terms of what we need to do. The majority, based on the submittal timelines for initial plans, I think we've staged it in a way that we can kind of learn as we go and make us more efficient towards the end, when the largest volume of applications are going to come in for this initial tranche. I did neglect to mention, Commissioner Mesner, that for every single financial assurance plan option, the director will continue, or the director and staff will continue to do an annual review of those 5 or 6 enumerated things in 707A. And yes, we think that's feasible. We've been holding open a position pending the outcome of this rulemaking to make sure we get the right skill set built in based on the rules that are adopted today. And we're also looking at broadly, what do the rules need us to have on staff to be able to administer them. So there's some very operational answers in that.
Just relatively important to me.
Same.
I have other questions as far as what would constitute elements in a director or commission review, but if people have questions about this particular topic, I can pause.
Commissioner McGowan.
Thank you, Mr. Chair. And I've been thinking a lot too about the workload and what the annual review looks like, what information comes to the commission, and how the public can see that information. So I just want to maybe create some clarity around that. I also wonder if we can put half the operators on one schedule and half on the operator, so it's kind of a 2-year review schedule. Folks might not be comfortable with that, but then every other year we're doing half each year reviewing. And I'm wondering if the annual review needs to be some sort of a template that kind of almost is like the green, yellow, red light, where these cause concern, they go to the commission for discussion. These folks look good or whatever. I'm just trying to figure out what all this information is going to look like, and the sheer volume of information that's going to be out there, and how we are going to be able to sift through it in a meaningful way and figure out where folks, like where the operators are at and how we're doing.
Commissioner McGowan, who's the we in the review sentence? Like, are you concerned about staff's ability to review 400 or the commission's ability to review? And I will say it's been important to me that staff on an annual basis is verifying that the type of financial assurance in particular remains in place. I've had pretty rough experiences in my former experience with the Division of Reclamation, Mining and Safety in particular, where banks let letters of credit go before they were supposed to. And so I remain I will strongly advocate for staff's annual review for at a minimum, what you see on screen, 707A1 C.
No, point taken. So if staff is reviewing this annually, is there going to be like a general report that summarizes everything so that, I mean, I don't want folks to think it's a black box and not kind of know what the review resulted in. But I also don't want to make this like some painful exercise, but some sort of transparency. So I'm just wondering what your thoughts are on what this might look like.
I think that's a great question, Commissioner. In light of the conversation on Friday between commissioners and the parties, I started, exchanging notes with some staff members about what our plan was to make it visible in terms of staff's review. I think that a document confirming that the review has been provided, that's fairly straightforward. I mean, it's going to be a little bit formish and a yes, no, not a giant narrative, exhaustive review of everything on file. But I think that we've tried to set out the review in 707A1 as fairly yes, no questions, no being problematic and needing to be elevated or additional financial assurance being requested. And so I think that it has always been contemplated for me that we would be doing that work. I think the staff hadn't totally thought through how to document that the work had been performed and where that the completion of that review would be housed when I think about the operator file. And again, I'm getting way into the weeds on the operational components. Long-winded way of saying, yes, I think we can certainly put together a form that reflects staff's review. I just don't want to mislead anybody to think that it's going to be a 32-page tome or super exhaustive compliance evaluation. I think that we have enforcement tools to deal with compliance. I think that there are other tools to address some of the other places where we have concerns, and that's where we need to zoom back out to the macro picture of the entirety of our rule sets and how they're working. And I think that this is an important component as well, especially as focused on the 5 topics that staff has proposed in 707A1.
Commissioner Gonzalez.
Thanks, Chair. Yeah, I'm not quite sure if this is right along the same lines what we've been talking about, but I'll take a second and acknowledge that, I too think it's important. I think a lot of the protections that we've discussed and really a lot of the protections that we have potentially not adopted from stakeholders benefit from the review on an annual basis by the staff of financial assurance plans. So long as the staff can do it and wants to do it, I'm 100% in support of that frequency. I wanted to kind of ask a question and then give my thoughts around it. But I don't know why we would need a commission review for options 3 and 4. Is that still on the table as being contemplated, Director Murphy? I see 9 in your head. I think about options 1, 2, 3, and 4 as all being pretty prescriptive in terms of what gets you in there. And so long as you meet that criteria, you are in there. And then the important stuff of your financial assurance plan to make sure it's all intact and I guess adheres to those options could very well and is probably best housed with staff reviews. So I'm not quite sure why those would come to the commission. And so that's kind of my 2 cents on that, and really a question for my fellow commissioners as to whether or not we need that review. Now, I think for option 5, super important that comes to us. That's going to be really determined by us and shaped by us as it comes before us. It's going to have a lot of unique, independent pieces of information that are specific to that plan. So I think that's appropriate. And then we've already kind of settled on option 6 being commission review. So I'm a proponent of staff being able to approve financial assurance plans for options 1 through 4. And I don't know that I've heard a good argument to have commission review for any other ones or for any of those, should I say. So
Commissioner Njapa, then Commissioner Mesner.
Thanks, Mr. Chair. Director Murphy, were you about to respond on that? Oh, if that's okay.
Director Murphy, do you want to go first?
I would like to respond. I think as I had initially envisioned option 4, it could have been a director level decision. The challenge for me in both 3 and 4 is the use of the word presumptive. And if that creates latitude, what is the director's latitude to change it or not? That makes me a little bit nervous as we're launching an entirely new system. I think if an operator were accepting of those timelines, it makes it easier for staff to administer those rules consistent with your direction. The other piece that is particularly complicated about option 3 is it's the requirement to bond up to single well financial assurance for all of the wells. And there's a lot of discretion between 0 and 100%. And what is staff's role versus a commission's role. So those are the reasons, Commissioner Gonzalez, I think as staff put this together initially, we thought that 3 and 4 would be appropriate for commission review. I think if we either tighten some of those up or set some pieces in place that were less discretionary, yes, staff could administer them.
Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you, Director Murphy. I think that was I was going to comment on some of that. You know, I'm wondering, I was thinking about this as well, and you know, kind of generally agree with Commissioner Gonzalez that maybe we don't need to have commission review for options 1 through 4 unless the operator is coming forward with a demonstrated cost for single well financial assurance, or I guess my inclination would be on the presumptive, you know, timelines to just tighten that up and just say that it's the amounts that we have written, whatever, what is it, 5% and 10%, I think, right? That we just go with that, and that my assumption would be then, if given what we just discussed about option 5, that if an operator needed a different amount than what we have specified, that they would have to come to the commission with a different time frame. So I would say from this commissioner that we remove the presumptive amount and just say the amount will be 10% of the total or 5% in those different options. And then it comes before us in an option 5 if it's anything different than that. And only if in any of those 1 through 4, the operator is coming forward with a demonstrated cost for single well financial assurance, then I think it would come to the commission. That's just one commissioner's thoughts on that.
Commissioner Messner?
Thank you, Mr. Chair. I mean, I think on this one, we're messing with the root of the concept here again, because I think that the idea of option 3 and 4, and I forgot that we had in there up to single well financial assurance in option 3, and I think I suggested that language. I'm comfortable with tightening that up to just say option 3 is single well financial assurance, but I think the elegance of the concept that was created in this plug and play option 3, anticipates, really looking at an operator's portfolio and situation and tailoring a financial assurance plan that allows this operator to be able to retire their assets themselves and utilize money that they're putting away in a sinking fund and do this over an anticipated life of the well timeline. And so that it really allows that creativity and that flexibility in option 3, even somewhat in option 4 as well. And so to me, that discretion needs to be part of option 3 and 4. Also, the option to tighten those timeframes if necessary too, if we see a particular situation where an operator is not meeting its obligations, to comply with all the rules associated with the act and so on and so forth, so that, you know, if it's clear we've got an operator that's in distress or is having problems, to tighten those in order to acquire single well financial assurance quicker than that 10-year time frame for a tier 4 or a 20-year time frame for a tier 3. And so I think that discretion is important. I think it's appropriate for it to go in front of the commission. And so I want to maintain that ability for that creativity. So, I mean, I guess one potential compromise here is that if it's important for this not to go in front of the commission, although I think it's still good for it to go in front of the commission, that if an operator comes in, presumes single well financial assurance on the 20-year or the 10-year cycle, I mean, it could be a director review because it's a little more straightforward then, but I don't know. I mean, to me, those were always designed to be commission review to allow for that flexibility.
Commissioner Gonzalez?
Yeah, and I think one of the issues I have with that is the idea of options 3 and 4 being tailored financial assurance plans. And tailored to me sounds like a bespoke plan. So it's basically a bespoke plan that is almost prescribed for option 3 and a bespoke plan that's almost prescribed for option 4. And I'm curious how that differs from a bespoke plan in general. If we're saying that an operator could come in and say, it's up to single well financial assurance, I'd like to financially assure at 30% of my total demonstrated costs. Isn't that a bespoke plan? Right? Is at what point does the tailoring, is it within the rule, and at what point does it become just a complete custom financial assurance plan up to single well financial assurance, of which is already contemplated in option 5? So that's kind of my argument on why maybe options 3 and 4 should be tightened a little bit, and then the off ramp is option 5, which I think would still fall into the 2 kind of triggers that we've identified there. So that's one thing. And then the suggestion about us being able to look at it and then tighten the time frame if necessary. If I'm not mistaken, I think commission is only looking at the initial financial assurance plans for options 3 and 4, with the rest of them being identified or reviewed by the staff on an annual basis, in which case the staff has the ability to bring it to us and to ask for additional financial assurance. But I don't think that we, the commission, are in the position to review that on an annual basis and to check that operator against that time frame and their effectuation of their financial assurance plan. So again, that's kind of why I'm questioning this. So if I'm off on either one of those points, I'm happy to discuss it further. I'm failing to understand why what you're describing, Commissioner Messner, isn't a bespoke plan, I guess.
I mean, I'm happy to respond to that. I mean, number one, it is contemplated that the commission review option 3 and 4. It is contemplated that we do the initial review. The initial review develops the financial assurance plan. And so we're looking at an operator's portfolio. We're looking at the anticipated life of those wells. We're looking at the proposal that the operator puts towards us as we look at the anticipated life of the wells. If these are micro producing wells in a tier option 4 scenario, it doesn't make sense to allow for a 10-year runway on those, where really these are functionally inactive wells, the entire portfolio. And so this is where I think the importance of us being able to tailor that initial financial assurance plan based on what the portfolio of those wells is, becomes an important consideration for us. I think that the idea behind option 3 really came from Own Resources and their submittals, and it was a plug and play concept. It's a fixed concept, right? There is some discretion in there as far as allowing timelines, and which is why I suggested that language initially around up to single well financial assurance, in my mind, probably needs to be eliminated, because that does create probably more confusion than potential help. And so I would recommend we take that out. But I still think that there needs to be some consideration of timelines. We can presume a 20-year timeline But in some circumstances, based on the anticipated life of those wells, it should be 15. Some it may be 25, but we're doing the initial review. We're setting the financial assurance plan. And I still think that's kind of the grace of option 3 and 4 is that you're requiring single well financial assurance, but you are naturally tailoring that to the operator that really in the end benefits that operator. And so, and helps them, put aside the money necessary to ultimately retire those assets, which is what the whole philosophy of this is. As they get closer to the end of their life, more and more money is getting put aside in order for them to retire those assets. And so I'm comfortable with the way it is. I don't think we need to make a big shift to put everything into bespoke and have director review of these particular plans. And I think if you look overall at the number of operators that currently would be in option 3 and 4, it's not such a massive amount that we wouldn't be able to do it as a commission review.
Commissioner Gonzalez.
Yeah, just to follow up on that last point, Commissioner Mester, how many operators are you expecting to be in options 3 and 4?
I don't have the exact amount. I mean, I had a spreadsheet and I looked at the spreadsheet and it's not, again, I think Western Slope COGA put together a pretty good bell curve. I've seen other bell curves that incorporate all the operators in the state. And so from a percentage standpoint, we're at the lower end of the bell curve on both option 3 and 4 as it's trending down versus option 2 being at the high end of it, right? So that's how I'm making that rationalization, right? But there is no question that as we look at this, either option 3, 4, 5, 6, if commissioners are going to review them, this initial review is going to be a big lift. But this is us setting up these plans for a significant amount of time. And this is just the way it is, in my opinion.
Yeah, that's helpful, Commissioner Messner. I appreciate the response there. I still hold the concern that, I appreciate that the bespoke nature of options 3 and 4 is limited to the timing for contribution to a financial assurance fund and to the amount up to a single well financial assurance. Isn't so much, contemplating different mechanisms for financial assurance. So I think it is limited in that nature, and I appreciate the clarification there. I guess, I still have some concerns about the amount of operators that would come before us and the extent to which these hearings would actually dig into these financial assurance plans, right? If we set aside an hour for, half the operators and we say there's 450 operators, whatever, 225 hours, give or take, worth of hearings just dedicated to reviewing a financial assurance plans and working with that operator to toggle up and down their timing and or amounts. I guess I have some concerns about the efficiency of that being the best use of this commission's time. So that's kind of my position on it. But again, just one commissioner sharing my thoughts. So,
Commissioner Nanjapa.
Thank you, Mr. Chair. And I appreciate the explanation, Commissioner Messner, in terms of, your thinking in how this all came about and the reasoning behind it. I guess I also sort of share some of the concerns that Commissioner Gonzalez articulated. And to me, it seems that if we put firmer, timeframes and more definitive language in 3 and 4, we'll capture, we'll capture a number of operators that way who are able to just do it as it is. And then there may be some that may require something more custom, and then they come before us with option 5. So I guess I'm still thinking along those lines. I have some numbers from a spreadsheet that Director Murphy had shared with me, and Director Murphy, you can correct me if I'm wrong, but it's around 100 operators, both oil and gas, in both 3 and 4. So 200 total we're talking about. So I think that's a pretty large number. And if we can get more of them to be able to just do, you know, remove the word presumptive and just say 5% and 10%. And if they have a problem with that, then they can come to us via option 5. I think that's my view. And then just separately, I wanted to pin, because we didn't talk about this, but I do think it would be worth at least some discussion on whether a minimum amount should be deposited before an operator can start withdrawing for plug and pay. So anyway, that's just a separate thing. So that's not directed at Commissioner Messner, but just in general. But I just wanted to note that I think if we do tighten up the language, we can reduce the number of plans that are coming before us, unless they have, you know, a unique or special circumstance, like requiring a different time frame or a different amount, or you know, are using their own numbers for their single well financial assurance.
Commissioner Gonzalez.
Yeah, Chair, I just want to piggyback on that. Yeah, so 200 was kind of a round number that I was using. If we assume an hour for each one of these financial assurance reviews on the plans for this initial plan, of which we've never done any. So I imagine there's going to be some digging on our end to want to get some details there. Assuming 6 hours a day for hearing, that's 33 1/3 hearing days, full days of reviewing 200 financial assurance plans over the course of the year. That number is influential to me, given that we have scheduled hearings 52 times a year. Now, if we have a separate day, and I mean, there's all sorts of ways to tweak it, and we can add more time, more hearings to our weeks, no problem on my end. But it is a concern, the amount of time that these might take. I also want to acknowledge something that Commissioner Nanjapa said, and maybe tweak my proposal or my position a little bit, and perhaps in options 3 and 4 specifically, that if the operator would like a different time frame other than 5% contribution per year, or a different amount less than single well financial assurance, then in those cases there could be an appeal to the commission for hearing in that regard. And perhaps that kind of covers both aspects of what we're trying to do, to give the operator the appropriate flexibility and look under the hood that they would like, but then also to save us, you know, an exorbitant amount of hearing time looking at financial assurance plans that I think could be just as well be approved by the director or by the staff if they are on the timeline presumed and at single well financial assurance as presumed.
Okay, so where are we at this point? Commissioner Messner?
Thank you, Mr. Chair. Yeah, I mean, I think in the end, I just disagree. I mean, I think that it's designed to have a commission review. I think if an operator comes in and suggests a 5% or 10%, 10-year, 20-year plan, then it's I mean, this is a 5-minute review at that point, right? I mean, it's just not, we're looking at the plan, they've presented a plan, we've reviewed it prior to the hearing, we've got a few questions, they ask the questions and we move forward with it. If they ask for something different, they're going to present a plan that says, well, we actually think our anticipated life of the well is 25 years. Here's our plan, here's how we're planning on doing it. We have the plan in advance, we review the plan, we ask a few questions. I mean, I'm just not as concerned as you guys are about this. And so, I mean, I think it creates flexibility for the operators. I think what these operators have asked for is flexibility in tier 3 and 4. I think that they're feeling burdened by the requirement for single well financial assurance. And so they've asked for some concessions around flexibility, around timelines and tailoring plans so that they can be successful and they can ultimately retire their own assets. I guess I'm not willing to give that up for some administrative ease. And so, I mean, I think that's just where I sit on that. So.
Commissioner Gonzalez?
Yeah, just for the purposes of furthering the discussion and maybe trying to find some common ground here, Commissioner Messner, would you entertain that these financial assurance plans, if they had recommendation from staff, go on a consent agenda?
So again, I mean, you're going to ask, I mean, I hear what you're saying. You're asking staff to make a discretionary review of these to determine whether it's appropriate to have a longer timeline or not. I mean, if staff wants to review them, if they're proposing a 10-year or 20-year, the presumed numbers, and they want to put it on consent agenda, then yeah, I could be okay with that. I don't even know if staff needs a review, and they can go on a consent agenda if they're doing the presumed amount, and we can review them and then pull them off the consent agenda if we want, because those are the presumed amounts, right? And so really it gets down to the ones where we're not necessarily utilizing those presumed amount, and we're allowing for some creativity or flexibility in there.
I think that could be an appropriate approach.
I'm good with that too. Commissioner McGowan?
Thank you, Mr. Chair. And I guess one light bulb just went on for me in that is the assumption that staff will have put an eye towards all of these, regardless whether they go to the commission first. And sorry, I really have read the rules. Is there going to be just a completeness check from the director and or a recommendation? So if options 1 and 2 are director review, then will there be something that comes to the commission that says the following plans have been reviewed by the director and they've been approved? Or does it just happen behind the scenes and it just gets done and the only ones that aren't approved? Sorry, my brain is mush right now. And okay, so it's going to come to us with a recommendation. But only those that we're saying the director reviews. All. So Commissioner Messner, if the director is reviewing all of them with a recommendation, to Commissioner Gonzalez's point, those that are recommended go on consent agenda. Those that have issues then go to the commission, like as agenda items. So I'm just trying to work through what this all looks like and kind of comparing it to how the OGDP process works to a certain extent, right? Like what things get recommended, things that staff bring to us as you know, we asked about this or we saw this, you might want to note this. Is it kind of a parallel process?
And I think in a lot of ways it is. And so I do acknowledge, and I forgot that there was a director recommendation for 3 and 4 as well. So if there is a recommendation and then, I mean, anytime you utilize a consent agenda, and I mean, as a county commissioner, we utilize consent agendas all the time, but we reviewed everything that was on the consent agenda, and we often pulled things off of the consent agenda that we didn't agree with or we had questions about. And so I think that that process can be utilized in this situation as well. So I don't have a problem with that. I mean, that's just, I think, a good way to consider it. So, I mean, if there's a recommendation for denial or a recommendation for additional information, then maybe it does not go onto the consent agenda and it just comes onto a regular agenda. But if there's a recommendation for approval and we want to put it on the consent agenda, and I think it's our responsibility to look hard at those and pull them off the consent agenda if we have questions. So that doesn't give me a ton of heartburn, though. I just want the flexibility for an operator to suggest something other than the exact fixed amounts that are in option 3 and 4. So,
And to your point, maybe those are somehow noted for the commission that they didn't follow like the exact formula or the cookie cutter option 1, 2, 3, or 4. They proposed something different, but it's been recommended by the director, or the director has flagged it, or whatever. I guess I'd also like to know what Director Murphy thinks about all this. So
My position on reviewing initial financial assurance plans has been, if they're non-discretionary, staff can do it. If they get into squishy areas, it makes me very uncomfortable to do it as we're in this transition. If we'd been running this program for a decade and we had pretty clear understanding of what expectations are, discretionary review is less important to me. And so again, if, I can live with what Commissioner Gonzalez put forward in that if an operator is okay sticking with 3 and 4 with the presumptive amounts and presumptive timelines, that's fairly discretionary. At the same time, functionally, what's different? I mean, there are some different functionalities in terms of applying for a commission hearing and providing notice. There is more of an onus on the operator in that context. From the staff side, I think that our review will look fairly similar between the two options. But a commission hearing does entail more oversight and more onus on the operator.
Commissioner Gonzalez?
Yeah, I just want to clarify one thing, Commissioner McGowan, is that I'm speaking specifically about options 3 and 4 here. Not, I'm categorized, I'm saying all options 1 through 4 was my original proposal, but now I want to dial it back to just 3 and 4. And I am specifically asking that the director recommendation be the approach and the way we go for the presumptive amount of time being, or the presumptive contribution amount being 5 or 10%, and the presumptive amount of financial assurance being single well financial assurance. So if it meets those two things, and it's basically under what would otherwise be a bright line rule, staff should have the say, or it goes on consent agenda, and we decide if we want to take the commission's time to review it and to dig in a little deeper.
So I think we've got 3 votes toward that. Does that make sense? Are you capturing this on your little piece of paper? PowerPoint?
I am. Yes, Chair. Sorry, my dog decided he wanted to invade my space. I think the only question is there is a distinction between approving versus recommending on consent. And I'm not sure where all the commissioners are on that distinction.
Commissioner Gonzalez?
So my suggestion was approve, but I want to entertain Commissioner Messner's concerns and really the intent behind what we drafted up there. So I am pivoting to a recommendation on consent.
A recommendation of approval on consent.
Correct. Does that answer your question clearly, Director Murphy? Enough.
It means there's still a discussion to be had.
Or not, if we leave it
Yeah.
on consent.
Mr. Chair,
Commissioner Nanchapa?
thank you. I think I support that idea, and I don't know if I missed as I was switching over to my phone here, but are we also saying then that anything that does not sort of fit the conditions that Commissioner Gonzalez articulated, then that would definitely come before commission for review? So we're talking about where it is, it fits the presumptive timeframes, and otherwise kind of, is sort of as written, that it can come to us as a director recommendation for approval under consent agenda. Did I understand that correctly? And then otherwise, if it's different, it would go before us for broader review.
Yes, I believe so.
Okay. Okay. I support that.
Do you want to share screen again, Director Murphy?
Sorry, I thought I was. I couldn't understand why nobody could see what I was capturing so brilliantly. So if you look under the fourth bullet point, the fourth bullet point under the fourth bullet point, option 3 and 4, if an operator proposes a plan consistent with the total single well financial assurance and presumptive timelines can be heard on consent if the director recommends approval. Anything else requires commission review, not on consent. And certainly our lawyers will find a more artful way to express those sentiments.
Okay, good. If we're done with that discussion, Director Murphy, can I get you to go back to the top that articulates the 12 areas that we need to be getting through? I'm just trying to do kind of a gut check on kind of where we're at.
Yep, I just want to highlight this one piece so I don't lose track of it.
Okay.
How to. I don't know what I'm doing. Anyway, I'll figure it out. Okay. We are almost through 2.
That's what I was afraid of.
That said, I think that that topic 2 in particular had the most substantive nuance. And so I think that the amount of time is appropriate. I think some of the other pieces are a little bit more standalone and a little bit more straightforward conversation, especially as we get past 4.
Okay, so do we want to, I'm just trying to angle out the rest of the day because I can tell that I at least am exhausted and I bet the others are too. But I want to try to continue to move forward so that we can get this done, by tomorrow is our plan. I think we're still sort of giving direction to staff and then probably turning a final document for consideration early next week. Does it make sense to try to tackle 3 and 4 yet today and at a minimum and then break and then come back in the morning? Or do you have ideas, Director Murphy?
I think we could all use 10 minutes to stretch our legs, or maybe I'm the only one who's getting stiff. And then both 3 and 4 could go in rapid fire or could be pretty lengthy discussions. I don't know if it's easier to tackle like 7 through 11, which might be kind of more straightforward conversations and come back fresh. I'm agnostic, Chair, sorry.
I think that might be a nice pivot. Those other 7 through 11 might be quicker. And then we would be fresh for 3, 4, which are a little more dense, not less important, just there's more there. So why don't we do this? Everybody think about it, leave this screen up. Let's come back at 4:10. Everybody take 10 minutes. Refresh your legs, ice your legs, Commissioner Messner, and otherwise, and we'll see everybody in 10. All right. Welcome back. I think we want to start with determining what's our pleasure in terms of utilization of the not last hour or 2 of today versus tomorrow. I thought your idea, Director Murphy, of doing 7 through 11 had some elegance to it because those are sort of more minor one-offs and we've got to get through everything anyway. But I'm happy to just sort of, pound back into 3, definition of single well financial assurance followed by transfers of wells. So I add no value to making that decision. Commissioner Messner.
I mean, I'm okay taking the suggestion to go to the bottom few. I do want to point out that I do have some suggestions. more likely their suggestions for statement of basis and purpose around kind of director and commission review criteria. I mean, we could talk about it later if you want. Because it may create some conversation, I think, that may be a little tough to go into, in the evening here or late afternoon. So, but I guess I just want to mention that I do want to bring this up at some point, and so we can wait on that till tomorrow.
Okay. If there's not any significant heartburn or caring one way or another, why don't we just jump down to 7? Commissioner Gonzalez, this is surface owner protection bond, which I think is an issue that you had brought to bear. Do you want to lead on this?
Happy to, Chair. So I appreciate the updates that were made in the last draft. I think there was a lot of consensus for those amounts. I had some discussion with Mr. Sir about this during one of his presentations in regard to, this potential benefit of having a blanket bond there. And I'm convinced that a blanket bond element to the service owner protection bond is the way to go as an addition for a number of purposes, but one of the purposes is to ensure that if an operator does have individual service protection bonds somewhere in their portfolio that came through some legacy operator that perhaps they acquired or whatever for bad record keeping, they may not know, they have that option to bond up on that surface owner protection blanket bond to cover that scenario. So I think at this point, we can deliberate on whether or not the blanket bond should be in there. I think it should. I propose an amount of $100,000. We doubled all other amounts. I'm offering or suggesting that we quadruple that amount because of the really unlimited nature of a blanket bond and how many locations may fall underneath it. Acknowledging this is a rarely used bonding mechanism, and bonding on is not viewed very favorably historically by this commission and by staff. So I think that's an appropriate number, and that's kind of my proposal.
Commissioner Gonzalez, does your 100K double blanket bond go backward, go forward, go both ways, cover all wells?
It would cover all wells, and it's a quadruple blanket bond. And I think this kind of solves the debate or solves the problem on whether or not this rule should be applied retroactively. And so I think that if we include the blanket bond, that it can be applied retroactively, in which case an operator either has the option of knowing where their individual service owner bonds are and bonding those up to the current amounts as proposed in this draft, or moving to a blanket bond statewide in what I believe is a reasonable amount for both protection and accessibility by operators.
And that, I think you just answered the next clarifying question I had. We would still maintain the individual bonds as an option for operators.
Correct.
Not to put too fine a point on it, but I'm good too.
I see 4 thumbs ups.
I
Next.
see 4 votes, thumbs up. I know Commissioner Nanjapa is on the phone, and so, but with 4 votes up, that's a majority. So I think we can
I
move
support
on.
as well.
Great, thank you, Commissioner Nanjapa. Director Murphy, help me. What is the 702A1B language?
I can't understand why nobody just remembers it out of hand. I'm shocked. Sorry, it's the end of the day and I'm getting a little giddy. This is the language that staff had initially proposed, I think in the October draft, that would allow operators of less than 10 wells over a certain production threshold, which is calculated in barrels and MCF instead of BOE and MCFE, to essentially maintain their financial assurance under the current existing structure today. They could carry that forward until they acquired wells. In light of how the commission has set forward the framework, and keying back to the comments that I've heard from Commissioner Mesner today, this is a framework that works. I think it really appropriately captures a number of things. It would be my suggestion that the commission strike that grandfathering language. And if you want me to pull it up, I'm happy to do that. But I own that it was my suggestion and now I'm telling you to not do it. And that might create some consternation.
Commissioner Messner?
I would agree with that. I think striking the language is the right thing to do in light of like looking at things holistically. So.
Commissioner Gonzalez?
Yep, nope, I think that's, holistically, we've got a good approach. We've got a good way of doing financial assurance that should capture every operator.
Great, and Commissioner McGowan did a thumbs up as well. We should have taken a 10-minute break a long time ago because we're just rolling now. Just that little bit of exercise.
Chair Robbins, I'm good with this too.
Thank you, Commissioner Nanjapa, and just please speak up because I can't see you.
I'm really sorry. If you see me looking like I'm having a random arm, it's my dog, just super excited about life.
I think he's telling you it's time for a walk.
Well, it's 2 hours to dinner time, so he must be starving, right? So buttoning that one up, federal wells is next on the list. And are there comments, topics, questions that we should talk about federal wells?
Commissioner McGowan?
Thank you, Mr. Chair. So I guess I have 2 points I'd like just make sure we get taken care of. One is language around, I think is equal to or exceeds the bonding amount that is required by the state for those who have federal wells instead of substantially equivalent. I think that makes things a little more clear and less fuzzy. I might be a minority commissioner here, but I feel like it's equitable for the rules to apply to everybody at the same time when we implement them. And I think that our bonding requirements should apply to federal wells upon approval of our rules along with everybody else. But I know that that's been a topic of discussion and that's not currently the draft language.
Commissioner Gonzalez?
Thanks, Chair. So I am comfortable with the language as drafted. Again, we kind of went through this in our pre-deliberations a couple weeks ago, and I haven't really changed that. I think that substantially equivalent is as much as it gives me a little consternation in the application or the, I guess, anticipated application of it. I think that addresses things a little bit better than equal to or exceeds for one reason, Commissioner McGowan, and that's just because the financial assurance under federal wells is different, right? And so there may not be a way to equalize it to an equal or exceeds level. But I think that if there is arguments to be made in terms of substantially equivalent, I think that we can then essentially compare apples to oranges or Pink Lady apples to Gala apples, et cetera, to make sure that, we give the appropriate credit for the financial assurance regime under the BLM.
And Commissioner Gonzalez, not to put a point on it, but you're comfortable, right, with the delayed time frame?
Yeah, the sooner of the two, the drafting or the approval of the BLM rules, 90 days after the approval of the BLM rules, or the date certain, which I believe is October 15th, 2023. Although we did have a request from, I believe, West Slope COGA. I don't know if we got it from others to make that date December 15th, 2023. That's 60 days there. I don't know how much difference that makes, but if it gives us the best opportunity to understand the BLM rules, I'd be in support of that. Yeah.
Thank you. I think on these 2 issues, and I appreciate Commissioner McGowan bringing them up, I was an advocate of the delay turn on. I remain in that camp. I'm a bit agnostic as to October 15th versus December 15th. And I might turn to Director Murphy for some thoughts about that in terms of staffing and when it gets turned on. On the language, I have not been a big advocate for substantially equivalent. I think it's difficult at times to apply. Having said that, I am an advocate of substantial equivalent in this scenario. And I think it's really for the reasons that you point out, Commissioner Gonzalez. The two regimes are not likely to overlap, intersect, likely lay well together, interconnect, whatever word we want to use. And I think it's better to use a more subjective, substantially equivalent language. I think we'll be in a better spot to use the rule with that language as compared to a more prescriptive equal to or exceeds language, which I don't think is appropriate in the usage of what it is we're trying to do. I also want to echo that I'm proud that we have made the determination to apply our rules to federal wells. I think that's the appropriate thing to do. I think SB 19181 tells us to do that. And I think that the way that we have crafted this in a slow measured steps approach is really going to be helpful to us, and it gives us the opportunity to be involved at the BLM as it undertakes its review. So those are my thoughts. Commissioner Messner?
Chair Ross?
Oh,
It's okay. Commissioner Najapa can go.
go ahead, Commissioner Najapa.
Thank you. I am generally in agreement with the timeframes. I think I'm still thinking more along the lines of equal to or exceeds, and I'm terribly sorry, I'm forgetting the name of the commissioner from Pitkin County who presented to us, but she said that there were some different ways that you could apply the calculation, kind of take the total amount, given that it is a different approach to assigning it, and divide that by the number of wells or the number of locations, and we can look at it similarly once we've determined what our single well financial assurance is. And so I guess I'm thinking more along the lines of the equal to or exceeds based on what she had recommended in terms of the calculation. Now, that said, I would look to Director Murphy to see if staff has already kind of thought through that and if that would be too difficult to do. But other than that, I'm okay with the time frame.
Director Murphy, do you want to weigh in, or do you want to hear from Commissioner Messner first?
I defer to you, Chair. Oh.
He's pointing at you, even though he's pointing in the wrong direction.
That might be the right direction. I don't know. No, I tend to think that it's difficult currently to compare dollar for dollar COGCC financial assurance requirements to federal requirements. And unless and until we know what those federal requirements are, I tend to prefer the substantially equivalent language. If we knew today what was laid out, I think it'd be more straightforward to pick something, pick different language. So I tend to be more comfortable with substantially equivalent in this context as well. In terms of, I think, while I have the floor, Chair, and I don't remember if it was you or somebody else who asked about the difference between, I think that was actually Commissioner Gonzalez, October 15th versus December 15th. I think I'm pretty good with October 15th. I understand the concern about wanting to build in a little more time for the federal process to wrap up. But the federal process is inherently, is going to follow its own path. And if we're getting close to October 15th, 2023, and we think a different course of action is appropriate, we can take it at that point in time. I would understand that an operator would need to have a plan submitted by October 15th, and that if there are continuing pieces to be worked out through the federal process, we could use the financial assurance plan filing and that the process of review to work out those details. So I think that I think that we could accommodate, even if the feds were a little bit slow and their rules didn't go into effect until October 30th, a way to work through some of those pieces. So and again, like if the federal process goes off the rails and takes 5 years, I think we're going to need to come back a few months before October 15th, 2023 and reevaluate what our game plan is under any scenario. So I guess what I'm trying to state in sum is that what you all directed on the 31st and the 1st seems like the right place to land based on what I've heard from you and from the parties.
Commissioner, thank you, Director Murphy, for the thoughts. We appreciate it quite a bit. Commissioner Messner.
Thank you, Mr. Chair. So I don't know why anyone has a problem with substantially equivalent. To me, it makes tons of sense. I get it. I don't know, but I mean, to me, it works in this particular scenario. I mean, I do think there's going to be enough differences, whether it's, you know, road reclamation bonds versus surface bonds versus downhole bonds. You know, I mean, there's going to be enough difference that I think we want a little bit of the flexibility that's allowed with substantially equivalent in determining those, rather than looking for specific dollar to dollar amounts. And I'm not suggesting that we should be very far apart when we look at substantially equivalent, but I think that it allows that. I think it's a good utilization of that. I mean, I appreciate the language that was presented around equal or exceeds. I just think substantially equivalent works a little better in this scenario. And I'm sympathetic to the idea that if we require it immediately, I mean, I acknowledge that the chances that this rulemaking from the feds is going to be done in 18 months is not very likely. At the same time, if there is an opportunity for us to glean at least a general idea of what may be the outcome of that, that can certainly help, I think, as we try to determine you know, a path forward later next year. So I'm okay with the 18 months. I mean, I appreciate Commissioner McGowan's point. If we're going to apply the rules, apply the rules. But I think if there's a way to just take a little more time to try to glean where the Fed rulemaking may go, I think that's beneficial enough to provide 18 months there. And so I think that the big point here that I don't want to get lost in any of this is that I do think federal wells should be subject to state financial assurance requirements, and I think we're doing that. And so I think that's a really important thing. But I think that the language as it exists today in the rules works. So not today in the rules, in the draft rules is what I meant. Yeah.
Okay, do we just want to go with the fact that we've got 3 leaning one way, 2 leaning the other, and call it? Do we want to have further discussion? I'm good just to call it, but I'm cognizant of further discussion if that is what folks desire. Commissioner McGowan?
Since I'm in the minority, I'd just say let's move forward.
Thank you. Okay, we are now moving forward. The concept of amnesty, or however you want to call it, is on the table. Commissioner McGowan?
Well, after Friday, Mr. Chair, this is my favorite subject. Well, there's no laughing. Okay. I have to say that I'm gonna do my wishy-washy Commissioner McGowan thing, right? Which is, I feel like after looking at some of the data again, there are, I think, 60-ish operators with zero production in our list of operators. There are more than 100 operators who own just one well, and a high percentage of those are inactive, meaning they're shut in or temporarily abandoned or inactive. And I feel like those are the wells that we could take an opportunity to streamline into a system that deals with them and plugs and abandons them. I feel like hearing from stakeholders that those are the wells that are the most concerning. As a commissioner, I feel that those are the wells that are probably the most at risk of an operator potentially not succeeding under the new draft rules. And I feel like the amnesty could be an appropriate pathway forward without going through a lot of administrative procedural steps on our end to get to the same point. I also think that if people want to game the system, they're going to game the system. They could be doing it today. If they had wells that they thought were higher producing and then they could walk away and bankrupt, they would already be doing that. That being said, I feel like I heard loud and clear that it was not really popular with many of our stakeholders, and I have not heard from any operators that they might take advantage of this option. And so I'm not sure I want to follow my sword about it, but I think it is a good idea. I think it's a good idea if we put some guardrails around it, which were suggested last week, which was you can't transfer anything between now and the end of the year when you have to decide whether or not you want to take this path. And that as an owner of that company, you're done operating oil and gas activity in Colorado with the commission. I think those are pretty substantial things to ask for in return. And then the benefit from us is we are potentially getting wells that we think are going to end up in our orphan well fund anyway sooner without a lot of administrative burden. That being said, I am not going to fall on my sword on this after testimony last week.
Commissioner Gonzalez?
So Chair, I've been way less than lukewarm on this kind of throughout the discussion as we've talked about it. I think that the concept of trying to daylight and to accelerate the identification of effectively orphan wells is an important endeavor. I don't like the idea of it going through an amnesty type regime as it's been contemplated. To me, the thought of an operator to come before us and say, hey, I'm not going to fulfill my obligations to plug these wells. I'm not going to clean up the operations that I've taken responsibility for. And by the way, you can have my whatever financial assurance I have, and thank you very much. See you later. It makes my stomach turn really to think about that. And so I don't like amnesty if it's categorical. I think I'm probably a no vote on amnesty. I think that we have an opportunity to identify and daylight these wells through the enforcement process. And we've done that in a number of instances thus far. I'd suggest that we make a priority to bring these through enforcement, to accelerate the enforcement of zero production wells, to accelerate the enforcement of wells that have no reporting or no contact or have been out of compliance for a number of, that are currently out of compliance, right? And have been, right? I think we know where that those operators are gone, or that those operators are not participating in the regulatory process. So that's kind of where I land on it. Now, if we do go with amnesty, I think that's, and I asked AAG Davenport about this over the weekend, and I was thinking, can there be a penalty associated with amnesty? And I think that kind of, when we talked about that kind of goes back into the enforcement realm, and perhaps that's where it's best housed. I thought about the idea of, instead of just taking your financial assurance, that if you want to, ride off into the sunset, and leave a bunch of orphan wells, and you're going to come ask for amnesty on that, that perhaps you should make an offer to buy yourself out of that plugging obligation through some, monetary amount that's above and beyond the financial assurance that you may be holding. Those are, I think, would be stronger ways of implementing an amnesty program. I think that the ALGC language is fine. I think it would need to track with language that we use in our enforcement documents. And I think that it should identify specific principles if that's the case, because I do have a concern with categorically just eliminating principals, members, managers, however, we use those terms of those companies that may catch unintended persons associated with those companies. And so again, it kind of all falls back to me that I think this should go through enforcement. I'm not a fan of amnesty. I don't think that word applies really to what we're contemplating here, or at least as I would intend it to apply here. So that's really my 2 cents. I know that may not be where other commissioners are, since we've talked about this, and I've been relatively silent on this matter, but we're at the 0 hour, and it's time that I take a position, and this is my position on it.
Commissioner Messner.
Thank you, Mr. Chair. Well, Commissioner Gonzalez, I agree with you. I think that I hate calling it amnesty. I think it's voluntary relinquishment makes sense. I thought when I initially heard from a number of stakeholders that they would want these zombie wells identified and addressed as quickly as possible in order to minimize any potential emissions or issues associated with them. I thought initially, when I heard the idea of the voluntary relinquishment program, that I thought this may be a good idea in order to address some of those concerns expressed by some stakeholders. I also acknowledge that there's a significant amount of hearing officer time in particular, as well as other staff time associated with going through an enforcement process for these. But based on testimony that I heard last week, I agree with Commissioner Gonzalez. I think the appropriate avenue forward on this is to utilize the enforcement process. I think we should emphasize and prioritize, addressing some of these particular instances and just kind of move forward with that process. But I'm not going to be in support of a voluntary relinquishment program.
I was waiting to see if Commissioner Nanjava wanted to weigh in, but not seeing her unmuting. I guess I'm disappointed. I thought that the voluntary relinquishment program idea, appreciate calling it a VR idea and not amnesty. I thought it made some sense. I mean, from many of our stakeholders, we got this concept that we are going to daylight zombie wells, zombie operators, whatever we want to call it. And I agree with you, Commissioner Messner. I thought there would have been kind of an embracement of the concept of getting that done sooner and quicker and with less administrative process than otherwise. It also would have allowed us to do what we're going to do anyway if we kick up the enforcement process, which is do it. It's just going to take longer. And the remedies in enforcement is exactly the same remedies as voluntary relinquishment. We will, assuming they don't respond, we'll get their wells. We will tell them they can't operate in the state anymore. We'll get whatever funds they might have with us. And that's the place we're going to end up. And so I thought that being creative and ending up in that place maybe a year or more sooner than if we have to go through the enforcement. That's where I'm just kind of pulling my hair out, like that folks are thinking that somehow or another we're rewarding people, because we're not. We're going to end up in the exact same spot with enforcement. Having said that, we heard from a lot of stakeholders that this was, not a good idea. I'm kind of with Commissioner McGowan. I still think that, this is a good idea, and, but I'm not going to die on my sword either. And if there's a majority of us that want to just not go down this path and tell Director Murphy and team that they've got to amp up enforcement, okay. Commissioner
Chair.
Najapa. Yep, I see you've unmuted, so
Thank you.
you have the floor.
Thank you. I am with you and Commissioner McGowan. I still think overall, this is a better path for the most distressed operators to be able to get these wells put into a program where they're plugged and abandoned and made safe. And while I understand the concerns of, people kind of relinquishing their obligations and not following through with what they're going to do, I think unfortunately we're going to have a number of those operators anyway. And I totally agree with you, Chair Robbins, that the savings in enforcement, time, staffing, effort, and the money that the state would be paying for all of that time makes the voluntary relinquishment program an appropriate option.
And thank you, Commissioner Najapa. And the other component to that is we have, through the rulemaking process, identified potential hiccups with the voluntary relinquishment. And I think we have done a good job of finding guardrails to ensure that it is not a problem. But having said that, I don't really know what the consensus is at this point. And it just annoys me. Commissioner McGowan.
Thank you, Mr. Chair. I think there's just been a lot of discussion about it and the pros and the cons. And having not heard very much support from it through our process, I would say we let it go. We've put it out there as what I thought was a pretty good alternative to some other things that I don't think necessarily are working and working timely. So I guess we're going to find out when we adopt these rules. We'll see who's going to have to go through this process anyway, and deal with, to Commissioner Gonzalez's point, deal with it through enforcement.
Okay, I think we've got consensus to pull voluntary relinquishment. Insurance is next up. Commissioner Messner.
I'll kick it off by just saying, I think the 5 million is appropriate. I think COGA had made a suggestion that I'd run through a few different stakeholders, and no one seemed to have heartburn about it, which was the coverage required may be secured alone or in combination with an umbrella or excess policy. And so I think that's where I'm at.
Commissioner Gonzalez.
Same.
Commissioner McGowan.
Thank you, Mr. Chair. I think this is where we also heard from Ms. Legere and her folks that around different ideas and frustration working their way through insurance. I have two thoughts about it. One was it didn't seem to me like it was a large issue right now, based on some questions that the commissioners asked of what were the problems and trouble getting them resolved. I realize that sometimes it can be hard to work through an insurance company. But I also feel like the commission would be stuck in the same boat if we had a separate fund that we were pulling from for environmental or other types of issues that came up around operations. And I'm not necessarily convinced that the process through the commission would be any easier than going through the appropriate insurance measures. But I do want those folks to know that I heard them. I just not sure that I'm on the same page or heard enough compelling testimony to see that what they wanted the commission to create would solve the problem.
Commissioner Gonzalez?
Thank you for bringing that up, Commissioner McGowan. This is actually something that I thought a lot about over the weekend and made some calls in regards to kind of how this operates. And so I may, and that was a reminder for something I had missed on my notes. So thank you for that trigger. One of my understandings when it comes to the general liability insurance, these umbrella policies that operators carry, is that basically what they would call a seismic exclusion is essentially coverage that would be due to offset impacts due to seismic activity on the ground or subsurface. I still think that the commission is absolutely not the right person or the right entity to determine that causation, and that an insurance company would be the appropriate one. It's my understanding that that exclusion is not contained in most oil and gas umbrella policies, but that it is contained in commercial saltwater disposal operations. And so if we are thinking about insurance as it pertains here, I guess my question for Director Murphy is, does this insurance provision that we're looking at under 705, does this apply to all operators, including saltwater disposal operators? I may offer a consideration that since this is kind of already common practice with just regular umbrella policies, that with the exception of saltwater disposal wells, or operators that operate saltwater disposal wells, that the umbrella or an umbrella policy does not contain an exclusion for seismic activity or catastrophic events tied to seismic activity. I don't know the exact language there, and I was still working through that. So maybe that's something that needs to be fleshed out tomorrow or in subsequent days. But I think that perhaps that may address some of the concerns we've heard numerous times from the Citizens for Healthy Community group, and perhaps it's something that's already being done, and we could just codify it in a way that gives a little more protection than is currently available in that regard. So that was a long ramble to say maybe there's an avenue to do something other than create a fund, which I don't think is appropriate. And maybe that avenue is just adding some additional language into what would be required, similar to the environmental side, under a general liability insurance policy. And I'm not reading along, Director Murphy, even though I see you put this on the screen. So if I missed anything or there's something I'm speaking out of turn on, please let me know.
Commissioner Gonzalez, can I ask a question? Did you chop that idea with some of the folks that would need to be purchasing said insurance?
No, I ran it through Gilstrap with the insurance surety company. So he was a contact I had, and I asked about the prevalence of that exclusion. And in his estimate and what he told me, and I have not socialized this with other operators, so perhaps I'm getting too far out over my skis there, but that is not a common exclusion, that it is typically covered.
Director Murphy?
Thank you, Chair. And Commissioner Gonzalez, I was trying to pull up the language so that we could see 705, and that it applies to all operators, number one. And in so doing, I missed maybe the precision of your language around not allowing the exclusion of what?
Saltwater disposal wells. Oh, no, I'm sorry. No, let me read what you're typing there. Not allow the exclusion of, well, it's called a seismic exclusion. So I don't have more information other than that. That's what I have written down in my notes. I wish I had a little more detail, and I apologize for not being thorough enough in my note taking to have that, but not allow seismic exclusions from umbrella insurance policies.
Chair Robin,
Go ahead.
thank you. And thank you, Commissioner Gonzalez. I was trying to look into this as well to try to find out, what other potential provisions they were. I was not as successful and resourceful as you, and so I appreciate your research on this. I like this suggestion. I definitely was trying to figure out a way to address the concerns that Citizens for a Healthy Community have raised as well. And then apart from that, I do support the use of an umbrella policy that you previously were discussing.
Commissioner McGowan.
I agree, and I appreciate Commissioner Gonzalez doing a little extra homework to figure out how we might tighten up and address concerns about seismic impacts.
I'm good too. All right, Director Murphy, where are we at?
So we've made it through the identified topics 7 through 11. We could go back to 6, or we could identify other topics that we haven't identified. The one that I have on the screen is the consolidation language, and that means this language makes no sense to anybody but me, I'm sure. But this relates to the request by industry and the clarification suggested by Commissioner Mesner that if operators are consolidating under a parent, you have to consolidate all of your subs, not just your favorite or least favorite subs. I think that commissioners were okay with that during staff's presentation, but I wanted to make sure staff was appropriate in including that language. So that's my one topic there. And so we could add topics, as I said, or we could go back.
Let's take a quick straw vote on that topic. I'm comfortable with that. Okay, so you got 4 yeses, and Commissioner Nanjapa is probably an audio.
And me
yes.
as well. Yep.
Okay.
Chair Robbins, I think I've got maybe an easy one. Maybe.
Easy is good.
Rule 503 G12. There was a suggestion to change the language in there from 36 months to the past 3 years. I would like to support that. I think we were all in agreement with the language that was in the draft, and so this is just a tweak.
And that was with regard to the well or location closure issue.
Yeah, that's the one that associates the 211 hearing. So
Yeah.
it's a useful hearing, and so there was just a concern. The current draft has 36 months in it. There was a suggestion to just change that to the past 3 years. Same timeline, just slightly different language. I didn't talk to anyone that has any heartburn about that.
Sounds good. Everybody else okay? Affirmative nod. all the
I'm
way
good too.
around. Commissioner McGowan?
Thank you, Mr. Chair. And I'm trying to scroll through my notes, so I might be back and forth here. One thing I was wondering if we could do, there was some testimony early on about concern about us having in the definition of orphan well, I think, about the being an unwilling operator. And if we could just explain what we mean by that in the statement basis and purpose, I think folks were maybe taking it in the wrong light versus how it was intended from staff's perspective.
Director Murphy?
Thank you, Chair, and thank you for the comment, Commissioner. I had the same concern when I heard that from stakeholders, and I think it's very important to clarify that unwilling doesn't mean that an operator kind of la-di-das and hands us 6 wells and then keeps going at all. Unwilling means that we may have a company that hasn't gone bankrupt or that is identified, but they have not and have not been able to comply with our regulatory requirements as demonstrated through an enforcement hearing, and it results in all of the wells being taken over, and at least in the actions that staff has pursued thus far, consequential language for the principals of those companies. And so I think that the intent and the way that we have used this term is very consistent with the expectations set forward by our stakeholders, and we'll make sure to address that in the SPP.
Anybody have any concerns with that? Asking the affirmative, is everybody okay with that? Okay. Director Murphy, you mentioned going back to number quote 6. Is that out of service? Let's pull that up.
Mr. Chair, I still have just we can come back to it, but I still have some miscellaneous things. It's just taking me a while to scroll through
I'm sorry.
all of my notes. So it's fine. We can circle back around.
And I think the other point I would make is we can all scroll. I mean, I've got lots of notes as well. And I think we can do some scrolling through them this evening, and we can have a miscellaneous timeframe in the morning as well. But if you've got more this afternoon, we can definitely do that.
Thank you, Mr. Chair. So one thing that was brought up last week in testimony was, I think, 709A1E, which I think is no longer in the rules, but used to be in the rules maybe. That was talking about if you're not in compliance with your financial assurance rules, you cannot apply for an OGDP. Am I understanding that correctly? That was also brought up by Citizens for a Healthy Community. Now I lost my rules on my computer. So anyway, we don't have to decide today, but I think that was brought up last week.
And you're right, it's going to have to go back a draft or two because it's not in the red line that I'm working off of. Commissioner Messner?
Thank you, Mr. Chair. Just a supposal. I mean, understanding that we've had a super long day and we've worked through some really difficult issues here, and acknowledging that it's 5 o'clock. I don't know if we want to go much longer into big topics tonight, because I think we all do a lot better in the morning as far as working through stuff. And I know we need to get through stuff tomorrow, but I know that my brain is starting to get fatigued.
Director Murphy, can you take us back to the order of play slide? And I'm trying to get a sense of what's left, because I would be happy to take Commissioner Messner up on his idea. So we've got 3, 4, 5, 6, and then miscellaneous. Is that right?
So I'm trying to strike through the ones that I think we've completely dealt with. I think that there are 3 topics and 2 that we didn't quite get to. Kind of close. And my notes right now are my handwritten notes, which are scattered, which is staff report out, which I think relates to what comes out of staff's review of its annual review of a financial assurance plan. And then my next note says Mesner language, which I don't remember what it relates to, Commissioner Mesner. But I think you said you wanted to go back and talk about something. And then I think Commissioner Nanjapa had also proposed something around option 3 that I don't recall, but I know there's a note in the slide about it. I think we proposed it in a different conversation and we needed to come back to it. So that's where I think we are, as I see.
I mean, I think that what's left is doable for a morning session. And so I'd take Commissioner Messner up on his motion to continue to 9 a.m. tomorrow morning, if that's what he was suggesting.
Second.
Yes,
Mr. Murphy, we're going to be gone before you know it.
I know. I appreciate that efficiency. Caitlin checked on the language, Commissioner McGowan, you were citing to about CHC, and I think we're talking about 707 A1D. And that's helpful because I don't think we've ever had a 709. But in case somebody wants to look at it tonight, because we're going to adjourn and think about it and come back tomorrow. I wanted to get everybody the right site before we got too carried away.
And thank AAG Stafford for the diligence. Okay. We have a motion and a second to adjourn. Any discussion? The discussion I will make is good job to my fellow commissioners and to staff, as well as to all of our stakeholders for helping get us to a, I think, productive, deliberative initial day. I think the second point I would make is for everybody listening in, we're likely to convene. We will reconvene at 9 a.m. tomorrow. I think we're hopeful that we'll be able to get through this issue list by midday. And I believe that at that point in time, we would look to adjourn until, like Monday, and then come back and be prepared for a final vote with a final red line to have been produced by staff at the time that it takes them to get it done. We're not looking to take additional public comment or stakeholder comment, but the record is not closed, which means the commissioners can still have discussions with folks if they desire to do so. And with that, if there's no further questions or comments, I would look for a motion on a vote on the motion to adjourn. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? See you in the morning.